Fiction and not a fact. That's how Vice President Sara Duterte describes allegations she made grave threats against against the first couple and former House Speaker Martin Romualdez. Today's impeachment trial centered on the so-called Oplan Romanov, which the defense is using to justify Duterte's controversial remarks. What impact could these arguments have on the course of the proceedings? Let's get on point with House Lead Prosecutor, Congresswoman Jervil Jinky Luistro, who joins us live from the Senate. Congresswoman, good to have you again. Welcome to the show, and always thank you for your time, ma'am.
Good evening, Pinky, and good evening to all our viewers and followers.
Congresswoman Jinky, I was just watching the last minutes of what is happening in the Senate right now before we went on air, and maybe to apprise our viewers right now and myself. Attorney Lorna Capunan was actually saying that hindi na po ipepresent si Attorney Zulaika Lopez. Please tell us more about this.
That is correct, Pinky. At merong tatlong bagay na in-emphasize si Attorney Capunan, no? That includes to avoid redundancy, unnecessary, and repetition, no? So, surplusage, no? To correct. So, that is the reasons, or those are the reasons why we are doing away now with presenting subpoenaed witness Attorney Zulaika Lopez as well as Captain Bello, no? We believe na yung sasabihin ni Attorney Zulaika Lopez at ni Captain Bello ay na-cover na ng testimony ni Agent Calilong as well as Attorney Lotok, and as a matter of fact, they were even admitted by the Defense Counsel, no? So, ulitin ko, Pinky, yun, ha? The reasons are, they are unnecessary, they are surplusage, and they are redundancy. So, these are the reasons. And ultimately, we want to spare the court with wasting its time so that we can focus and dedicate the same to other witnesses who will be presented by the prosecution.
But that particular decision coming from the public and the private prosecutors, I'm sorry, apologies, ma'am, because I missed parts of it because I was also on air. Ang narinig ko po sinabi ni Attorney Capunan, nagkaroon po kayo ng, she used actually two words, huddle and hurdle. Can you tell us more about that, please?
Well, we've been observing the testimony of Agent Calilong as well as the testimony of Attorney Lotok, no? And ultimately, this afternoon, we were able to resolve with finality that if we will be presenting Attorney Zulaika as well as Captain Bello, it will be a repetition already of what was testified to by the first two witnesses. And that includes the admission of Attorney Villuan na paulit-ulit sinasabi kanina ni Attorney Capunan, no? Kasi there are only few things na kailangang sabihin sana nitong dalawang witnesses na to. And that includes nandun sila sa loob ng detention center and they personally witnessed the Vice President utter those words of threat against the President, the First Lady, and the former Speaker, no? And it appears to us, it was witnessed actually by the public, na na-cover ito ng testimony ng ating dalawang agents from NBI, and na-cover na rin siya repeatedly by the admissions of the defense during their cross-examination and even during recross-examination, no? So to us, Pinky, no, kung aming isasalang pa itong dalawang ito, it will be a waste of time of the court because it is actually a repetition already. Uulitin na lang ang na-cover na ng mga naunang testigo. Surplus age na siya or kalabisan sapagkat na-establish na yung gusto naming ma-establish from these two witnesses. And it will be a redundancy or a
fiction and not a fact. That's how Vice President Sara Duterte describes allegations she made grave threats against against the first couple and former House Speaker Martin Romualdez. Today's impeachment trial centered on the so-called Oplan Romanov, which the defense is using to justify Duterte's controversial remarks. What impact could these arguments have on the course of the proceedings? Let's get on point with House Lead Prosecutor, Congresswoman Jervil Jinky Luistro, who joins us live from the Senate. Congresswoman, good to have you again. Welcome to the show, and always thank you for your time, ma'am.
Good evening, Pinky, and good evening to all our viewers and followers.
Congresswoman Jinky, I was just watching the last minutes of what is happening in the Senate right now before we went on air, and maybe to apprise our viewers right now and myself. Attorney Lorna Capunan was actually saying that hindi na po ipepresent si Attorney Zulaika Lopez. Please tell us more about this.
That is correct, Pinky. At merong tatlong bagay na in-emphasize si Attorney Capunan, no? That includes to avoid redundancy, unnecessary, and repetition, no? So, surplusage, no? To correct. So, that is the reasons, or those are the reasons why we are doing away now with presenting subpoenaed witness Attorney Zulaika Lopez as well as Captain Bello, no? We believe na yung sasabihin ni Attorney Zulaika Lopez at ni Captain Bello ay na-cover na ng testimony ni Agent Calilong as well as Attorney Lotok, and as a matter of fact, they were even admitted by the Defense Counsel, no? So, ulitin ko, Pinky, yun, ha? The reasons are, they are unnecessary, they are surplusage, and they are redundancy. So, these are the reasons. And ultimately, we want to spare the court with wasting its time so that we can focus and dedicate the same to other witnesses who will be presented by the prosecution.
But that particular decision coming from the public and the private prosecutors, I'm sorry, apologies, ma'am, because I missed parts of it because I was also on air. Ang narinig ko po sinabi ni Attorney Capunan, nagkaroon po kayo ng, she used actually two words, huddle and hurdle. Can you tell us more about that, please?
Well, we've been observing the testimony of Agent Calilong as well as the testimony of Attorney Lotok, no? And ultimately, this afternoon, we were able to resolve with finality that if we will be presenting Attorney Zulaika as well as Captain Bello, it will be a repetition already of what was testified to by the first two witnesses. And that includes the admission of Attorney Villuan na paulit-ulit sinasabi kanina ni Attorney Capunan, no? Kasi there are only few things na kailangang sabihin sana nitong dalawang witnesses na to. And that includes nandun sila sa loob ng detention center and they personally witnessed the Vice President utter those words of threat against the President, the First Lady, and the former Speaker, no? And it appears to us, it was witnessed actually by the public, na na-cover ito ng testimony ng ating dalawang agents from NBI, and na-cover na rin siya repeatedly by the admissions of the defense during their cross-examination and even during recross-examination, no? So to ask Pinky, no, kung aming isasalang pa itong dalawang ito, it will be a waste of time of the court because it is actually a repetition already. Uulitin na lang ang na-cover na ng mga naunang testigo. Surplus age na siya or kalabisan sapagkat na-establish na yung gusto naming ma-establish from these two witnesses. And it will be a redundancy or unnecessary. Redundancy, paulit-ulit, unnecessary, hindi na kailangan, no? We would like to focus to other witnesses, other evidence na may ibang established aside from those na nasabi na ng dalawang naunang testigo.
I understand, of course, that a process like that is definitely up to the prosecution or even the defense when their turn comes. We had an interview a couple of weeks ago, ma'am, and sabi mo nga meron kayong I think now 57 witnesses. And at any given time, you're able to reduce, subtract any of the witnesses if necessary. And in fact, meron din yung tinatawag nga that I learned from you, yung reserved witness that you are given now. What we talked about then was 3 days, but hearing from the presiding officer, I think the agreement was 5 days. But when did you decide not to call as a hostile witness si Attorney Zuleika Lopez? I'm assuming it was just today, but specifically around what time, ma'am?
Well, just today, just after the conclusion of the testimony of Attorney Lotok. Although admittedly, since yesterday, we've been considering ang ganda na ng testimony ni Attorney Lotok. Halos kompleto na, but the final decision only came after the conclusion of the testimony of Attorney Lotok. To be specific, that was after recross examination, no? While admittedly, since kahapon, pinag-aaralan na talaga namin yan, and we became more convinced with his testimony today to dispense with the testimony of these two witnesses.
And there is no, was there any concern that because we understand that Attorney Zuleika Lopez would be a hostile witness, that it could possibly, just possibly be detrimental to the prosecution? Of course, I understand, ma'am, na pinaghandaan niyo to. Pero being a hostile witness, sabi nga ng interview kanina dito po sa BNC kay Corina at kay Willard, tricky po kasi din talaga ang hostile witness. Did it have anything to do with that?
We acknowledge that, Picky, but of course, kamukha ng sinabi mo kanina, it depends on the exigency of the trial, no? Naging observation namin na kompleto na yung gusto naming ma-establish from the testimony of the first two witnesses, and that is the ultimate reason why we are dispensing with the testimony of these two witnesses. And I wish to take note, hindi lang testimonya ni Attorney Zuleika ang dinidispense ng prosecution. It even includes our witness, Captain Bello, no? Dalawa sila na dinidispense na namin tonight, no? For the reason na na-establish na at magiging repetition na lang kung i-present pa sila.
For the benefit of those who do not know what the testimony of Captain Bello would be, please give us the explanation. Ano ho bang ite-testify ni Captain Bello?
Well, Captain Bello was the LSB official of the House of Representatives, no? Who served the transfer order to Attorney Zuleika Lopez, no? Nung ililipat sana siya sa hospital while the Vice President was inside the detention center, no? She's supposed to tell the court na nakita niya nandun ang Vice President at nakita din niya si Attorney Zuleika Lopez. These are the circumstances surrounding the video conferencing where the Vice President uttered the words of threat against the President, the First Lady, and the former Speaker.
Congresswoman Jinky, so who's next? What happens now tomorrow?
Well, tomorrow I understand na nakaschedule ang oral argument. This is about the preterm evidence or documents pertaining to AMLAC, BIR, and even the bank documents, no? The issue here is whether or not those documents which pertain to acts or omissions prior to 2022, when the respondent became an impeachable official, are relevant to this impeachment trial.
Ibig sabihin ho ba na magkakaroon ng oral arguments ang magkabilang kampo para patunayan na kailangan o hindi dapat isama yung mga records ng mga bangko ni Vice President bago po siya maging Vice Presidente? Did I understand that right, ma'am?
That is correct, Pinky, no? But it does not pertain only to the bank documents. It pertains as well to SALN.
Right.
It pertains also to BIR documents, the ITR, no? And the AMLAC documents, no? So ang issue dito, you are correct when you said, no? Kompletohin lang natin yung documents which are concerned in this particular issue. Kung ito bang mga dokumentong ito which are prior to 2022 when the respondent became an impeachable official are relevant in this impeachment trial, no? Of course, the position of the prosecution is they are relevant.
And with that oral argument coming from both the prosecution and the defense, what happens after? Is that going to be a decision that will be put forward to the senator judges to vote upon if indeed pwedeng isama o hindi?
Well, actually, before I came here, no, the senator judges were discussing whether they will be voting tomorrow immediately after the oral argument, or they will be given additional time to be able to make their position on the matter. And the last thing I heard from Senator Judge Alan Cayetano is like he's requesting for a caucus, no, about the subject matter to be debated upon tomorrow by the prosecution and the defense.
Fair enough, because you had to go to our live point to be able to speak to us tonight. So we thank you for that. So tomorrow is actually going to be also, not that the other days were less important, but this is a shift now, because are you saying na tapos na po ang issue on grave threats?
Well, we still have one witness, no? And I don't know if there will be additional witnesses pa after this one. The last witness I'm pertaining to as of now is Attorney Melvin Matibag, our NBI director, no? I understand that we have reservations, so we haven't discussed whether Attorney Melvin will be the last or whether there will be additional witnesses pa, anchored under the reservation to present additional witnesses or evidence in support of the threat article.
Just to understand it before we go on a break, ma'am, so bakit po bukas yung oral arguments on the can you include AMLAC, BIR, and other pertinent documents prior to the assumption of Sara Duterte as Vice President? Why are we jumping?
What I understand, why the reason, Pinky, is we have pending motion for issuance of subpoena. We have pending requests for issuance of subpoena of these documents, including those prior to 2022. No? Itong documents na to, that includes bank documents, that includes the AMLAC documents, that includes the BIR documents. No? Parang hindi naman kasama yung SALN. Parang we have them already. No? So for these three documents, they include those prior to 2022, and that is why I believe the impeachment court deemed it proper to set the oral argument tomorrow before they decide on the request of the prosecution for the issuance of this subpoena.
We'll be taking a very short break. We'll continue our discussion with Congresswoman Jervil Jinky Luistro when we return. Stay tuned. This is On Point. Welcome back. Still with us, House Lead Prosecutor Congresswoman Jervil Jinky Luistro. Congresswoman, so sino pong mag-opening statement for the prosecution bukas?
It will be Congressman Chel Jokno. Of course, we understand. He has been with the academe for so long. He has been a seasoned litigation lawyer, no? As a matter of fact, decano siya, Dean of the College of Law, before he was elected as member of the House of Representatives. So we are very much confident and positive about his engagement to represent the prosecution in this debate regarding the relevancy of the documents prior to 2022 in this impeachment trial.
Let me ask you this, Congresswoman. What kind of an effect would a possible vote by the senator judges, if it comes to that nga, tungkol po dito sa pertinent documents, that they decide that prior to 2022 is unnecessary, which means, I guess that would be a, not a loss, but you don't, I mean, you wouldn't call that victorious on your end, hindi ho ba? Kasi gusto nyo isama yung prior to 2022. Malaking epekto ho ba yan sa pagsusuri o sa debate or proving the point of unexplained wealth kung hindi po masama yung prior to 2022?
Without dwelling on the merits, no, Pinky, and without reference to this particular impeachment trial, but by allowing the documents pertaining to acts or omissions prior to the time when the public official became an impeachable official will provide a clear picture of what happened. And by clear picture, it will provide the source, it will provide retention, ownership, control, no, and accumulation. As a matter of fact, without reference to this particular impeachment trial, if it is proven that what was acquired as ill-gotten prior to becoming an impeachable official is still retained by the public official, then there is a continuing violation of the law. At the very least, RA 3019 or perhaps the plunder law, or even 6713, the law pertaining to the ethical standards of public officials and employees, no? And I wish to point out as well that with respect to the constitutional provision on accountability, particularly Section 2 of Article 11, ang binanggit lang naman doon, who are the impeachable officials? Ang binanggit din lang doon, what are the grounds for impeachment? But the Constitution never provide with respect to the timeline regarding the date of commission, omission or commission of act that constitutes an impeachable offense, no? Sabi sa Section 2, Article 11, the impeachable officials are as follows: President, Vice President, members of the Constitutional Commission, and then the justices of the Supreme Court, the Ombudsman, no? And then they made mention also about the grounds. Kasama dun yung mga culpable violation of the Constitution: treason, bribery, graft and corruption, betrayal of public trust, and other high crimes. But nowhere will you see the timeline as to the commission of the act, as to whether it should be committed prior to or during the time that the public official is an impeachable official. Walang binanggit ang Constitution doon, no? And that is very clear. That is without specific reference to the subject matter of this impeachment trial.
I actually remember two things after you said that. I understand that you weren't referencing it to the issue now. So let me reference it to the impeachment proceedings trials in the past. During the Corona impeachment trial, I do need to research on this, just to be very frank, and look back again. But were there references prior to the Chief Justice on his SAL-N that were used before he became Chief Justice? Number two, also with former President Joseph Estrada, were there also references used that the court admitted prior to him becoming president?
Yeah, that is correct. Meron. As a matter of fact, we can invoke legislative precedents, no? Sapagkat merong mga incidents na pinag-usapan during the trial which are prior to becoming the impeachable official. We can include, as a matter of fact, Pinky, yung kaso ni Justice Sereno naman, where the basis for the grant of a co-warrant of proceeding ay yung failure niya na i-disclose yung kanyang salary as a UP professor, which was during the time, long before she became a member of the Supreme Court, right? No? So, ang point doon, without, again, particular reference to this impeachment trial, no? Kung yung prior conduct ay ginagamit as basis of disqualification, just like what happened to Justice Sereno, then it must be considered as well in removing impeachable public official.
And siguro para mabalikan lang yung kay Justice Sereno, Congresswoman, hindi po kasi natuloy yung impeachment proceedings laban sa kanya.
I understand.
Hindi ho ba? Well, just
I understand.
making it clear, except yung, of course, ang natuloy po yung kay Chief Justice Corona rather, and former President Joseph Estrada. I mean, it's you know, we have to look back at all the impeachment proceedings that happened in the past. So now that will be the case, it will be still up to the senator judges to decide on this. Now, I want to go back to some of the highlights of what happened today, which is really part of my questioning dahil nagulat din po ako. I was surprised with the turn of events towards the last part of the impeachment day. Anong araw na ho ba to? 1, 2, 3, day 5. All right. Ma'am, ang sinabi niyo po kanina, maganda na po kasi yung testimony ni Attorney Lotoc at ni Senior Agent Calilong. Now,
perhaps hindi lang siguro maganda kung hindi kompleto na.
Kompleto.
And the supposed offer of testimony for Attorney Zulaika and Captain Bello were served already in the testimony of Agent Calilong and Attorney Lotoc.
Okay. Having said that, ma'am, yung pong kanina, some of the points that I wrote down, yung tinanong po kasi itong grave threats, because of course ito naman po yung pinag-uusapan the past days. Attorney Binluan, when asked, said the defense was saying it wasn't a threat in the first place. Ang sabi po niya, it was a mere response to a Q&A and it was never aimed directly to BBM, the First Lady, and the former speaker. Yun po yung kanyang sinabi. I forget who asked that question. Could have been Senator Judge Pia Cayetano. But do you remember that, ma'am?
Yeah, but our position has always been res ipsa loquitur. No, I do not want to dwell really too much on the merits of the case, okay. But ever since ang position ng prosecution dyan is res ipsa loquitur, and those utterances constitute an impeachable offense.
Can we talk about, though, are you allowed, please forgive me if you are not allowed, are you allowed to even comment on some of the seeming flaws that the defense were highlighting during the questioning, the cross-examination po kay Attorney Binluan, yung pong mga typographical errors and even the mismatch of the dates?
I don't know really how my fellow prosecutors are addressing the questions, no? But under the sub judice rule, and we were reminded as well by the presiding officer during the first day of the trial, we're not supposed to comment on the
okay.
on the merits of this impeachment trial, no? And that is why I've been very, very restrictive in providing answers to your questions, no?
Apo.
But nevertheless, about the inconsistencies, discrepancies, without again specific reference to the subject matter of this impeachment trial, as to whether it will affect the theory of our case, it depends if it is significant or not. Mm-hmm. Our position is they are not significant.
It was also Attorney Lotoc who said that the grave threats were real and actual. I think that's what he said yesterday. All right. So it's day 5. Bukas po ay day 6. Equally, I'm sure interesting, especially because of this oral argument on documents, BIR files, etc. Last question, ma'am. What happens to that BIR box? Does that mean that if the vote becomes favorable to the prosecution, does it necessarily mean that the BIR box can be opened?
Okay, so to update the viewing public, no, the BIR box was returned already by the impeachment court to the BIR, no? But I wish to share as well that part of the request for issuance of subpoena is an expanded list for BIR documents, no? And that is supposed to include what we believe are inside this BIR box, no? So we hope that we will be able to get the favorable judgment of the impeachment court with respect to the debate which will happen tomorrow, because doon nakasalalay yung completeness ng mga documents na nire-request ng prosecution on this request for issuance of subpoena. Kasama doon yung expanded list ng BIR documents. Not only those which we believe are inside the box, but even the other documents of the BIR which we believe are pertinent as well in this impeachment trial.
And just to last question, ma'am, I saw you yesterday together with some of the House prosecutors and even, of course, the defense. How are you guys? Are you in high spirits? Pagod ho ba kayo? Kamusta ho kayo ang prosecutor, public and private?
The prosecutors are always in high spirit, both the public and the private prosecutors, no? We believe in the nobility of what we are doing. We believe that this is for the Filipino people. We understand that this is a constitutional duty, no? And yes, we are always in high spirit, and we're positive that we will be able to present all the evidence necessary to support the 4 articles of impeachment.
And we'll see you again tomorrow. Maraming salamat. House Lead Prosecutor, Congresswoman Jervil Jinky Luistro. Thank you po.
Thank you, Pinky, and thank you to all the viewers and followers.
And that's On Point. Join us again tomorrow, 7:30 p.m. here on BNC, the Bilyonaryo News Channel. I'm Pinky Webb. Thank you for watching.
Oplan Romanov pa rin ang sentro ng ikalimang araw ng impeachment trial. Target daw nito si VP Sara, kaya siya nagbanta laban sa first couple at kay dating House Speaker Martin Romualdez. Pero ayon sa testigo ng prosekusyon, sa kapatid ng bise mismo na si Mayor Baste Duterte nanggaling ang salitang Romanov. Yan ang agenda report ni Hannah T. Nag-uulat live mula dito sa Senado. Hannah.
Corina, ang usapang Romanov ay issue sa umano'y banta laban kay Pangulong Bongbong Marcos at sa kanyang pamilya. Hindi raw ito banta laban kay Vice President Sara Duterte. Yan ang isa sa mga lumitaw sa 5th day ng impeachment trial ni VP Sara matapos tanungin ni Senator Judge Raffy Tulfo sa NBI si NBI Regional Director Jeremy Lotok tungkol sa pinagmula ng salitang Romanov na iniuugnay ng depensa sa tanong ni blogger Princess Maui sa online press briefing ni VP Sara noong November 2024.
Saan ba talaga yung Romanov nag-umpisa at sino ba talaga ang dapat mag-ingat doon sa banta na Romanov?
Yeah, insofar as our investigation is concerned, since nag-start yan doon kay Mayor Baste at wala ho kaming ma-validate na ibang Romanov operations na nangyari, I think nag-start yan sa kanila, sir, sa kapatid ng Vice Presidente.
Ayon kay Lotok, batay sa investigasyon ng NBI, hindi nagsimula ang Romanov sa online press conference. Sa halip, nagmula ito sa pahayag ni Davao City Mayor Baste Duterte sa isang maisog rally kung saan sinabihan nito si PBBM na, quote, think of the Romanovs bago matulog. Corina, ang mga Romanov ang huling Russian imperial family na na-execute noong 1918. Kasunod nito, tinanong ni Senator Tulfo kung ang tinutukoy ng Romanov ay babala laban sa first family at hindi kay VP Sara. Sumang-ayon si Lotok at sinabing iyon ang lumabas sa investigasyon ng NBI. Dagdag niya, wala rin silang napatunayang umiiral na hiwalay na Operation Romanov. Kung sumipot daw sa investigasyon ng NBI si blogger Princess Maui matapos itanong ang umano'y operasyon sa online presser, standard procedure daw ng Bureau ang i-validate ang impormasyon at magsagawa ng case build-up para matukoy kung may katotohanan ang naturang pahayag. Tila dumepensa rin si Senator Judge Alan Peter Cayetano at ipinaalalang hindi raw dapat i-conclude na may banta rin si Mayor Baste laban sa first family. Una na rin kasing sinabi ng defense panel ni VP Sara na iba naman daw ang Romanov sa Operation Romanov na tinanong ni Princess Maui sa bise.
And in the same manner, we have to be fair to the first family. We have to be fair also to Mayor Baste and to the Dutertes, that rather than draw a conclusion that there was an actual. So the Counsel for Defense was making a distinction, mentioning Romanov and Oplan Romanov are two different things. It may be the same, it may be different thing. For all we know, narinig ni Mayor Baste na sila Iro Romanov, kaya binanggit niya pabalik. We don't know. I don't know.
Nasa day 5 na tayo ng trial at hinihimay nila kung pasok ba sa grave threats at inciting to sedition ang naging banta ng bise laban sa first couple at kay dating Speaker Martin Romualdez sakaling may mangyari raw sa kanya. Corina, napag-usapan na rin kanina kung pasok ba sa inciting to sedition yung naging pahayag nga ni VP Sara doon sa 2024 online press con at nang tanungin si Lotok kung masasabi bang was someone incited by the remarks of the Vice President, kinonsidera raw nila yung utterance at yung naging pahayag mismo ng bise at tila naging epekto nito sa publiko at ipanilotok maituturing kasing example si VP Sara bilang public official at bukod pa rito may sinite siyang desisyon ng Korte Suprema na ang sinasabi sa People versus Nabang hindi raw kailangang may aktual na naganap na pag-aalsa o sedisyon bago maging illegal ang isang pahayag. Sapat na ayon sa Korte Suprema na ang pananalita ay may tendency na mag-udyok ng sedisyon o maglagay ng panganib ng kaayusan ng publiko. Corina.
Hana, ang ibig bang sabihin nito ay maaari pang idagdag bilang pang-5 article yung inciting to sedition? Saan papaloob yun? Sa grave threats o hiwalay siya at mas malubha na krimeng matatawag? O basehan para sa impeachment?
Corina, katunayan na tanong yan ng prosecution or rather ng defense team ni VP Sara doon sa witness nga na si Attorney Jeremy Lotok kung masasabi bang impeachable offense ang grave threats and inciting to sedition. Gayong yun yung lumalabas daw na tila reklamo laban sa bise because of the controversial remark nga of the Vice President doon sa press conference. Pero nilinaw naman kalaunan sa Senate Impeachment Court na ang pasok doon sa articles of impeachment ay betrayal of public trust kung saan sinasabi nga doon or nakapasok doon yung grave threats and inciting to sedition na reklamo laban sa bise. So bahagi yan noong Article 4 nga ng Articles of Impeachment. Corina.
I see. Hana, ilang oras na rin ang paglilitis pero hindi pa tapos dito sa grave threats na sinasabi at si Ginoong Lotok nga ang nakasalang at hindi pa natin nakikita si OVP Chief of Staff Zulayca Lopez. Sasalang pa ba siya sa witness stand ngayong araw?
Corina, sa ating latest monitoring, nandito pa si Attorney Zulayca Lopez na OVP Chief of Staff pero hindi tiyak sa ngayon kung isasalang ba siya sa witness stand dahil supposedly yung sabina para sa kanya ng Senate Impeachment Court ay kahapon lang at ngayong araw. So nasa desisyon niya ng Senate Impeachment Court kung may extend ba ito hanggang bukas o kung mamayang gabi ba ay posible pa siyang maisalang. Anyway, Corina, kahapon naman din na-brief na rin tayo ng Senate Impeachment Court na posible ngang mag-extend hanggang mamayang gabi itong paglilitis ngayong araw given na magkasunod itong si Lotok at si Zulayca Lopez. Balik sa'yo, Corina.
Okay, maghihintay tayo. Maraming salamat, Hana T. Nag-uulat live mula dito sa Senado. Ginisa muli ng defense team ni VP Sara ang prosecution witness na si NBI Director Jeremy Lotok. Ang mga senador, judge, sumingit na rin sa pagtatanong tungkol sa Oplan Romanov. Yan ang agenda report ni Dexter Ganibe ng Abante, live nag-uulat mula din dito sa Senado. Dexter?
Corina, 2 oras kahapon, 3.5 oras ngayon, kabuang 5.5 hours o nasa ganun nga, nakahaba ang isinagawang cross-examination ng depensa dito kay NBI Director Jeremy Lotok. Agad nakapag-umpisa ang depensa sa pagpapatuloy ng kanilang cross-examination sa ikalawang testigo ng prosekusyon para sa Article 4 ng Articles of Impeachment ngayong ika-5 araw ng impeachment trial. Pero hindi naman dire-diretso ang pagsasagawa ng cross-examination ngayong hapon dahil may mga pagkakataon na nagtatanong din ang senator judges. Kabilang narito ang usapin ng Oplan Romanov at natanong din ang prosekusyon at depensa na bigyang linaw nila ang issue ng grave threat.
Ang question ko ay, in your appreciation, dapat ba na ang supposed victim nakaramdam talaga siya ng threats? Or is it enough that the general public considers the statement threatening?
Etong sinabi ng Supreme Court, all that needs to be proven is that they were intended by the accused to have that effects. Yung sagot sa tanong, hindi po galing sa prosecution, hindi po opinion, galing mismo sa Supreme Court.
It is our position that the statements made by the Vice President were not threats in the first place. That's why we were categorizing it as response, a mere response to a Q&A. Number one. Number two, it was never aimed directly at BBM, FL, and the former speaker.
Samantala, sa inilabas niyang pahayag ngayong araw, batay sa naging paglilitis kahapon sa Day 4 ng impeachment trial, nanindigan si Vice President Sara Duterte na ang reklamo laban sa kanya ay hindi suportado ng mga ebidensya. Lagi niyang ginigiit ng prosekusyon na may nangyaring pagbabanta, gayong wala naman talaga ang pagkakaroon ng hitman pero panay imbento lang daw at pawang mga hinabi lang na ebidensya na hindi naman kayang gawin ang mga kathang isip na isang katotohanan. Kailangan niya ay nakabatay ang impeachment trial sa mga kapani-paniwalang ebidensya at hindi sa espekulasyon, gawa-gawa na naratibo o copy-paste na affidavit at mga aligasyong walang matibay na ebidensya. Kahapon kasi, inamin ni Attorney Jeremy Lotok na ang ilan sa mga nakalakip na affidavit sa isinumiti nilang reklamo sa DOJ noong Enero ng 2025 laban sa Vice Presidente para sa grave threats ay templated affidavit dahil sa pagkakapareho ng mga typographical errors. Samantala, ako rin nabalikan ko lang ang pagkakasalang kay Attorney Jeremy Lotok bilang testigo dito sa Article 4 matapos yung napakahabang cross-examination ng depensa. Abay, sumasalang pa ulit siya ngayon sa redirect. Bakit nga ba nangyayari itong redirect examination? Ginagawa ito ng prosekusyon kapag may mga nasambit ang kanilang testigo doon sa cross-examination na medyo makakasira doon sa mga nauna niyang sinabi sa direct examination, kaya nagkakaroon ng redirect para maitama nila yung mga pahayag ni Attorney Jeremy Lotok. Karina?
Okay, so mukhang mahaba ang ating gabi, Dexter, at meron pang redirect pagkatapos ng cross-examination. Siguro naman pagkatapos ng redirect, meron pa bang kasunod yon?
Pagkatapos ng redirect, Corina, kapag may nakita naman ang depensa na kailangan nilang itama doon sa nangyari sa redirect, ay magkakaroon ng cross-examination. Titignan natin yan along the way, baka abutin nga ng gabi or dahil gabi na rin, titignan natin kung maisasalang nga ba ngayong araw itong si Attorney Zulaika Lopez, ang Chief of Staff ng OBP na kanina ay dumating na dito, mag-alas 2 ng hapon, nandito na siya sa Senado. At may dagdag ko lang po rin na ang defense team pala ay talaga ng kanilang deputy spokesperson, sa katauhan po yan ni Attorney Justin Nicole Golar. Siya yung hahalili kay Attorney Michael Powa kapag absent si Attorney Michael Powa o hindi niya kayang magbigay ng briefing sa media kaugnay ng mga updates sa impeachment trial. Attorney Justin Nicole Golar na isang Cebuano lawyer ang magbibigay ng updates sa media para sa depensa. Corina?
Maraming salamat, Dexter Ganibe ng Abante. Nag-uulat live mula rin dito sa Senado.
Imbento at walang ebidensya. Ito ang banat ni VP Sara sa ikalimang araw ng kanyang impeachment trial. Giit ng bise, walang nangyaring pagbabanta sa buhay ng first couple at ni former House Speaker Martin Romualdez. Gawa-gawa lang din daw ng prosekusyon ng issue ng assassin para patibayin ng akusasyong grave threat laban sa kanya. Dagdag ng VP, dapat nakabatay sa matibay na ebidensya ang paglilitis at hindi sa kathang isip lamang.
Wala talagang lusot para sa prosecution si VP Sara sa paratang na grave threats. Tinulugsa din nila ang anilay panlilin lang ng depensa sa mga Pilipino. Ang detalye sa agenda report ni Isaiah Mirapuentes ng Abante, live mula sa Senado. Isaiah.
Pinky, nasa ikalimang araw na nga tayo ng impeachment trial laban kay Vice President Sara Duterte. Subalit ayon sa prosecution, Pinky, wala raw sila nakikitang sinyales na nagiba o nasira na ang mga ebidensyang laban kay VP Sara. Sa katunayan, Pinky, ayon mismo kay Representative Terry Redon na isa sa mga House prosecutor, tila parang no-brainer daw kung magtanong ang mga abogado mula sa depensa.
May kinausap na ako na tao. Sinabi ko sa kanya, kapag pinatay ako, patayin mo si BBM, si Lisa Araneta, at si Martin Romales. No joke. No joke. Nagbilin na ako, ma'am. Pag namatay ako, sabi ko, huwag ka tumigil hanggang hindi mo mapatay sila. And then he said yes.
Second highest person in the land and wants to be president in 2028. Is this the kind of president that we want?
Walang duda ang House Prosecution Panel na nagbanta ang bise laban sa matataas na opisyal ng bansa.
Una, kung totoong hindi siya kumuha ng killer, ibig sabihin niya vice president that lies. Di ba? Pero kung totoo na nag-contract siya ng killer, then you have a vice president that contracts a killer.
Ang depensa raw, sa halip na itinanggi ang mga ligasyon, ay tila nililinlang na ang taong bayan. Hanggang sa umabot pa nga raw sa pagkwestiyon sa typo errors at sa tila pagtuturo sa Pangulo na umano'y nagmando sa investigasyon laban sa bise.
Kumbaga sa Bisaya pa, ganahan sila nga maglibog ang tao ba para kung ang tanaw nimo dili na nimo maintindihan. In other words, yun ay paglilihis. A deviation from the real issue being discussed.
This was never denied by the Vice President. It was not denied in the answer. And even, 3 days when she was asked about this, and bukod sa hindi niya to deny despite the repeated opportunities to do so, yung fact ho na pag-amin niya, isa yan sa pinakamataas na uri ng ebidensya.
Giit pa ng prosekusyon, kahit ano pa ang idahilan ni VP Sara, ang banta ay banta. At saklawaan nila ito ng betrayal of public trust na isang impeachable offense.
Pinky, alam mo, ayon pa sa prosekusyon, ang hinihintay raw nila ay kontrahin ng depensa ang aligasyon ng grave threats laban kay VP Sara. Subalit hanggang sa ngayon nga raw, Pinky, wala pa silang naririnig kaugnay rito. Maliban pa dyan na Pinky, hindi rin daw pwedeng sabihin ng defense team na walang ebidensyang magsasabing may umano'y pagbabanta nga dahil ayon mismo sa prosekusyon na panood ng taong bayan ang video ng tila pagbabanta ni VP Sara sa first couple maging kay former House Speaker Martin Romualdez at sa katunayan nga, Pinky, ginamit pa mismo yan ng defense team sa kanilang cross-examination. Pinky.
Maraming salamat, Isaiah Mirapuentes ng Abante, nag-uulat ng live mula po dyan sa Senado.
Habang nakatuon ngayon ang pansin ng publiko sa issue ng grave threats, naniniwala naman ang isang abogado na hindi ito ang pinakamahirap na artikulong haharapin ng depensa. Mahalaga rin daw na tandaan na ang impeachment ay hindi ordinaryong criminal case. Hindi lamang ito usapin ng paglabag sa batas ang sinusukat, kundi kung karapat-dapat pa bang manatili sa pwesto ang pangalawang Pangulo. Usapang SALN ang nakikita ni Attorney Tranquil Salvador na pinakamalaking hamon para sa depensa ni Vice President Sara Duterte. Kabilang si Salvador sa nooy defense panel ni former Chief Justice Renato Corona noong 2012 impeachment trial, kung saan naging sentro rin ang issue ng SALN at naging basihan para sa impeachment ni Corona. Sinabi ni Salvador sa memo ng Bilyonaryo News Channel na di katulad ng grave threats na naaayon sa magkaibang interpretasyon ng magkabilang panig, ang mga numero sa SALN ay hindi maaaring baluktutin ang pangangatwiran. Sa huli, ano ang dapat abangan ng publiko sa mga susunod na araw ng impeachment trial at ano ang magiging pinakamahalagang batayan ng impeachment court?
Sa SALN, tsaka yung unexplained wealth, yung sa AMLA, secrecy of bank deposit. Even in the past, yan ang mga issues Nung kay CJ Corona, yan ang issue. Nung kay President Estrada, yan ang issue, remember? Yung kay CJ Sereno na hindi naman nag-trial, di ba? Na-file sa Supreme Court, saliin rin ang pinag-uusapan. So I think that's something that the public could easily understand. Kasi ba't hindi na-deklara? Ganon. So sa tingin ko, yun ang greater challenge ng depensa. Tapos yung BIR box.
Noong 2001 sa impeachment trial ni President Joseph Estrada, nagdesisyon ang mayorya ng senator judges na huwag buksan ng second envelope na naglalaman ng mga numero at dokumento na nagpapatunay ng ill-gotten wealth ni Erap. Ito ang naging mitya sa pagsiklab naman ng EDSA 2 at pagpapatalsik rin kay Estrada bilang presidente. Noong 2018, nagkaroon din ng impeachment complaint laban kay dating Supreme Court Chief Justice Maria Lourdes Sereno dahil din sa isyu ng salin. Pero bago pa umusad ang impeachment proceedings, tinanggal sa pwesto si Sereno ng kanyang mga kapwa mahistrado dahil sa quo warranto petition ng nooy Solicitor General na si Jose Calida. Mahalaga rin anya na makumbinsi ng senator judges ang publiko sa mismong proseso ng impeachment court. Ano man daw ang maging desisyon nito ay mas magiging katanggap-tanggap sa publiko kung makikitang patas, maayos at kapanipaniwala ang paglilitis at may malinaw na ebidensya.
Kasi at the end of the day, ang process, ang greater challenge ng Senate dito is the entire process should be credible. Because regardless of the outcome, if it's credible, ang tao kahit na, alam mo, masama loob niya, tanggap niya eh. Alam mo yung gano'n eh. Pero pag nakita niya hindi, magre-react ang tao.
May duda siya.
Yun ang kasama rito. Kaya it's a very challenging process.
Makakasama natin ngayon si House Prosecutor at Justice Committee Vice Chairman Jonathan Keith Flores. Magandang gabi po sa inyo, Kong.
Magandang gabi po.
Opo. So, before we go into grave threats, do you agree sa sinabi po ni Attorney Tranquil Salvador na baka ang pinakamatinding haharapin ng depensa ay hindi pa ito grave threats, kung hindi yung confidential funds or all evidence that have anything to do with numbers? Kasi hindi mababaluktot ang numero.
Well, tama naman po, in a way, tama din po. But sa tingin ko po, lahat naman ng articles na impeachment na final namin, ay may strength naman po.
Okay, so going back to grave threats, pinag-aralan po namin kanina lahat ng mga sinasabing elemento ng grave threats. 4 po yung nakasulat, binasa namin. So ano po sa palagay ninyo, pasok naman sa lahat ng elemento ng grave threats?
Based po sa findings ng NBI na sinabit nila sa DOJ, pasok naman po yung elements. But ang importante po dito is that we're not trying the Vice President on grave threats alone. This is articles of impeachment po na ang tinitingnan po natin dito is not the criminal aspect of grave threats only, but whether she is fit to stay in the position, in an impeachable position po.
So thereby, kailangan hintayin natin hanggang dulo lahat ng 4 na artikulo.
Hindi naman. One has its own purpose.
Each one has
Yes
its
po.
own
end po. No?
Yes.
Ito naman is betrayal of public trust, culpable violation of the Constitution, pero hindi siya necessary na grave threats lang as a crime itself.
Okay. So, can it stand alone as an impeachable offense? Grave threats. Kung mapatunayan yan, sabi ng iba, tulad ni Attorney Howard Calleja, it's enough. Hindi na natin kailangan magpatuloy, pwede na siya ma-impeach. So, that is possible.
Well, if we have established everything po na ganun, sabi sa testimony ni Attorney Lotok and the other NBI witness po na the threats were made, it's not been denied by the defense naman po. Now, they admitted that the video existed, that these things were said. So, that alone is already enough po.
Kung ganyan lang po kadali ang pagrarason, bakit po inaabot tayo dito ng 7:30, 7 o'clock? Hindi pa tapos, may redirect pa pagkatapos ng cross-examination kay Ginoong Lotto.
Ongoing ang redirect ngayon. Minsan na we're caught up in the technicalities of things. If only we could keep it simple sana na maintindihan not only by the senator judges but also by the people who are watching the impeachment proceeding, mas madali po sana.
So, ano pa sa palagay ninyo? Parang, delaying tactic po ba ito? Parang deliberate, they're deliberately going technical para mapahaba?
I don't want to say that po, but I think that they're using everything that is legally possible to be used para ma-exhaust din nila whatever time that is given
Ano
to
po
them.
ang assessment ninyo? Nagtagumpay po ba sila sa kanilang cross-examination?
Sa akin,
Yung alam nyo na, yung mabawasan ng kredibilidad ng presentasyon ng NBI.
Sa akin naman po, yung mga minor errors like the typographical errors, the wrong case numbers, it doesn't change the fact that these things were uttered by the Vice President. It doesn't change the fact na sinabi niya yun, sinabi niya totoo yun, di ba? And walang nagbago doon as far as we are concerned po.
At ang sagot doon sa tanong ni Senator Pia Cayetano na kailangan ba nakaramdam ng pagbabanta ang mga pinagbantaan bago yan makonsiderang grave threats? Ang sagot is jurisprudence.
Yes po.
Well,
for as long as dumating sa kanila and they felt threatened also by the statements that were made, then that is also considered as a threat already.
ayun. So para sa inyo, your one-line assessment is one more point again for the prosecution?
Well, I would say that because I'm with the prosecution po. I'm sure they would say another thing. But sa akin naman is walang changes na nagawa sila. Serious damage to whatever the testimony was of Attorney Loto.
So kumbaga parang klaro, basta't ikaw ay nagbanta, that's grave threats.
Yes po.
Against the President et al. Okay, so sa palagay po ninyo, hanggang kailan po itong tungkol sa grave threats? Magtatagal? Baka matapos na ngayong gabi?
We were hoping to finish it this week po. But as nakita po natin, instead of just 1 day per witness, humahaba po ng 2 araw with just 1 witness. May, I think, 2 more on the list supposedly this week na hindi namin naisalang because of the delays that has happened.
Do you foresee that this particular witness, si Ginoong Lotok, hahaba pa hanggang mamayang gabi? Paglaon po ng gabi?
Right now, it's redirect So maybe may recross na naman yung defense. But that should be just a few questions. Depende din sa haba ng redirect ni prosecution.
Hanggang ngayon na lamang po ang subpina ni Attorney Zulaika Lopez, ang Executive Assistant ng Vice Presidente. So, sa palagay nyo, ipipilit nyo na po na matuloy na rin ang kanyang pagsasalita ngayong araw?
Kung if the Senate will not break for the day, no? Meaning hindi sila mag-adjourn early and bibigyan nila lang yung opportunity na tawagin si Attorney Lopez, then it might happen today.
Okay, huling tanong na lamang po. What do you intend to accomplish by putting on the stand a hostile witness? Ano po ang mahihita natin dito kay Ms. Lopez?
Well, she was there when the statements were made. When the Vice President made those statements. So it's important po na mabigyan din siya ng opportunity to state this for the record din.
Na nandoon siya, at narinig niya?
Narinig niya.
Yun lamang po?
And she was there. Other things po, I'm sorry, I cannot elaborate now.
Okay. Abangan ang susunod na kabanata pala ito.
Yes, ma'am.
Okay. Maraming salamat, Congressman Jonathan Keith Flores from the prosecution team. Thank you po.
Thank you po.
Isang panibagong kabanata na naman ang inaasahan ngayong araw sa impeachment trial ni Vice President Sara Duterte. Matapos ang 5 araw ng testimonya, wala munang witness na haharap po sa Senado ngayon dahil nakatakdang pagtalunan ng magkabilang panig yung hiling na masubpina yung bank records, yung AMLAC records at BIR records ng Vice Presidente at ng kanyang asawa. Dapat naman, hindi ba?
Kasabay niyan, pinag-uusapan pa rin ang naging desisyon ng prosecution na wag nang iharap sina Attorney Zulaika Lopez at Captain Belinda Bello bilang mga testigo sa Article 4.
So matapos ang jam-pack na 5 araw, tinanong namin ang taong bayan kung makakalusot nga kaya sa mga kaso si VP Sara. Sa kanilang palagay, ang sabi nila, particularly on grave threats.
Hindi ko naman siguro. Pero wala naman akong mapapala kung tutusin niya. Pero kung ano mong mangyari, pahala na sila. Kasi sa akin lang, nahanap ko ay lang.
I don't think na makakatakas siya. Threatening itself is already like a very huge parang threat na or card sa ibang party na okay, she's being defensive, so siguro she's really hiding something and she's really involved with something corrupt.
Yes. It might be a controversial thought. I hope I'm wrong. Sana mali ako. Pero sa nakikita ko sa recent progress po ng impeachment, diverting ourselves to different issues as opposed to the main issue. But nevertheless, I think at the end of the day, she won't, the VP won't get the punishment for example people are, shouting for.
Siguro makakalusot for the meantime sa panahon ngayon kasi 'di ba marami silang mga connection. Lalabas at lalabas naman na yung katotohanan eh. Kahit anong sabi na nga may example yan, kahit gaano mo dinidiin yung isang tao, pero kung wala naman lihim na di nabubunyag, right? Sabi yan sa Bible. Kaya yung doon sa impeachment ni Sara, kung dinidiin niya yung Pangulo tsaka yung mga speaker na kung sino man yung sinasabi niyang tao doon sa impeachment niya, alam ko darating yung panahon na haharapin nila yan. Kung makukulong sila, makukulong. Kung dinidiin naman ito, kung wala namang kasalanan, darating yung araw na makakalaya din sila at malilinis yung pangalan ng Pangulo.
Ano kaya ang naging estratehiya sa likod nito at paano nito maaapektuhan ang direksyon ng impeachment trial? Makakasama po natin ngayong umaga, House Prosecution Panel Member at Bicol Saro Representative Terry Ridon. Magandang umaga po, Kong. Terry? Hello, sir.
Magandang umaga. Maraming salamat sa pag-imbita.
Opo. Kahapon po sinabi ninyo, galingan pa ninyo. Ano pong ibig ninyong sabihin doon? Parang ito ba ay dahil sila ay bigo sa kanilang tangka na guluhin ang usapan tungkol sa grave threats? Ano po ang inyong assessment?
Again, binanggit ho natin yun before the resumption yesterday and hindi ho nagbago yung position ho natin. Hindi ho natibag yung kredibilidad ni Atty. Lotok, hindi ho natibag yung kredibilidad ni Mr. Calilong. Doon po sa usapin po ng pagbabanta laban sa Pangulo at sa kanya pong pamilya. Yun naman po yung essential aspect nung pong testimonya. Hindi po yung mga sinasabi nila mga typo error, hindi po yung sinasabi nila na nagbabagong docket number daw po ng DOJ na wala namang kinalaman si Atty. Lotok.
Okay, so bakit po talaga bang kailangan po natin pagtiisan yung pagsisinsin ng lahat ng kuntil-butil ng batas kung pumapaloob nga ba ang mga nilalaman noong video na pagbabanta ni VP laban kay Pangulong Marcos na lahat ay binubusisi, bawat letra? Kailangan po talaga nating daanan yon?
Kapag siyempre nung depensa po, na makapaglatag ng, at the very least, as far as they're concerned, a credible defense. No? So, kung yung pong kanilang estratehiya at taktika ay sinsinin yung pong mga bawat pirma, bawat mama versus ma'am na pagkakamali halimbawa doon sa mga dokumento, ipinapaubaya ho natin. Pero siyempre, sa dulo-dulo naman ho, yung mag-appreciate po nito, yung po mga senator judges at yung mga kababayan po natin. Kung yung mga pagtatanong po ba ay wawasak doon po sa na-establish na pagpapakita ho talaga ng pagbabanta ng pangalang Pangulo laban sa Pangulo at sa kanya pong pamilya.
Kung Terry, halimbawa itong desisyon po ng prosecution na hindi na ipresenta sina Attorney Zulaika Lopez at Captain Belinda Bello, ay talaga nga bang dahil lang redundant na ika nga at di na kailangan ng kanilang testimonya?
Tama ho yun kasi nasapatan na ho kami kahapon doon sa talaga pong very comprehensive and extensive direct and cross ni Mr. Calilong at ni Mr. Lotok. No? So, tingin ko ho, yung pong pagsasalang kay Miss Bello at kay Miss Lopez, pandagdag na lang ho yun eh. Kumbaga, wala hong bagong detalye, walang bagong kwento. Kasi, for example, ang itatanong lang naman po kay Attorney Lopez ay talaga nga ba na binanggit ni Vice President Sara Duterte in her presence ito pong mga utterances, mga pagbabanta laban sa Pangulo at sa kanya pong pamilya. Pero pasok naman na ho eh. Yung pong video documentation. In fact, hindi nga ho ito dinidebate ng depensa. Mayroon lang ho silang paliwanag kung bakit po ginawa ito pong pagbabanta na ito.
Pero ipapatawag niyo pa rin ba si Attorney Zulaika sa ibang mga artikulo?
We will see po. That is something that we will have to decide as soon as we get to that point. No? So, I think she was listed as a witness for confidential funds as well. No? So, we will see po if she will be placed on the stand pagka po umabot na po tayo ron.
Okay, so ito pong si Miss Lopez, Zulaika Lopez, she seems to be an intelligent person. No? I mean, meron siyang talino. At ang pangamba nga po ng iba para sa inyo sa prosekusyon ay magagamit ni Miss Lopez ang pagkakataon na siya'y tetestigo para, to grandstand or to promote the messaging of the defense. So ngayon nawala na yung pagkakataon na yon na magamit niya ito. Pero hindi kaya siya'y gagamitin naman ng depensa bilang isang testigo din?
Wala naman ng problema doon. Sa totoo lang, it is the prerogative of the defense to implement however strategy that they would want to undertake. No? So, kung isasalang husin nila si Attorney Lopez for their defense, then we will subject her most definitely to cross. No? So, antayin natin. Kaya nga wala naman ho napagsasara dito po sa testimonya po na ito, in the event, for example, na gusto naman po ng depensa na si Ms. Lopez yung isa lang relating to the threats against the President.
Okay, so today marks the end of the discussion threats. Tama po ba? Kasi iba na po yata ang pag-uusapan ninyo mamaya.
May isasalang lang pong hiwalay na usapin, yung sabina po ng AMLC at ng BIR documents na mag-asawa po ng Duterte Carpio. Pero magtutuloy po yung witness testimony on Monday si NBI Director Melvin Matibag po. Yung po isasalang sa Lunes. Pero today will be devoted solely for discussions on whether or not a subpoena should be issued on the BIR and the AMLC records of the Duterte Carpio couple.
And just to refresh the memory of our viewers, gaano kahalaga, sir, na masabpina itong mga bank records at BIR tax records ng BICE, sir?
Mahalaga po ito kasi this will complete the financial picture of the Vice President over the course of several years. No? Kasama po dyan yung SALN, kasama po dyan yung iba pang mga ownership and financial documents which will be subpoenaed and presented as well. Kasi dito natin makikita kung meron ba talagang unexplained wealth yung ating pong pangalang Pangulo. So, I'm certain marami pong itatanong kailan yung cut-off nung pong mga taon, nung pong mga dokumento pong ito. Pero ang position po namin kasi we should be able to get an actual baseline of the wealth of the Vice President. So, it should coincide doon po sa panahon that she was actually submitting SALN documents. No? So, ang position ho namin as far back as 2007 when she first became a public official.
Inaasahan nyo ba kung Terry na mag-rule ang presiding officer tungkol dito sa issue or pagbobotohan ito ng mga senator judges after the oral arguments or within the day?
Ang understanding ko namin talagang kasi I think this is a foundational question, particularly on the unexplained wealth article. Tingin ko pagbobotohan po ito ng kapulungan ng atin pong Senate impeachment vote.
Ayun, okay. So, ito pong, mabalik lang po tayo sandali sa grave threats. So, what was established exactly so far? Na pumapaloob talaga may 4 pong elemento yan pinag-aralan namin kahapon. 4 elements, the lawful elements that constitute grave threats. Sa amin pong assessment, kami-kami lang naman po, parang pasok. Dahil all you need to do is to threaten and that's it. Pero sumampa na po ba sa sedition or inciting to sedition itong ginawa po ni Vice President Sara ayon sa prosekusyon?
Well, batay po doon sa testimonya ng ating pong witness, Attorney Loto, yung pong totality of the actuations and utterances of the Vice President would in fact show that she was inciting seditious acts on the public or on her supporters. So, yun po yung kanyang pagtingin. So, ibig sabihin, even if may sinasabi na wag daw pong mag-EDSA, pero yung pinagsama-sama kong mga public statements po niya would still signal na she might have been inciting the public towards sedition. So, yan po yung distinction yan. But again, hindi naman ho kailangan establish yung inciting to sedition for grave threats to actually be present. No? So, tingin ko naman ho, the threat made by the Vice President herself has already been established and that would arise to a betrayal of public trust as far as the prosecution is concerned.
Ayun, okay. So, teka, last question ko na lang ito. Sorry po, hinahabol ko lang. Hindi po ba kapag ikaw ay isang public official, I mean, all of your finances should be transparent. Period. Hindi po ba, nasa Constitution po ba yon na ngayon ay kailangan papunin yung pagdebatehan kung pwedeng isubpina and make public or not?
Well, to be fair naman po to everyone, meron ho talaga silang riniraise halimbawa na concerns relating to confidentiality of AMLC records and confidentiality po of the BIR records. Pero ang position ho namin dito kasi, yung po Senate Impeachment Court, meron po yung, hindi lang po yan kapangyarihan sa ilalim ng batas, kundi kapangyarihan sa ilalim ng konstitusyon na makapagsabina po ng iba't ibang mga dokumento. In the same manner na yung pong mga korte, pwede ho magsabina ng mga BIR documents yan at ng iba pang mga documents po yan. So, kumbaga, yung confidentiality issue does not apply to the Senate Impeachment Court. In the same manner, na yung pong mga bank records does not apply to the Senate Impeachment Court under the Bank Secrecy Law. So, yan ho yung more or less gist po ng magiging debate po mamaya sa Senate Impeachment Court relating to the matter.
Ayun pala. Kaya pala kailangan pang pag-usapan. Kumbaga, there is a right to subpoena but not necessarily automatically the right to divulge confidential information about a person or even the Vice President. Okay, so kasunod po ng usaping yan ay sama-sama naman nating basahin ang sagot ng Madla Online. Ano po, Kong? Alamin natin kung ano nga ba ang kukumbinsi sa publiko. Ano ang kukumbinsi talaga sa publiko na guilty si Vice President Sara Duterte? Nang tanungin namin online, ang sabi nila, sabi ni Ikop Angelo, already convinced. I guess the real question is, what can prove that she is not guilty?
Sabi ni Mel PJC, she is not guilty. At least for those who watched the video in its entirety in real time. She was just acting as any normal person will do in those circumstances.
Sabi naman ni Angie Legara, hard evidence and there's definitely a lot. Guilty.
Sabi naman ni Ayan Saluta, wala. Kung may kasalanan naman siya, mas lalo naman yung nag-aakusa sa kanya. Daming ha.
Okay, Nelson Malabanan, ang linaw-linaw ng video evidence, tinatanong pa ba yan? Ayun, okay. Kong Terry, maraming salamat. Good luck po mamaya at tututukan po namin ang inyong debate. Salamat po.
Thank you, Kong.
Maraming salamat. Magandang umaga.
And the spokes is back. As the impeachment unfolds onto its sixth day of trial, both the prosecution and defense fight over evidence, witnesses, and procedure. How does an actual impeachment defense team think, strategize, and respond?
Our guest for today, he has lived it as part of the defense team of former Chief Justice Renato Corona. Joining us is former President and Dean of PLM College of Law, Dean Jose Roy III. Welcome, Dean.
Welcome,
Judd. Attorney Judd.
Good morning,
How should we
Edwin.
call you?
Judd is fine.
Judd, okay.
Good morning, Edwin. Good morning, Relly. Good morning, Philippines and everyone out there.
Full disclosure, classmate ko po to sa Ateneo. Kaya uupakan ko po ito ngayon. Kasi kaaway namin sa impeachment.
Second disclosure, he is also from LaSalle, where I also went. Third disclosure, I promise to let Pinoy rest in peace if he leaves it alone.
As well as I promise to leave Chief Justice Corona rest in peace.
Nako, ano pala ang role ko dito? Magiging referee pala ako.
Hindi naman.
Siya ating guest.
We respect what has happened and we lay to rest what is resting. So let's leave it at that. But there are many lessons from the past that can lead us into a better insight of what's going on
And that's
today.
what we want to hear from you, right?
Well, what did you want to know?
Marami.
You were, how were you? I noticed, and the late Chief Justice Corona was a member of the Utopia fraternity.
Right.
And almost all his lawyers were all Utopia.
Right.
Except for you.
I was one of the few who isn't. Dennis Manalo and I were not.
Right.
And I suspected Dennis Manalo was from the Iglesia ni Cristo, but it was only by the accident of a surname.
Okay. But how were you recruited by Chief Justice?
Well, this is the truth. When he was under siege and the president was attacking him publicly, if you recall.
Yeah.
Whatever it was, no? So, Chief Justice Corona, who is a very self-effacing and quiet fellow by nature, was unsure how to proceed. So he inquired in the court and he asked around, is there anyone here who handles public relations, who replies and whatnot? And they told him, sir, he's not here anymore. Who is he? And they mentioned my name because I used to be chief of staff of Andres Narvaza.
Yeah.
And if you remember,
Yes, you were.
Yes, you remember that we had to deal with that hoodlum in robes
Yeah,
issue
right.
Yeah.
for a long time. And I worked closely with the Chief Justice, who was a mentor and like a second father to me, and the court administrator and all that. And the court administrator at this time was no other than Maidas Marquez, who lived down the road. Just like Boying Remulla lives down the road from where I live. But anyway, so the long and short of it is he came to me. He says, can you help me? They're going to do this to me, etc., etc. And I was surprised. I was oblivious to what was going on. So that led to that day when he appeared on the steps and he rallied the judiciary and he called Pinoy some nasty names.
That's okay.
That's how.
Let sleeping dogs lie.
But that's history, diba?
Right.
Yeah.
And that's how it started. And then December 14th, and you know that it was transmitted directly, and they had 188 signatures, and so it was instantly sent. So we received a copy of the. Well, we were meeting already, you know, and I was actually the first member of the defense team putting it together. Then the Utopians came, Dito de Los Angeles.
Issues and answer your queries are none other than Representative Isabel Maria Zamora of San Juan City, Representative Zia Lonto Adiong of the 1st District of Lanao del Sur, and also spokesperson of the prosecution panel, and Attorney Benjamin J. Tolosa Jr., also one of the spokesperson, and a member of the House Prosecution Panel. To start the ball rolling, let's hear first the opening statement of Representative Zamora.
Good morning, everyone. Good morning to our friends in media and to everyone watching. Magandang umaga po sa inyong lahat. So, as an opening statement, let me recap what we have seen in the past 2 days. We presented Attorney Jeremy Lotok of the NBI. He is the chief of the Cybercrime Division when the investigation subject of this case was conducted. And the gist of his testimony was that the threats made by the Vice President against the President, the First Lady, and the former Speaker of the House of Representatives were real, actual, and serious. He also said that if they allowed this behavior, if they did not find the threats to be serious, then anarchy, chaos, and disorder would occur, as this behavior is highly unusual. We were able to conclude the presentation of the witness. There was, after the direct testimony, there was cross, there was redirect and recross. And we concluded the presentation of the witness yesterday. He also answered questions by the senator judges, but in essence, and as earlier stated, he reiterated that the threats were actual, serious, and real. Also, yesterday, counsel for the panel of the prosecution, Attorney Lorna Patapunan, manifested that we will no longer be presenting Attorney Zulaika Lopez and Captain Bilyonaryo as witnesses for the prosecution in relation to Article 4 or the grave threats article. This is because their testimonies would merely be corroborative, meaning dadagdagan lang naman nila yung testimonya ng ating dalawang witnesses na si Agent John Mark Calilong at si Attorney Jeremy Lotok. In the words of Attorney Kapunan, their testimonies would be unnecessary, redundant, and a mere surplusage. So we have for later the oral arguments regarding the BIR box, and we will hear the sides, the two sides, and we were given 15 minutes each to present our case and 10 minutes for rebuttal. And of course, time was given also to the senator judges further questions. So in the meantime, that is our opening statement. I hope that everyone will watch the proceedings later and in the coming weeks. Thank you very much.
All right, we're now ready to answer your questions. Rosalie, do the honors.
Good morning, ma'am, and good morning, sirs. Ano po ba ang relevance ng process na isasagwa po mamaya sa oral arguments po sa request na isapina yun pong bank records and tax records of the Vice President, given that pang-fourth naman po itong article na ito sa presentation niyo po?
Well, first, you'd remember that we first filed the request for the issuance of subpoena for these documents. And then the parties were directed to submit the respective memorandum. So doon ho tinatalakay kung ano yung mga kanya-kanyang legal arguments and positions namin dito. At minabuti na din ng impeachment court na iset din ito for all our arguments. And I think magiging purpose nito mainly is, aside from hearing the parties articulate their arguments in support of their position, gusto din nilang magkaroon ng pagkakataon yung mga senator judges na matanong ng diretso yung mga parties ukol sa bagay na to. Ngayon, that's a good question. Bakit natin pinag-uusapan na ito kung itong mga dokumentong ito ay relevant pa with respect to the unexplained wealth na based on the order of presentation of evidence, pinakahuli pa naman yan. Pero minabuti na ho kasi namin na mas maaga, humingi na ng subpoena para sa documents na to para ho masigurado nating hindi makapag-cause ng delay yung usapin ho dito, no? Because we already anticipated it. Again, they will probably try to block it, which is exactly what they're trying to do now. Kaya we already asked for their issuance in advance para tuloy-tuloy na ho yung pagpresenta namin ng ebidensya pag nandun na tayo sa unexplained wealth.
Okay po.
Well, you want us to respond to...
If you want to, sir, it's all right.
Well, unang-una, it also allows the court to examine and probably to appreciate these documents. Remember, these documents are not only technical, but it could be voluminous. So to give time for the court also, and for the defense as well, to appreciate these documents and also to have them time na makita nila kung ano yung and how relevant these are, these documents to the articles that we would present after the grave threats.
Follow-up lang po. Since si Representative Terry Redon po, yun pong assigned prosecutor to lead yung pong presentation sa article na ito, do we expect him also to lead the prosecution in the oral arguments?
Every time we're asked about the particular assignments of the prosecutors, you always have one response. No, we hope you understand why we can't go into the details of these matters. These are matters of strategy that we can't disclose. Para clear lang hon, ayaw naman namin magmukhang bakit tayo di pa namin sabihin. Sabi nyo nga, of course, naghahanda kami. Alam na namin kung sino ang mga designated lawyers sa mga ganyan-ganyang bagay. No? Pero iniiwasan lang ho natin yung sitwasyon na we will say in advance, this particular prosecutor will handle this matter, will do these arguments, will present this witness, no? Pero pagdating na sa panahon, nauupo na itong testigo na to, baka biglang merong kailangang changes for whatever reason, unavailability, no, whatever. Iniwasan lang natin yung sitwasyon na baka gawin pang issue to, no? O bakit biglang nagpalit, no? Nagkaroon ba ng problema, whatever. So may nabuti natin na hintayin na lang natin, no? Total, yan naman ang mas importante dito, no? Yung mga ebidensya na ilalapag namin, argumento, na ilalatag namin sa korte, hindi ho yung mga personalities.
Dadagdag lang, Congressman Terry Redon is more than capable to handle this article. In fact, he was assigned to present this article to the court, but there are certain adjustments and elbow room for the prosecution to make sure na whatever is the flow, kasi depende rin po yan sa flow ng discussion sa korte. So mag-a-adjust daw talaga yung presentation din ng evidence, including the prosecutors who would present evidence and the call for testimony of witness sa impeachment court. So kaya ganun may elbow room pa rin. So elbow room is meaning to say allowing the prosecution panel to decide on time kung ano yung mas hindi lang strategy but how to relay the information or the evidence clearly to the public. Yun ang pinaka-primary consideration po ng House Prosecution Panel, not just to prove to the court that we have the evidence to prove our allegation, but as well as for the public to effectively and easily understand.
Sorry po sa kulit. Miyane. But we heard reports po, si Representative Shell Jokno po, yung pong mangunguna sa oral arguments ng prosecution team. Is that confirmed?
Oral arguments today, no? Sir, a while ago you were asking about the next articles, is that?
No,
correct?
for today's oral arguments
But for today's,
po.
again, I hope you'll understand that
That's not yet confirmed po.
Let's just wait and see. Total,
Okay, last na
ilang
lang
hours
po.
na lang naman mag-start na tayo.
Okay po. Ikaw na lang yun, B. Last na lang, sorry. Yun pong, if ever lang, speculative question, if ever hindi pagbigyan po ng impeachment court, yun pong inyong request for the subpoena ng bank and tax records, enough pa po ba or sufficient po yung evidence nyo po to prove the allegation of unexplained wealth against the Vice President?
Definitely, we have enough evidence to support each of the articles, and even if we don't have the documents that we are requesting for, we can support the prosecution of the 4 articles.
Of course, no, we don't want to preempt the decision that and the action that the impeachment court will take on this matter. But as pointed out by Kongwell, our case is not hinged on just one evidence, no? For example, as we've stated, we intend to present these documents in relation to the articles of impeachment, no? For the charges on unexplained wealth. So, ang dami hong dokumento na gagamitin din, no, para mapagpatibay ho yung charges, no, tukol dito. For example, we have the SAL-ins, no? We have so hindi lang isa yan, madami ho yan, no, yung doon sa AMLAC records, BI records, bank records, and testimonies of witnesses. So hindi naman ho nakasalalay lang sa isang ebidensya yung kaso natin.
Idadagdag ko lang, no, every evidence will stand on its own merit. Ang ginagawa po ng ebidensya, tinatahi po yung pinapresenta ng ebidensya at yung pangalawang ebidensya para magkaroon po ng whole picture understanding ating mga kababayan para ino-collaborate po ng isang ebidensya patungo doon sa ebidensya. So, importante po yun. Again, ito pong impeachment trial na ito, sui generis po siya, may legal component. Meron din pong component kung saan dapat ang taong bayan mas maintindihan nila ng maayos yung ating pinag-uusapan dito. So, we are also looking at presenting this evidence not based on its probative value, but based on how the people would understand and have a full picture of what we're talking here under the article na kung saan pag-uusapan yung unexplained wealth ng Vice Presidente.
Sir, very quick clarification lang. Mamaya po ba, dalawa yung motion na lalatagan doon sa oral arguments, hiwalay po yung tax records, hiwalay din yung AMLAC and bank records. Paki-clarify lang, sir.
Yes, that's correct. No? But as to how they'll go about it dun sa oral arguments, no? Because I think we were given 15 minutes, no, to present our side, and mukhang kasama na yun, no, yung two issues. No? Kailangan matapos na within 15 minutes.
Depende po sa Senator Judges paano sila magbobotohan. Kasi natanong po yun ni Cayetano kahapon kung hiwalay ba.
In terms of how they'll rule on it, yes, these are separate requests. So, although, no, ang mga arguments dyan would be meron na common arguments. No? For example, yung arguments nila about pre-office conduct. No? Ayaw nilang makapagpresenta tayo ng ebidensya na paukol dun sa mga panahon na hindi pa siya presidente. So that applies to all. So yung arguments dun, relating to those different kinds of documents.
Sorry, sir. Just to follow up on Ate Rose's question. Bale, sabi ninyo kanina, if ever hindi payagan ng impeachment court itong inyong motion, ay meron pang mga ibang evidence that can support this alleged unexplained wealth article. Kasi I understand dun sa hearing ng House, ang crucial was the AMLC report. Can you expound lang kung how will you prove this just based on SAL-in po ba?
Can I take it first muna? Unang-una siguro, we're getting ahead of ourselves. No? Why are we already speculating that it won't be granted? No? Because ang position namin dito, napakalinaw. Of course, no? We respect, no, the authority of the impeachment court to rule on this matter. No? Ang Constitution sa kanila yung binigayan. But just the same, ang position namin, we don't see any reason why we should not allow, no, the introduction of these documents, no, in these impeachment proceedings. After all, purpose nito impeachment proceedings nito, no, is to exact accountability. No? Yan ang hinihingi din ng mga tao. Bakit hindi natin tignan lahat ng mga ebidensya na makakapagpakita kung ano ba ang katotohanan? No? Kung makakabuti ito or hindi makakabuti sa magkabilang panig o kanino man. At the end of the day, makikita talaga yan kapag binuksan natin. So, hayaan natin, no? Wag nating, pangunahan, at wag nating katakutan yung paglatag ng ebidensya. Kung merong kakatakutan, siguro yung paghadlang sa ebidensya. Ano?
Ako, in connection to that, no, ito'y isa doon sa panawagan, halimbawa, at pagre-respeto din, in a way, you can say it, doon sa mandato po ng Senado to try and decide ang impeachment case. Dahil unang-una, mabibigyan ho, para sa amin, itong pagpresenta itong mga ebidensya na to, maibibigyan po ng lahat ng anggulo ang impeachment court na mag-decide sa kanilang judgment, mag-arrive into judgment with all the complete evidence and the whole picture in order for them to appreciate and eventually to arrive into impartial and sound judgment. So ito'y makakatulong din po sa mag-exercise ng impeachment court ng kanilang mandato bilang hukom, no? Mas maganda po para sa amin yung isang trial ay accessible ang lahat ng mga relevant na dokumento, testimonya at witnesses para ang korte ay mabigyan ng whole picture o lahat ng kinakailangan na dokumento para sa kanilang para ma-exercise sila kanilang trabaho at mag-render din ng mas magandang at mas na appropriate at proper na resolution or judgment pagdating sa punto na ito'y matatapos na.
Okay, Tina, your turn.
Good morning po, Kongs and Attorney. Can you walk us through what will happen this afternoon? Like, mauuna po bang mag-argue yung prosecution because kayo po yung nagpapasabpina and immediately followed by the defense po ba? Or can the senator judges already ask questions sa prosecution? Ano po yung mangyayari?
So it seems like we'll be given the first opportunity to articulate our arguments in support of our request for issuance of subpoena. So we'll be given 15 minutes to do that. That will be followed by the respondent's turn to discuss their counter arguments, no? Tapos merong rebuttals. So we'll be given 10 minutes. 10 minutes will also be given to the other side. And it looks like once we're done, that will be the time when the senators would be asking questions towards the parties.
Thank you.
No follow-up. Eden, your turn.
Good morning po. Yun pong pag-address ng prosecution panel sa mga testigong sina Attorney Lopez and Bello ay parang patunay na hindi na pag-isipang mabuti ng prosecution ito bago sila ginawang testigo or natatakot lang ang prosecution panel na baka sa halip na makatulong ay makasama pa po sa kaso under Article 4 ng impeachment.
Actually, without giving too much information from the prosecutors here, it's actually the opposite. It's the opposite why we decided not to dispense with the testimony of Attorney Zulaika and Ms. Bello, precisely because we think it over and we have decided na pag-usapan talaga na yun talaga yung proper na way to move forward. Unang-una, we don't want to consume too much time of the court kasi kailangan ang mismong respondent also deserves expeditious trial. Pangalawa, gusto rin natin, again, binabalikan po natin ito, na gusto natin ang may latag na kaso or ang argument na pag-explain natin sa articles ng ating kaso ay mas maintindihan ng maayos ng ating mga taong bayan. Kung nailatag naman po yung draft dapat na rason kung bakit ipapatawag sana natin si Attorney Zulaika at si Captain Bello ng mga naunang testimonya ni Mr. Lotok ay para sa amin, it is proper and it is more convenient for the court to dispense with the presentation of Attorney Zulaika and Ms. Bello. So your question, hindi ba napag-usap? Actually, it's the opposite. Pinag-isipan ng mas maayos.
Can I also add something to that? Tulad doon na sabi namin dati, pagkatapos namin magupo ng testigo, lagi ho kaming sa team, we meet, nag-uusap, nag-analyze, nag-assess. Ano na ang mga importanteng bagay na natalakay na ng aming testigo? At ano pa ang mga ninanais naming talakayin gamit ng mga ibang testigo? At titignan namin kung ito ay na-cover na, natalakay na nung mga naupo namin, hindi na kailangang iupo pa sa witness stand yung mga iba. Sabi nga ni Kong Zian, naririnig ho namin ang panawagan ng mismong impeachment court ng mga kababayan natin na wag nating itong pahabain unnecessarily. And that is exactly what we're doing. Gusto din naman naming mapabilis ito as much as possible. Now, ano ba ang mga naging importanteng mga testimonya na binigay na sa atin ng dalawa nating witnesses? First, napakalinaw na dun sa naging testimonya ni Agent Calilong na authenticate na nung video kung saan ginawa yung pagbabanta sa buhay ng presidente, no? At alalahanin natin during that first hearing, I mean the first witness's testimony, mismong depensa na ang umamin sa katanungan ng mga senador na ginawa talaga itong threat na to. Ano ho? So wala nang question diyan, ginamit pa nila yung sariling video. Second, si Attorney Lotto, pinaliwanag niya, no, he emphasized that the detention was not the cause of the threats. It was not the cause why the Vice President had an agreement with an assassin to assassinate the President. No, Attorney Lotto pointed out that it was admitted by the Vice President during that November 23, if I'm mistaken, no? Yeah, live interview, no? Na sinabi niya doon, nung tinanong siya, sumagot siya, huwag kayong mag-alala, meron na akong kinausap. No? Meron na akong kinausap na tao. Sinabi ko, di ba, nabigay siyang instructions, patayin mo ang presidente, ang asawa niya, no? First Lady, Speaker of the House. At sinabi niya, pumayag na siya. Sinabi niya, oo, no? Okay. At nagbigay pa siya ng instructions paano gawin nito. Diba? Huwag mo silang titigilan. Huwag kang titigil hanggat di mo sila napatay. Napaka-importante ho niya, no? Dahil sinabi na nga ni Attorney Lotok, ang pinapatunayan nito, nagkaroon na ng ganitong kasunduan na patay ng presidente bago pa nangyari ang detention. So, hindi ang detention ang reason kung bakit nangyari ito. Pupunta ako ngayon, bakit hindi na natin kailangan tawagin pa, no? Si Attorney Zulaika, no? At si Captain Bello. Si Attorney Zulaika, maalala natin, during cross-examination, pinalabas ng depensa yung portion ng video kung saan makikitang nandun din siya sa loob ng kwarto kasama ng Vice Presidente nung ginawa itong mga pananakot. Ano? So, initially, we wanted to present her as witness to help authenticate the document, no? The video. Pero, again, wala na hong issue doon sa authenticity dahil doon sa dalawa nating witnesses. Same as Captain Bello, no? She was supposed to testify, among others, yung circumstances surrounding this utterance. But, tulad nga ho, nung nasabi ko kanina, sinabi na nga ni Attorney Lotok, we don't need, no, to dwell on that dahil malinaw naman, hindi ang detention, no, ang reason kung bakit nagkaroon ng pananakot. Ang detention lang ay yun ang naging panahon kung kailan inanunsyo sa buong mundo na meron ng kasunduan na ipapatay ang presidente. So, because of those two clear testimonies of our first two witnesses, there's no more need to present Zulaika Lopez and Captain Bello.
If I may add, every day po after trial here, the whole prosecution team meets to discuss the witnesses for that day. Ginagawa po namin to araw-araw to see if there will be some change in the strategy, to see if we can limit the number of witnesses para po hindi mapagod ang ating senator judges, ang ating lawyers on both sides, at ang ating publiko na nanonood sa atin. So if we can limit the number of witnesses dahil po nasabi na ng ating mga witnesses ang kailangan nilang sabihin at ang gusto nating marinig, then we will limit the number of witnesses. And this is what we did. Siguro po, to add, no, it is the purpose for the presentation of Attorney Lopez was to indeed to authenticate. And it is not only because our first two witnesses, or the first witness authenticated the video, and our second witness explained the whole process of the investigation of the NBI, that we are removing Attorney Lopez as a witness, but it is because the defense themselves used the video that we presented. In short, sila po mismo tanggap nila na authentic ang ating video. Tanggap nila na sinabi ng Vice Presidente ang mga statements niya. It is just a matter of defense kung ano yung represent nila, no? In relation to the words stated by the Vice President. Remember nung nag-closing argument ang kanilang abogado, si Attorney Binluan, sinabi nga niya na, well, she said these statements because she was a mother, daughter, you know, all of that. And she was responding to threats. But in essence, the defense, are admitting that she made the statements, and these statements are threats.
Idadagdag ko lang, Eden, no? Practicality of the whole situation that we're in right now, no? Moving forward to the next presentation of the witness. Kasi kung lahat naman po tayo nanonood ng impeachment trial ng ibang nakaraang araw na ito, minsan ho, yung adjustment na ginagawa ng prosecution ay depende doon sa actual na development ng trial. Ibig sabihin, kung si Attorney Lotok, na-explain na nga po ni Attorney Jay at saka ni Kong Bell, na nasabi na niya ito. Nasabi na ni Attorney Lotok, so hindi na kailangan pa yung mismong tao na mag-testify na yes, nandoon ako. Kasi na-verify na yon from both the prosecution and the defense. So, I guess, again, ang decision ay minsan ay base po doon sa aktual na pangyayari sa trial. So, ang nangyari ng aktual na pangyayari at narinig natin kay Attorney Lotok ay nandoon nga si Attorney Zulaika Lopez, si Attorney Bello, ang i-testify naman ni Attorney Bello ay si pagta-transfer from the house detention facility doon sa saan yung facility correctional, no? Sa may Mandaluyong, and that would be her possible testimony. So, kumbaga parang na-lay down na yon, na-accept na yon at na-establish na yon as a fact. So there's no need to, again, call on these two individuals in order for the public to know and determine na nandun nga sila sa facility na. It will be redundant and also for the practicality of time para to make use effectively the time that we are allotted by the court in so far as presentation of the Article 4 is concerned.
Attorney, nabanggit niyo po na at nagbigay pa siya ng instruction paano gagawin ito, yung pagpatay ho, no, regarding dun sa taong kinausap niya. Huwag mong titigilan hanggat di mo sila napatay. So, kinukonfirma nyo rin po ba na may banta sa buhay ng Vice Presidente? Kasi mangyayari lang po yung binanggit nyong pagpatay sa tatlo kung siya ay napatay na.
Definitely not. No? Una, paulit-ulit din ho itong na talakay dun sa mga nakaraan na mga pagdinig, no? Na hanggang ngayon, maliwanag, wala hong kahit na anong ebidensya na sumusuporta dito na meron pagtatangkaw o pagbabanta sa buhay ng presidente. No? Ulitin natin, maganda ho yung na-point out ng ibang mga senator judges dito, no? Dahil na-raise during that interview yung Romanov, no? Na mukhang yan yung sinasabing konteksto ng pagbabanta sa Vice Presidente. Pero na-point out ho yung kahapon na itong usapin na Romanov na to, unang-una ho itong nabanggit ni Mayor Baste Duterte at ang konteksto ho nun ng pagkakasabi niya ay pagbabanta sa first family. No? Na-point out nga ho sa mga senator, no? Ang sinabi doon, bago kayo matulog ngayong gabi, alalahanin nyo yung nangyari sa mga Romanov. No, yan ho yan, hindi ho sila natanggal because of peaceful political uprising. They were assassinated, no? They were executed. So maliwanag, itong Romanov na to, pananakot ho to, no? Sa buhay ng first family. So, yung tinatanong yung inaamin ba ng prosecution na meron far from it, no? Dahil walang kahit na anong ebidensya. And importante din, balikan natin yung sinabi ni Attorney Lotok dyan, no? Sinubukan nilang mag-imbestiga paukol dito. Inimbitahan nila ng ilang beses ang Vice Presidente pero hindi ho tumugon sa paanyaya. Kaya hindi sila nagkaroon ng oportunidad, no? Na mas magkaroon pa ng mas malalim pang investigasyon dito.
Idadagdag ko lang, no? First of all, hindi po pwedeng i-dismiss kung ano man yung mga reports of grave threats. That's why I commend NBI for taking cognizance of this. No? Dahil unang-una, apart from mandato talaga nila na mag-imbestiga ng grave threats, if the threats are directed to the President, the sitting Vice President, at yung mga matataas na panipuno ng ating gobyerno, talagang they can do that man motu proprio to conduct and preliminary investigation. So hindi dapat talaga nadidismiss yan. Pero apart from yung sinabi po ni Attorney J na elucidated and explained very well ni Attorney Lotok na binigyan ng pagkakataon. In fact, she was invited, Princess Maui was invited to share information what they know about Oplan Romanov. Diba? Pero unfortunately, for 2 consecutive subpoenas or an invitation by the NBI, there's an unwillingness on the part of the Vice President and Miss Princess Maui not to share this very important information on the basis that she was very busy or she was busy with some office matters. Ang ordinary po na tao magtatanong, if we're talking about life and death situation, especially if there's an attempt to wipe out your family, would it be that the topmost priority of everybody na dapat if you have that opportunity for the investigative agency to delve into this matter, you will grab it. You will set aside all the matters that you are doing, all things that you are doing, precisely because it's a life and death situation. It does not only concern you, it also concerns the safety of your family. So bakit ordinary people would ask, bakit hindi pumunta? So ang nangyayari ngayon, and still, ang sinabi po ng NBI, this is still a case built up. May case built up pa. It doesn't even reach the stage where there's really that filing. No? Nagki-case build up pa. Ibig sabihin, open pa yung opportunity po para sa kanila, para pumunta sa NBI and to share information, whatever they know about this threat or this Oplan Romanov. So it's time for them. But how come for several months, even over a year now, ay wala pa rin pumupunta sa NBI. So again, it's very clear that the NBI is still open para maimbestiga ito. Pero compare that to the threat that the Vice President said in that Zoom meeting. In fact, if you ask me, it's not just a mere threat. It was actually a revelation. It was a confession because she actually described the way by which she sought the help of a killer in order to carry out her bidding of killing the president, the first lady, and the former speaker. It is not as simple as threatening you because you are doing something bad to me. That's why I want also to do something bad to you. It was actually a revelation. No? So, ipagtabi po natin yung narinig natin kay Princess Maui at yung nasabi accordingly sa first na lumabas itong Romanov sa statement ni Mayor Baste sa May Sugrari with that of the description of the meeting between the Vice President and the hitman. Magkaiba po yun. No? Kaya nga po, and this does not reflect the position of the House Prosecution Panel, but I think this is if they cannot supply an intelligent or information to the NBI to have a basis to carry on with their investigation regarding this Oplan Romanov, I think, and I'm sorry, this is, for me, is a manufactured scenario.
All right, Dwight, your turn.
Hello po, good afternoon, sirs, ma'am. I would like to ask po sana for you to take us behind the scenes a bit. How spontaneous was the decision to drop Zuleika Lopez from the witness list? Did that happen lang ba talaga during the, when you asked for a 5-minute, ang tawag din, parang 5-minute break or huddle? Or was it floated ba at least a day before in one of in your conversations? Sino yung nag-float nitong idea na, ay, wag na nating isaalang si Zuleika Lopez? Whatever you can disclose lang.
Yes, of course. Every day po, pag nag-uusap kami, pinag-uusapan namin kung represent pa ba natin ito, yung susunod. Hindi lang naman to kay Zuleika Lopez at kay Captain Belbelio. After all, we are already prepared to present these witnesses. We have, we've been preparing for many months now. And we have our draft question and answers or questions, and we already have in our heads kung ano sana yung flow, no? Pero araw-araw nagbabago po yan. Maski na not considering Attorney Lopez or Captain Bello, sabihin ko sa inyo, nung una nga, ang represent namin si Captain Bello dapat. Pero after one day, naisip namin si Agent Calilong. Nagbabago-bago po every day ang aming strategy depending on what happens earlier in the day.
Congresswoman, could you just say na at least the day before, pagkatapos nung day 4, nag-huddle kayo, it was floated at least yung idea na baka hindi na natin kailangan si Zulaika Lopez for day 5. Given also dahil last week, matatandaan natin, Vinluan, the defense lawyer, in his closing speech, he said that the threat made by the Vice President while conditional is justified. So,
Yes.
parang may admission na rin dating. So, may yun bang mga ganong statements trigger na yun to at least discuss it a day prior to have it
Yes.
floated? So, it was discussed at least.
Indeed, we discussed it the day before, we discussed it earlier. And again, hindi lang po ito para kay Zulaika, even for Captain Belbelio, who's our witness from Congress. So sila pong lahat to pinag-uusapan namin every day, yung ating list of witnesses or who will be presented the following day and the list of witnesses for the coming days.
But Congresswoman, it doesn't stop naman the prosecution from asking the court to compel Zulaika to attend in the future, given that she is listed primarily as a witness in the first article of impeachment, which is confidential funds.
Yes, of course, we can still present her in the succeeding articles should the prosecution see that there is a need to present her.
And on another topic po, yung memo, the prosecution and the defense have both filed their memos to the impeachment court. I would assume that the defense also gave you a copy of their memo. Have you read it? Of course, I would assume that you've read it, but what is your appreciation of that memo by the defense? And siguro kahit in broad strokes lang, dahil I know naman that you cannot discuss necessarily the merits of the case, because the main argument of the defense there is that the prosecution or the impeachment court cannot obtain documents that were produced prior to her vice presidency. Ayun lang po.
I'm thinking how to respond to this safely, because as you know, this will exactly be the subject of the oral arguments to be had this afternoon. And I promise you, once that's done, we can discuss this at length. But so in broad strokes, what you could say, consistent with what already stated in our articles of impeachment, her act of failing to properly and accurately and fully disclose in her SAL-ends her total assets and net worth during her entire incumbency as a public official, not just when she became a vice president. These are all impeachable offenses. This is anchored in the Constitution, which does not place any temporal limitation, meaning there's no limitation as to time. You won't see that in the Constitution that states that impeachable offenses are limited to those done while you're in office. Diba? And at the end of the day, we're talking about fitness of a public official, the highest public officials, to remain in office. So I hope that will be enough for now, but I promise you after this, when you get a chance to talk about it again, we can elaborate and discuss it at length.
Maybe a quick soundbite from Spokesman Adyong, because it's not covered by the subjudice. Quick soundbite.
Yeah, and this does not, again, this does not reflect the position of the House prosecution. I'm speaking not just the House trial prosecutor. I'm also, I also watched the proceedings. And ako po ay isang Pilipino rin. At gusto ko rin pong malaman ang katotohanan. There would be no point of proving the allegation under the articles if you don't have a point of reference. If your only contention is the current financial record, you cannot derive into conclusion that there's really that unexplained wealth. If you don't start, for example, providing evidence throughout the years kung saan nag-umpisa yung accumulation of wealth. So there has to be a point of reference, no? Whether anong year ba yan, anong taon na ba yan, it does not matter, no? Ang point is that you have, it's not that it does not matter, but it has to be certain point where you can actually prove to the court at malaman ng taong bayan na mayroong time, mayroong oras, may panahon kung paano ito nakuha yung yaman na ito. Kasi hindi mo mapoprove yan sa korte at hindi rin ma-appreciate halimbawa ng ating taong bayan na meron talagang allegation of hidden wealth kung ang titingnan mo lang ay isang punto lang ng kanyang salin. So you really have to go back to a point where you would prove to the court and to the people na meron talagang allegation, meron talagang unexplained wealth. So again, I'm responding to your question now, not just an House trial spokes or one of the House trial spokes, but also as a Filipino who really want to know the truth. Hindi ba ang taong bayan karapatan nilang malaman base doon sa artikulo ng unexplained wealth kung saan nag-umpisa at paano nasabi ng prosecution na meron unexplained wealth kung walang point na oras kung saan tayo magsisimula. Maraming salamat.
Dadagdagan ko lang last white, no? Ang posisyon namin dito, clear from our stated in the articles of impeachment, ang pagkamkam ng hindi mapaliwanag na yaman, hindi ginawa sa iisang araw lamang. Dito magmula nung simulang araw na umupo bilang Vice Presidente. So kailangan natin tuntunin kailan nagsimula to at nagpatuloy itong pagtatago nito hanggang umabot sa punto na siya ay Vice Presidente na.
And the mere fact that we're talking not just of hidden unexplained wealth, but it is an accumulated wealth throughout the years. So you really have to stop somewhere.
All right, Joy, your question?
Buenos dias po. Nawala yung regards dun sa BIR box, VP Sara exercise her executive immunity or claim her executive privilege to withhold the important documents on that BIR box. Would you seek the judicial clarification from the Supreme Court?
So pwedeng ulitin natin na medyo mas dandahan para maintindihan namin at sasagutin namin mabuti. Yes.
Kasi po, nakatuwaan po kami kahapon ng iba-ibang language. May Bisaya, may Koreana. Ayun, tanong na. Sir, yung sa BIR box po, how do you draw the line? If Vice President Sara exercise her executive immunity on opening the BIR box, yung ano po, kasi meron pong National Internal Revenue Code dyan, would you seek the judicial clarification from the Supreme Court?
First of all, there's no such thing as executive immunity, especially in relation to the disclosure of this BIR filings. Ano. So, sunod, kung ang tinatanong nyo, do we need to go to the courts to have this opened? Hindi yun. Ang tamang venue to tackle this matter is the impeachment court. Ito na ho yun. Kaya dito ho namin sinumite ang aming request na compel yung home presentation and submission itong documents na to.
Dadagdagan ko lang yung sinabi ni Attorney G. Remember po nung tayo ay nasa Kongreso pa at pinag-usapan na namin nila Kuya Congresswoman Bell, itong box na to ng BIR, di ba? Nagkaroon po ng usap-usapan doon. That's why it was finally decided not to open the box but instead to present it to the impeachment court, no? Dahil unang-una, ang position po ng BIR dyan is that it is not covered by the exception, no? Nung confirmation hearing na yon. So the exception, one of the exception for the ITR, whatever is the content on whatever is inside that box is ang impeachment trial. So nandito na po tayo sa punto kung saan masasabi po natin na exemption itong ginagawa po nating paglilitis dahil nandun po klaro sa batas na sinasabi ng ating head ng BIR na that's the only venue where we can actually open the box and to appreciate the content of the box, which in this case, the ITRs of the Vice President.
With regards naman po sa assassin, sabi po nung defense panel, the evidence is weak. Wala naman daw po napalutang na assassin. If no assassin has been acquitted and notified, charged or proven to have links to the alleged plot to kill the...
Joy, kindly put sa mic closer to you para
sige. First Lady Lisa Marcos, the claim meet the standard of substantial evidence kung wala pong napalutang na assassin. Yan po kasi yung kiniklaim ng defense panel.
Hindi naman po natin kailangan ng isang assassin na lumutang para patunayan na may threats po on the life of the President, the First Lady, and the former Speaker of the House. The mere fact that the respondent Vice President uttered these words, said these words, which was witnessed by a lot of people, or maybe almost everyone here, yun po yung mispong pagbabanta. Hindi po kailangan ng assassin mismo na lumutang para sabihin na may pagbabanta. Yun lang po.
Dadagdagan ko lang. Tama ho, we completely agree, no? Sa threats, hindi kailangan mapatunayan, no? Hindi kailangan dumaanak mo ng dugo, hindi kailangan merong bangkay bago mapatunayan na nangyari nga ito. Importante lang dito, tinitignan lang, meron bang pagbabanta na meron kang gagawin na labag sa batas? At seryoso ba ito? At pinaniwalaan ba ito ng taong tinatakot mo? Now, dun sa sinasabi nyo naman, meron bang assassin o wala? Napakaliwanag ho ng sagot dito. Meron. Anong basihan natin? Tulad sinabi ho ni Atty. Lotok, narinig natin pare-pareho ang si Presidente ang umamin dito. Ang explanation ni Atty. Lotok, this is what you call admission against interest. Sa rules on evidence natin, yan hong isa sa mga pinakamatibay, no, na klase ng ebidensya, no? Dahil ho dito nanggaling na mismo dun sa tao. Ang reason ho dyan, bakit napakatibay niyang ebidensya? Dahil ang isang reasonableng tao, hindi siya magsasabi, magbibigkas ng isang bagay na ikakasama niya. Kaya under rules of evidence, no, these are treated as proof of truth of those statements. So, meron ba? Meron. Meron bang assassin? Meron. Anong ebidensya natin dyan? Mismong admission against interest ng Vice Presidente. At hindi lang ho yan minsang sinabi. Alalahanin natin, nagkaroon siya ng oportunidad na klaruhin ang sinabi niya. 3 days after, no? Bawiin yung sinabi, sabihin na dala lang ng bugso ng damdamin, no? Pero 3 days after, mas kalmado na siya. No? So it can't be said that it's just a spur of the moment thing. Pero ano hong ginawa niya? Hindi niya binawi. Kinonfirm niya. She doubled down and tried to justify what she did by saying, revenge from the grave is not a criminal act. So, meron bang assassin? Ay, napakaliwanag o meron.
Alam niyo po, sa amin sa prosecution, 100% nag-agree kami kay VP Sara. Ang hindi nag-agree sa kanya, ang kanyang depensa. Kaya nung sinabi niya na may assassin, paniwalang-paniwala po kami. Ang depensa, ayaw po nila maniwala. But again, ito mga abogado po yung mga kasamahan ko dito. No? Kung sa regular criminal proceeding, kailangan talaga, kasi ang kinakailangan may mapapresenta mo is ma-prove mo beyond reasonable doubt. No? Dito po sa impeachment trial na ito, ang tinetest po natin is yung conduct, yung pananalita, yung galaw, yung pag-iisip, yung restraint, no? That despite political pressure, meron kang restraint ang isang halal na opisyal na hindi magsabi, gumawa o umutos ng anumang bagay na labag sa Constitution. Ito po yung pinag-uusapan natin dito, yung culpable violation of the Constitution, yung betrayal of public trust. These are constitutional standards imposed upon elective officials. At pag yun po ay nalabag, at saka na-establish naman po ng prosecution sa korte at sa ating taong bayan, at mismo ang Vice Presidente po ang nagsabi na meron po siyang nakausap para ipapatay ang Presidente, ipapatay ang unang ginang, ipapatay ang former speaker. Yun lang ho, no? Yung appearances, yung mismong pagsabi at pag-usap, pagkontrata sa isang assassin, ay labag na po yan sa constitutional standard na Senate para po sa mga halal na mga opisyal. At in this case, dahil si VP Sara Duterte ay ang kanyang ino-occupy ay impeachable office at impeachable officer siya, talagang ang batayan ng Constitution ay naaayon doon sa standard na dinidemand ng Constitution sa mga halal na katulad po niya na impeachable officer.
Ibalik po natin lagi sa impeachable offenses na ito ay isang impeachment case, hindi po to isang criminal case. Kaya po, huwag natin hanapin ang mga elemento ng isang krimen. Ang hahanapin po natin ay yung fitness ng isang impeachable official na manatili to remain as the Vice President of the country. In this case, and in relation to Article 4, yung pananalita ba niya doon sa online press conference niya, kung saan sinabi niya na kung saan siya nagbanta sa buhay ng presidente, na First Lady at ng former Speaker of the House, ito ba ay mga words na gusto nating naririnig sa ating second highest official? Yun ba ay isang character that should be exhibited by the Vice President? Again, babalik tayo, fitness po ng ating Vice President to remain or to be the Vice President.
On the alleged grave threats po, follow-up lang. Nabanggit po ninyo na na-establish na yung gustong ma-establish regarding the video, the utterances of the Vice President. Dito po sa video, do you still see the need to present the two journalists na according dito sa pre-trial brief ninyo, ang purpose ay to prove that the witness was present during the November 23, 2024 online press briefing na nasabi ninyo ay na-establish na po?
We are talking about the presentation of further witnesses. In the meantime, we have Director Matibag as the one listed next. So, let's just wait and see.
Kasi ma'am, I understand Tuesday po ninyo sinasubmit yung inyong parang list of witnesses for the following week. Nagawa na po ba ito at ilan po at least yung i-recommend natin for next week?
We will be informing the court about the identity of our witnesses next week during the hearing this afternoon. So let's wait for that so we could give the official list.
Magandang hapon po, Isa Umali from DCWB. 2 questions lang po. Inaasahan po ba na mas magbabawas pa po kayo ng mga testigos sa iba pang mga articles para mas mapabilis din po ito pong trial? And kung sakali po na magbabawas po kayo ng witnesses, hindi po ba ito makaka-apekto rin sa pagpapatibay po ng articles of impeachment? Thank you po.
Tulad ho kung paano yung ginawa namin dito sa article ho on threats, is ang babawasan lang naman namin na testigo, yung tingin namin hindi na kailangan no, para patunayan yung mga charges. So of course, kung material and relevant yung testimony niya at wala pang ibang witness na nakapag-cover ng topic na yan, hindi namin na waive yan. No? So again, at the end of the day, ang goal dito no, is to make sure that we'll be able to present solid evidence no, to substantiate the charges in the articles of impeachment. So, yan ho laging batayan natin. Yun ang tinitignan natin kung kailangan pa bang magdagdag o pwede nang magbawas ng mga testigo.
And another question po. Umaasa po bang House Prosecution Panel na maglalabas po ng written authorization si President Ferdinand Marcos Jr. patungkol po doon sa BIR box? Thank you.
Well, una-una, ayaw namin pangunahan kung anong gagawin ng BIR dito. No? Nandito pa lang ho tayo sa punto ng hinihingi pa lang namin is for the impeachment court to issue a subpoena to the BIR directing it to submit these documents no, to the court. So, after that, let's see how the BIR will act.
Pero mas maganda sana kung may authorization.
Well, ang sinabi ho ng impeachment court mismo, no, they pointed it out. This is what happened in the late CJ Corona trial, and it was recognized that it's one of the exemptions in the National Internal Revenue Code. So, it's one of the exceptions under the law.
Sorry po makulit, pero wala pa pong abiso sa inyo, sa prosecution, na magbibigay ng authorization si President.
Wala ho kaming ganong communication, no? Basta ang importante sa amin, again, let's take it one step at a time. Nandito pa lang naman tayo dun sa request ng subpoena, no? And afterwards, hintayin ho natin kung ano magiging hakbang ng BIR.
Tama po ba, Attorney Tolosa, yung oral arguments, isang araw lang po yun? Tama po ba?
That's correct. That's correct. Later, yeah.
Alright, dahil isang araw lang yung oral argument, samantalahin natin ng mga oras, bigyan natin ng pagkakataon makapaghanda ang ating membro ng panel of prosecution. Salamat po sa inyong mga katanungan. Muli, salamat kay Lanao del Sur 1st District Representative C. Alonta Jong, Representative Isabel Mera Zamora of San Juan, and of course, Attorney Benjamin Tolosa Jr. Sa inyo rin po, maraming salamat. Magandang tanghali.
Kill our good friend.
Right,
diba?
right.
But the question was, who would be lead counsel? Okay? And and we ended up with Justice Cuevas, and I don't mean to put it like it was a poor choice, but there were other names considered at the time. But Justice Cuevas came along, and it was magical.
You were the spokesperson during that
Well,
time,
no,
right?
actually it was Karen.
Karen Jimeno.
Yes, you see.
Our host here.
Yeah, every morning they would give us this EPIS-laden room in the Senate, diba? And Karen would come in early. But I was running everything. I was running the team. I was writing all the pleadings. I'd be working until 3, 4 in the morning. Dennis Manalo would be sleeping there beside me, keeping me company, thanks to him. But then he'd wake up at 6, 7 o'clock, and I'd throw it him, here, read this, and I'd sleep.
So let's talk about
Yeah, well, what is the difference between the impeachment, today's impeachment, as a legal observer?
Well, the circumstances have changed. No, the politics has not. The politics is the same, but social media has changed the color. Now you can't be legalistic. Back in the day, if you remember, Justice Cuevas, irrelevant, immaterial, technical objections, and the presiding officer was a litigator himself.
That's true,
and a
sir.
skilled and knowledgeable jurist and lawyer. No?
We were talking before the last week during the spokes also. Yung may mga snippets silang ginagawa that yung mga what you call this, they made sure, especially the defense, that there will be captured statements for reels and for social media,
Right.
for TikTok, etc. Because yun na daw talaga ngayon ng
Yes.
that's how it is
Yes.
now. No, it's really through the social media also.
Yes.
Because it's public perception after all. Right?
Well, for instance, just a simple, it's no secret I get invited to talk about this. I go into a radio station and everybody looks wonderful. Back in the day, looks had nothing to do with radio.
Kasi teleradyo ngayon, no?
Kasi now everything's online and streamed. But I'll tell you one thing. When we started the defense, it was very clear in my head, very, very clear that management of the media was important, okay? And we had a disagreement in approach, actually, inside the team.
Oh, okay.
I said, look,
because you were the PR guy supposedly.
No.
That's why they wanted you to get
it's
to be
just a
there.
strategy thing, diba? And so I was telling them at the outset, I said, look, we're going to be hounded by the press. I know because I had already been working with Chief Justice Corona on how to position himself publicly, so I understood what would happen, and I understood that because of my years with Narvasa. But I was telling them, the media is divided. Don't think they're here to report. These guys all have their own agenda. Di ba? You remember that very well, Edwin. But let's not go into who is what, di ba? Let's not go into who controlled what.
Let me ask you, and this is on a personal note. You were the chief of staff of the late Chief Justice Andres Narvasa.
Yes.
So you're close to the Narvasa family.
Sure.
Your grandfather is a friend of the father of the president.
Very, very.
Were you ever asked to be part of either the prosecution or the defense in this impeachment case?
Can I plead the fifth? I actually got invitations from both sides.
Okay.
And it's just not the right thing for me at this time. There are certain issues in my professional life which will make it difficult for me to participate. I mean, actively. No? But it's still a long process.
That you cannot disclose.
I'd rather not. It might color the things that I have to say, and I'm trying to be as open with you about the impeachment as I can, no? But this thing about going back to that point, for instance, when we started, for me, what was important was to create an impact right away. Okay? Because we were being out-bullied and outnumbered. That's how we felt. There's 13 of us.
No, but by the way, John, when we started the Corona impeachment trial, the people were against the impeachment.
Correct.
Not like this.
Correct.
So you had an advantage at this
Yes,
time.
we had an advantage. And I tried to get everybody going in that direction. And as I was telling you, there was a division in the media. No? There was some were partisan, some were less. But, so I was telling the team, let's not give interviews to the partisan media. Oh, cannot be, etc. Because, of course, as practitioners, their clients watch that other show. And I say, no, let them force them to come here. Let's go to the crappy media where the people are. And I don't mean it that way. I mean, the media that serves a different market. The market is segmented as, A, B, C, D, and all that. Some cater to the upper, some cater to the middle and lower, and so on. I was saying, let's go where it's friendlier.
Right.
Those opposed. So they refused. They said, no, we should be open, transparent. My goodness, what are you talking about? This is war, di ba? So I made it a point to project braggadocio all the time. Loud and strong, di ba? And I knew this would be unnerving for the prosecution. It would be intimidating because you see somebody, we have the full force of government, and this guy doesn't give a hoot. And he's using his elbows and his knees, and he's sticking his mug right there, and the people will find it refreshing.
Yeah, pero kasi si Chief Justice Corona, that's not his image.
No, that's not his image. He's not a chummy sort of guy. He's very reserved. Yes, quiet. Unlike the former Chief Justice, my mentor, Narvasa, this guy was a man's man. He had buds all over the place. So when we had that hoodlums in robes, people started coming out of the woodwork, manifesting support. I'm like, who are these guys? Yung pala, they're friends from old. Because he was a litigator, he was in practice, and he was moving around a lot. But Corona was a different sort of individual.
So you've got a lot of lessons that you can impart to this present crop of either defense or prosecution. But what lessons can you...
That is still relevant today.
Let me confess, okay? Because my friends in the prosecution are going to give me the finger after this. I called there are two young lawyers in the defense who are like sons to me. Okay? They're like my kids. They're the grandchildren of
Chief
Narvasa.
Justice.
So you're friends to Carlo?
Your
Carlo
mentor.
and Robbie. No, Robbie, not Bilyonaryo. It's
okay.
not related.
Okay.
There's another fellow there. He hasn't
Attorney
taken the
Narvasa.
floor. But I wasn't able to speak with Carlo before he got on. So it was a surprise to me. And I felt bad. Why? Well, I would have told them, which incidentally I will also disclose, I also told previously my friends in the prosecution.
Okay.
Before you go on, you go to the mirror, check your best side, see what's wrong with your facial expression, because the camera is on you 24/7. I said, they were saying, no, that's not important. And they were saying, no, we get our jurisprudence. No. This is about making the public
Projection.
understand what you're trying to do. The senators, they know that. They know where the cameras are in the plenary. They know where to look, they know, etc. They're always properly prepared to appear on the floor.
Right.
Even the sudden appearance of the Rolling Stone Bato himself, di ba? All prepared, di ba? I mean, they're always ready. You guys have to understand how that works.
Is that the reason why the way that the defense have been conducting is pretty much too technical?
Well, I think the first problem, and I'm going to be honest, and I hope I don't hurt any feelings, but if I do, like I said, it doesn't really make a difference much.
It's a
I think the
strategy,
problem was
right?
the tenor, no, the mood was overkill. It was too aggressive. And,
Even the defense was so
yes,
aggressive.
the defense. And so the poor kids, the young guys, they take their cue from the senior. Diba? I mean, the same thing with us. You know, if we overdid it, when I go back to the chair, the Cuevas,
talaga?
lintok na anong pinaggagawa
Parang
mo, kayo
overly
nakikipag-away. Diba?
Parang overly defensive, you're saying?
No, overly aggressive. I think they were trying to project that they were, you know, ready
What you were
for-
trying to project before.
Before, I was just trying to project confidence, loud voice, firm, that's all.
And do you
Diba?
think that's not going to
Without
work
fear.
now?
No, but this one is, it's just a question of degree. If you overdo it, then the question is, you seem so angry. Why are you angry?
Jed, let me ask you, when you were very aware that although this is a trial before the senators,
Yes.
you are aware that the main audience is the Filipino people.
Yes.
Do you think that there's the present crop of defense and also the prosecution have that thing in mind as well?
Now they do. After the first week of reactions, now they do. Now, there's two levels there, no, Edwin? Yes, it's the Filipino people, but the attention span of the Filipino people is with the social media. The other thing is, the audience is also the media.
Right.
Because, like you guys, you need to sell. Diba? You need to have viewership. You need to have interesting things, see? So these are things that you have to understand. And it doesn't come easy to anybody. It's not, I'm going to the impeachment, I'm going to be on TV, I'm going to study all my cases. You've got to do it with style. You've got to do it with clarity. You've got to communicate well. And most importantly, you've got to remember what is your purpose.
Yeah. So, how critical is the cross-examination in an impeachment trial?
As a litigator, in the case of the defense, and I've said this many times, they have no choice. They have no choice. They started, you know why? We are not using the judicial affidavit rule.
Right.
If we were using the judicial affidavit rule, before the witness goes there, the testimony is already given to you. That's what the judicial affidavit is, the direct testimony.
That's meant to expedite the trial,
Well,
right?
that's meant to expedite the trial. But you see, when you see it, you can instantly say, all right, this witness, the testimony is admitted. Finished. You can't do that here. Or you can, but it takes braggadocio.
Jed, tatanungin kita.
What I was going to say,
Okay.
one last thing. What they could have done is on day one, first thing, Your Honor, we admit the facts being established by the prosecution for this article. Let's go to the next one. Tapos.
May tanong ko sa'yo, Jed. You're talking about the Filipino people as an audience.
Yeah.
Hindi nagtatagalog yung mga abogado.
Yun nga.
That's up to them.
I think that was
That's
a
up to them.
discussion
That's
before,
tricky.
di ba? Na dapat Tagalog.
That's tricky because it's not very easy to translate,
That's
di ba? Even us, di ba? We get bullied.
And we don't
when
conduct
try.
trials in Filipino. di ba?
But you know, if you're in and out of court, you will have witnesses who don't speak English.
Right.
Right? And so even I practice that when I'm in
Ay,
litigation.
hindi ka talaga marunong Tagalog. I've
It's
never heard you speak Tagalog.
Correct, but now I do it all the time, no? And when I'm in court and the witness is more comfortable in Tagalog, I try to speak in the Tagalog. The court gets mad.
Ah, really?
Yes.
The judge.
Don't do that. You speak in English, and the translator will take care of it. So the
Translate,
official
yes.
translation, di ba? Because mahirap pala mag-steno sa Tagalog.
Oo nga.
Apparently, that's a problem. But you see, I
May
don't
mga
like
apps
that.
na ngayon.
I don't like that also because I'm not sure that the translation will will register the way I want it
Yeah.
to. Yung
It may
speaking
have a
Tagalog,
different interpretation.
yes, and all that. And
Oo.
sometimes the words are particular. But here, that's not the case. Here, we want to put everything out for the public to appreciate. In this article, the defense really has its one arm tied behind its back. Wala kang laban eh. Di ba? Everything's out there. We've known this for gas-gas na nga yan eh.
Correct.
Oh,
Yung
but
video.
now, if you take it to the floor pa, you keep just replaying the thing.
Yeah.
How does that help you?
It has been repeated so many times.
Too many times. And all the...
Is that to the
and all
advantage of the prosecution or the... Is that the
advantage of the
Prosecution, I
prosecution?
guess, yeah.
You cannot win this article. You're done here.
It's too obvious.
Yeah, you're done here. What you should have done, personally, what I would have done, admit that, don't let any of the witnesses get on the stand, ask for oral argument. Next article.
Yeah.
Then oral argument na lang tayo,
I think that's
di ba?
what they're doing now, di ba?
Well,
Kaya
yeah, but
two
you
of the
see,
witnesses are not on
Wala na.
air.
No, because even the prosecution knows it's already overkill. Ligutan has already done his job, and congratulations to him and the prosecution. But then, as I said, this is a walk in the park. How can you drop the ball on this article, di ba?
there's a concern that there's always a concern. What is the effect of the absence of VP Sara in the hearing?
I find it sad that that's the case. Me, if I were in the defense, I would have insisted, you go. I don't care what it is.
Well,
You
but
go,
do you
you
think-
dress up in your best Sunday outfit, and we've seen her. She can be very charming, di ba?
I think there's a risk kasi, di ba?
Well,
Edwin, if she comes there and she cannot control her emotions, it might, backfire on her.
Go with somebody who can keep you calm. You don't have to stay the full course. Like she should have
At
gone.
least just show up.
She should have gone opening day. Listen to the opening statements. Wear earplugs if you have to. I don't care.
So you're
Show up
saying that
there,
she doesn't have to
look-
be on trial?
No. She just go there
Just
as
show
a
up.
guest. Yeah. Look, and your senator friends will protect you. The senators who like you will protect. The Senate will make sure that you are not going to be treated badly.
Chief Justice
Definitely.
Corona present on
If I
every day?
recall correctly, he
Yeah.
was.
I think he was.
And that was
yeah.
your advice?
Yes.
Yeah,
No, that
yeah.
was the team's advice. Go there. You're the Chief Justice. My goodness, you have faith in the process, and that was his thinking too.
Yeah.
Faith in the process.
If you know, what can you speculate on the reason why she doesn't want to appear?
Well, I guess it's a management issue for the defense. They're not
Okay.
sure what the reaction will be. When you handle high-profile clients, you're always careful. Like, do you want your client out in the public, living a normal life like nothing's wrong? And what if people start to boo them? Right there, di ba? You don't want them to go through that experience because you don't want them to feel demoralized. Di ba? And I tell you, during the impeachment, that has happened to me. There's people who didn't like Corona or
booed you?
oh yeah, I was walking in the grocery in shorts of all things, di ba? And I said, the guy, it's an old elderly gentleman with his umbrella pa, pointing to me. You're that lawyer on TV. I said, yes, good morning. I was trying to be friendly. How dare you, man? I hid behind the fruits, my
I
goodness.
can imagine. And ngayon pa naman, it's too extreme, no? It's either you really hate her or you love her.
Well, as your good friend, your good friend, Mr. Llama says, it's an existential battle. All right, there are many political implications
That's true.
both ways.
Did you notice that there were so many objections right now, and so many objections from the defense side?
Yes.
And how do you decide when to object, or when to remain silent, and when to let
Like
it
I
go?
said, Edwin, this is a no-win case. It's like you're being forced into a one-way street and there's a dead end.
So if it's a no-win, so if it's a no-win article for the defense, are they doing the right thing, objecting a lot? Or?
Well, yeah, why not? Because they're trying to contextualize the article and say this only happened because she was
It's
victim
conditional.
of injustice, under threat, never got any, and it was a systematic persecution. Parang ganun. Systematic persecution. Even the NBI investigation was sloppy. But like I said, if that had all been considered and you had a tough honcho heading it, let's just admit that article and move to the next one. Wala tayong laban dyan eh.
But
diba?
as you said, they're trying to contextualize
Yes.
it. So
Yes.
I think it's also important, no,
But-
to make the public know why is she, why
yes.
did she react that way?
Okay, really. But what does that do for you? Diba? Because the ultimate question is, have we ever seen a vice president anywhere in the world?
It doesn't justify.
Anywhere in history? Yes, with this.
You know, I have a question. You said, let's just admit the first article.
Sure.
But if you admitted the... Ano,
Yun
no,
na.
no.
You
Impeachable
admit the
na yan.
facts. You admit the facts. But what your admission will be, parang demurrer. Diba? I admit what you're saying without admitting liability. Demurrer. So let's be clear. We deny that this is impeachable. But all the facts, the video, we admit that it exists. The investigation, we admit it took place. Ano pa? We admit. Kasi, di ba?
Para tapos na, hindi
Yeah,
pa
wala
kita
na.
sa publiko.
Then,
Move
let's
on.
play the video. Wala na, tapos na.
Admitted na.
Admitted na di ba? May we request instead for oral argument, which we feel might be more helpful to the court. Then you could have just gotten into that. Can we have 2 days? Break. You write it in Tagalog, bang.
So how do you protect by your client, attorney? When do you think they should speak or not, or to hide? Or
Really, I wish I knew. Personally, my philosophy in litigation is preparation is key. No matter what your client has done, preparation is key. Okay? If the client is intelligent, calm, well composed, and you properly prepared, that is the strongest thing. Di ba? Avoidance is always scary. Now, when it was during the impeachment, we got into a big discussion about what to say, what to do, etc. Blah, blah, blah. It was the Chief Justice himself who said, no, I want to testify.
Okay. Let me ask you, why do you think did the prosecution drop Attorney Zuleika Lopez, the VP Sara, Chief of Staff of VP Sara, and Captain Belio, Executive Director of the House Legislative Security Break? But before you answer that, the spokes will return after this short break.
the spokes is back still with us. Is Dean Judd. Jude.
Judd.
No, don't do that.
I'm so sorry.
Hey,
Okay. So again, our hanging question, Dean Judd.
Yeah.
Why do you think did the prosecution drop witnesses Attorney Zuleika Lopez and Captain
Yes.
Belinda Bello?
Do you
What
drive?
think?
Do you drive?
I do.
Do you drive? You drive, no?
Yes.
Have
Secret.
either of you driven? Have either of you driven a race car?
No.
Fast, okay.
no.
Have you? Okay. This is the prosecution. They're like driving a race car. Bam! Right. Diba? And they've smoked the opposition. They're far away, far ahead. Right. So now the engine is maxed out. You want to step on it some more? What for?
Yeah.
You've scored the points. In fact,
Yeah, makes sense.
Zuleika is a slippery slope, right? They're so confident they could have presented her.
But she will be treated as a hostile witness.
Right, and
diba?
she would have testified in favor of the defense to strengthen
Most likely,
the
that's just
context,
should be
the
the
context
assumption.
theory. But it's already there's no point in doing that because it's already clear to the public what's at stake. And I think the prevailing conventional wisdom is kahit gaano ka kagalit, tama ba yun? The president is, if there's one individual that the government tries to keep safe, it's this guy, right? So why are you going to say, I'm going to kill you and then cuss him out and his wife? Hindi lang ikaw, your wife, your cousin, you know. So that's the thing. Eh.
So they made the right call.
Yeah, and besides, you might overdo it. Eh.
Okay.
They'll get tired of it.
And they're saying that one of the biggest factor why VP Sara reacted that way, it's also because of what happened with the Chief of Staff,
Sure,
Attorney Zuleika.
sure.
Yeah. So, okay, we have questions from our live viewers. Bong Sanchez, a comment niya, nakakainip po ang impeachment. Di po ba pwedeng bilisan na? Sinusubaybayan naman namin pero ang bagal ng pacing.
Actually, mabagal yung pacing because we don't have nga that judicial affidavit rule.
Right.
But if we had that, you won't enjoy it.
Yeah, you won't enjoy it.
You won't enjoy it. So,
So
it's okay na yan.
You won't enjoy it because it would be very highly technical?
Kasi admitted.
Admit na, okay.
And you won't know what the story is.
Hindi mo alam ang story.
Hindi siya
Cross-examination lang.
mako-contextualize.
Cross-examination lang abutin mo, di ba? Hindi mo makikita yung mga objection. Yung, as I always say, and if you've been in trial, yung direct testimony when the prosecution, that is the most difficult. It's not the cross-examination. Cross-examination is easy. It is direct testimony that is the most difficult. It's open to so many objections.
Edwin, yeah, another live viewer comment. Corruptionary?
Suki natin yan.
Jodoy didn't join the defense because he knew there's an overwhelming evidence against VP Sara. It's suicide.
Yes and no. It's also a question of, let me put it this way. When I joined the Corona defense team, it's because I wanted to join. Okay? I was chief of staff of former Chief Justice Narvasa, and I went to him to seek guidance. I said, "What do you want?" He said, "I visited them during his siesta hours." I said, "I came to ask your permission. Why? I'm being invited to join the defense of Chief Justice Corona." And he said, "So why are you asking me?" "Well, you might not feel..." Anyway, I can't disclose the reason why. But anyway, he said, "Yeah, you go there. You go there, you get my office back, and you give them hell." That's exactly what he told me, and that's exactly what I tried to do.
Just to clarify lang, hindi umiiwas sa laban si Jad Roy, no? So, kaya hindi yan dahil sa malakas na ebidensya. Kahit malakas na ebidensya, lalaban pa rin si Jad.
Alam mo, parang narinig ko yan kay Lorna Kapunan kanina sa interview niya.
But that was, for us, it was, like in many ways, they say this is an existential political battle. For us, it was an existential battle between the departments. This was and here, remember, the accuser was Pinoy himself against the Chief Justice. It was shocking to the judiciary. Well, to everyone, I think.
Sige, really.
Okay, we have another comment from our viewer, Romel Balaton. How much are we spending on this impeachment? Government priorities are not efficient. Oo nga naman, no? Hindi natin yan napapag-usapan, pero we're really spending for this. Diba?
Well, I remember I'm being asked about it, and I think Ping Lacson put a number on 25 million a day for the Senate to operate.
Okay.
Oo, kasi nung merong leadership crisis
so
sa
that's
Senate.
Little over 1 million per hour. Kasi pati yung pagtulog noon, kasama yung bayad doon. So, every objection of ligutan and every objection of biluan can be quantified. I think, remember the thing, they were given 4 minutes each. So how much is that in pesos?
And we're looking at 9 months, di ba? Yan ang duration nito, di ba? 9 months, more or less.
Kung hindi sila
Imagine how much would that
mag-isip.
cost.
I'm really worried about the next segments because these are document-driven
You're worried
articles.
for the prosecution
For
or
the
for
whole,
defense?
everybody. Can you imagine if nobody wants to watch anymore? What do we do now?
Sige, tingnan natin kung manonood pa rin.
Kung maiinip na masyado yung mga tao.
Sige.
Again, another one from our live viewer. Purples and Roses. Kudos to the prosecution for realizing that there was no need for Attorney Zulaika and Captain Bello.
Yeah, good call. Useless na. It's just, everybody's, enough. Stop eating pork. Let's move on.
There was a survey recently that the prosecution is a bit ahead of in comparison to the defense, no. And number two, I saw from Senator Frank Dillon that the prosecution is doing better than the defense. Do you agree with this assessment?
Way ahead.
Way ahead?
I think so.
Why way ahead?
Because the article alone is a lot in their favor.
Okay.
Okay. So, but to the credit of the defense, if you were watching carefully, first day, second day, the change and the shift and the adjustment was quite quick. So I expect to see even more improved reaction time from the defense.
And I think that was a good decision na inuna nila tong article na to talaga.
It's all right. Yeah.
So who do you think had the upper hand? As you said, in the past days, it was the prosecution. But what surprised you the most about the ongoing
whole thing?
impeachment, the whole thing, yeah. Is there anything that surprised you, or the
Well,
strategy of the,
well,
defense, for example?
The time surprised me. It took took long. I found it long.
The cross-examination of Bilyonaryo?
Both sides. Too long. Prosecution
And that's just
presentation
the
too long.
feedback also.
Yesterday they were talking about the affidavits and the subpoena, and they hadn't been properly marked. They were still arguing about it's a photocopy. That should have been finished already in the pre-trial. You know, you don't quibble over those little things.
But maybe that's where the technicalities come in if you're mahina sa facts. Hindi na inadmit eh.
There are no
Or is it a strategy to prolong,
There
to
are no
delay?
veteran impeachment lawyers on the floor. If there were, the temperature would be different.
Ojo is there. Attorney Nervasa.
I don't know
For the defense,
I don't
you're
know
saying?
I think
He was in the era of impeachment.
He was in the era of impeachment, but the guy who handles the operations at that time was Sig.
Sig, yeah.
Yes.
Sigrid Fortun.
My good friend Sig. I don't know how busy Sig has been with this team, but you know they're all young bucks, di ba? So and on the prosecution, wala ring.
Si Lorna is the
impeachment lawyer.
most senior.
Lorna is the most senior, but Lorna is guns blazing. She's your old associate.
She's
di ba?
my boss before.
Oh, there you go. Tita Lorna. What a character. One of my favorites for sure.
They needed someone like that.
Yeah.
Dapat sa defense kinuha siya eh.
Sure. Well,
Yeah.
the defense, if I were the client, I would be pleased. You can see them there fighting with whatever it is, no? Whether the people like it or not, in fairness to the defense, regardless of the social media reaction, they're just doing the thing. And if I were the client, and as a litigant, that's the best you can do. Of course, if you had just admitted it in the beginning, the client would probably have a heart attack. How could you do that? Because you wouldn't understand the strategy behind a tactic like that. That's not, even in regular, it's not commonly seen. Oh, redirect or no cross. That's not common. That takes real guts to do that. The guy there testifies for 2 or 3 hours and no cross, Your Honor. See? So it takes some real imagination and courage to pull off a stunt like that.
Yeah. So what do you think in these next few days of the impeachment trial? What should the Filipinos watch for closely?
I hope that both sides agree to expedite it. Maybe what they can do is admit. Let's talk about. I'm not sure which one is going to be next, but let's talk about the confidential funds, the Piatos stuff, diba?
The BIR documents?
The BIR documents. That one, that is a mystery box. I don't know what surprises are there.
But that's your second envelope also.
Well, maybe, there was nothing in it, remember?
Exactly.
Remember? But what I'm saying is, in the Piatos issue, that thing, that has already gotten out a lot, right? So, why don't they already agree, how do you say it? Those that aren't controversial, the non-controversial one, just admit them, that they were existent, that they are, etc., they were signed, etc. And let's just focus on these documents which have the funny names. I think there's a joke, no pa there.
You mentioned a while ago that you're thinking that sa BIR and all that, those are documented, it will be boring.
It might be.
If you were the prosecution, how would you make it exciting?
Well, we don't know kasi what the BIR box contains. No?
But the bank secrecy, for instance.
Well, then I'd point out, I'd highlight all the transactions, like what happened to Corona. They pulled up his AMLA records and they said he had 87 or 90 cases.
But remember, Jed, even if there was a bank exception in the bank secrecy, they still had to argue that you were trying to stop it from...
Yes, of course. Because Corona believed in the bank secrecy. In fact, there's a dichotomy there. When it's foreign exchange, you cannot inquire.
Right.
And then we were trying to stop PS Bank Remember, they
And
got
you won.
they got a TRO, right?
Yes, you got a
But
TRO.
it still got into the floor because
No, but
the
for the
little
da-
lady delivered it to the gate
No,
of
wait.
somebody. Edwin, have you met the little lady?
No, wait, for the dollar deposits, you won.
Yes, yes,
But
that
for
was
the
close.
peso deposit, there was a exception to the
Yes,
bank secrecy law.
no, we also got the TRO because PS Bank they were subpoenaed.
Right.
But the AMLAC was allowed, and remember, Carpio Morales
yes,
testified. Now, what we weren't clear about at the time, because the AMLAC was still a new entity, we should have called the bank investigator.
I have this is a very controversial question.
Sure.
Because on the bank secrecy deposits, it appears that it was only covering the bank deposits of the impeachable officer.
Right.
Would that also include the deposits of his spouse?
Now it should.
Now it should.
Unless
Why are you saying it should?
Because
And
of
now,
the
just now?
conjugal property rule, conjugal
Okay.
regime. Unless the initial defense is separation of property, prenuptial agreement, blah blah blah, or judicial decree of separation of property. Then, okay. But still, if you look at the graft and corruption law, di ba, yung close relatives,
Right.
immediately you're suspected by the fact of marriage.
So you're looking at the entire laws, anti-graft, SAL, and that's why you're saying that the bank secrecy deposit should also include not just VP Sara, but also
The spouses
spouse.
and the children.
And the children.
Yes, of course, because their children are minors, no? But that's not always
Okay.
going to be the case. Remember, in the case of Secretary Bonoan, there's a story that he put up a corporation and his
Right.
daughters were there.
And
Money
the
was
wife,
funneled
yes.
through. Yes, all
That's
of
right.
that.
Mm-mm.
Diba?
May I ask you, why not ask you
Sure.
this? What's going to happen? What is it for the Filipino people after the impeachment? We were talking earlier about US and China.
Oh.
Now, they were saying about the policies of the Duterte, and that's the reason why some would really argue that they don't want Sara Duterte to be the president.
This woman is going to get me shot, I swear. Anyway, well, this could also be viewed in that context. No? It's a U.S. versus China dichotomy or existential battle,
Right,
as
right.
Mr.
Yeah.
Llamas likes to say, meaning the Marcos administration representing our allegiance and alliance, not allegiance, alliance with the U.S., and Vice President Duterte, who the Duterte family is known to be very open to the overtures of China. And so, in fact, there's some concern. The reason that they want to make sure that President Marcos finishes his term, because if anything happens to him, then Vice President Sara becomes the president. She doesn't have to kill him anymore, like her threats, but if she becomes president, then the foreign policy shifts.
Right.
And you can imagine, you were saying this has a lot of impact on business, commerce, and all of that. Now, here's the question. If it's so important to stop VP Sara or to keep President Marcos there because we want to block China, what happens when you take her out in the impeachment?
Yeah.
What happens now if she's gone?
Oh, really?
Okay, so tough question. Let's assume you are you're leading VP Sara's defense team. What would you change in the current legal strategy? Is there anything that you would
Yes.
advise them? You were advising them earlier already.
Yes.
But
Well, like I said, physical and visual preparation. Mr. Villanueva handles himself well. I would tone down the
Less
rhetoric.
aggressive.
Yeah, less technical. I would tell the team, relax, just let it come in. If our defense is solid and tight, then it's okay. Remember, this is
but
about
that is if.
this is about persuasion. Okay, it's also about persuading your friendly senators to stay friendly. Now, that's not as easy as it seems because I know, and don't ask me how, during the Corona impeachment, we had it at 13 when we started. We had 13 for Corona when it began. At the end, there were only 3 left, one of whom was BBM. Remember?
Yeah.
BBM, Joker, and Miriam, the 3 of them.
Let's the next tough questions. Let's flip the coin. If you're leading the prosecution, what would you have changed differently?
Oh,
Strategy?
very little. The same. Doing the job is okay. I just asked Mr. Liguta not to say "Your Honor, please" so often. But I'm just kidding. Virgil's a very nice fellow. But sometimes when you're on the floor, you need phrases to give you time to think about the next phrase. So these things are you know what I mean?
Yeah,
When
yeah.
you're speaking extempore, from the heart.
Yeah. And again, the main difference also here is that you're talking to the social media audience.
Yes.
Not just the traditional. No?
The prosecution has a built-in advantage because these scandals, these issues, these articles were scandals in the news. So people are somewhat familiar. And the unfortunate thing is the VP has always evaded. So going into the trial, that's the image painted of the VP. He never answered, evasive, etc. So people it could work to your advantage because people are eager to hear, lay it on me now, baby. Di ba?
Ikaw na.
Okay, so last tough question. As a constitutional lawyer, do you think that it is time for the Supreme Court to definitely rule on the constitutional base of the 16-vote threshold? Napag-usapan na nila to sa Senate eh. Why does it really have to elevate again?
It always bothers me when well, it doesn't bother me, but I find it surprising when lawyers say, "Oh, well, let's bring it to the Supreme Court. Let's bring it to the Supreme Court." Yeah, well, you can let's bring everything to the Supreme Court. What do we name our next child? Let's ask the Supreme Court so we don't make a mistake. Is it time? The Supreme Court, time does not exist in the Supreme Court. I have a case that's going on 42 years. That's because the government, I've beaten the government, they refuse to pay. They keep going up. They want to go up to the Supreme Court for the third time. Started in 1984. Now, the Supreme Court is not the place when you're in a hurry. You got a trial waiting. What the Senate should do is take a position and go.
Judge, have any last words for us, for the prosecution, for the defense, for the senators?
I wish all of you good luck. I hope.
Are you glad that you're not part of any of the teams?
Yes, truly yes, because it is back-breaking work. Napakahirap yan. I tell you, there is no rest. Those guys now, they don't sleep well, especially the guy on the floor. The prosecutor is always lucky because it's a huge team. It's always huge. But in the defense...
And they have the congressmen backing them up as well.
They have the congressmen and all. Imagine, each congressman brings lang his staff.
Right.
See? Tiga-bili man lang nung pagkain mo, completos, ricados. What's my last word for them? Please take good care. Think carefully. I know that political lines are very clear and the people see that. But each of you, and now I dare speak to the senators, each of you has an opportunity to rise above whatever it is people think of you and show them what you're really made of. Loyalty is not always key.
Yeah, especially our young lawyers, no? Okay, thank you so much, Dean Jod Roy.
You're welcome.
Thank you.
Thank you for having me.
Thank you very much, Judge.
Nice reunion, Edwin.
As Bilyonaryo News Channel expands its reach in Central Luzon, the delayed telecast of the spokes can now be seen at CLTV from 5 p.m. to 6 p.m. just before agenda. I'm former Secretary Edwin Lasherda.
See you, CLTV Central Luzon. I'm former Secretary Relly Fajardo, and we are the Spokes.
Fiction and not a fact. That's how Vice President Sara Duterte describes allegations she made grave threats against the first couple and former House Speaker Martin Romualdez. Today's impeachment trial centered on the so-called Oplan Romanov, which the defense is using to justify Duterte's controversial remarks. What impact could these arguments have on the course of the proceedings? Let's get on point with House Lead Prosecutor, Congresswoman Jervil Jinky Luistro, who joins us live from the Senate. Congresswoman, good to have you again. Welcome to the show, and always thank you for your time, ma'am.
Good evening, Pinky, and good evening to all our viewers and followers.
Congresswoman Jinky, I was just watching the last minutes of what is happening in the Senate right now before we went on air, and maybe to apprise our viewers right now and myself. Attorney Lorna Capunan was actually saying that hindi na po ipepresent si Attorney Zulaika Lopez. Please tell us more about this.
That is correct, Pinky. At merong tatlong bagay na in-emphasize si Attorney Capunan, no? That includes to avoid redundancy, unnecessary, and repetition, no? So, surplusage, no? To correct. So, that is the reasons, or those are the reasons why we are doing away now with presenting subpoenaed witness Attorney Zulaika Lopez as well as Captain Bello, no? We believe na yung sasabihin ni Attorney Zulaika Lopez at ni Captain Bello ay na-cover na ng testimony ni Agent Calilong as well as Attorney Lotok, and as a matter of fact, they were even admitted by the Defense Counsel, no? So, ulitin ko, Pinky, yun, ha? The reasons are, they are unnecessary, they are surplusage, and they are redundancy. So, these are the reasons. And ultimately, we want to spare the court with wasting its time so that we can focus and dedicate the same to other witnesses who will be presented by the prosecution.
But that particular decision coming from the public and the private prosecutors, I'm sorry, apologies, ma'am, because I missed parts of it because I was also on air. Ang narinig ko po sinabi ni Attorney Capunan, nagkaroon po kayo ng, she used actually two words, huddle and hurdle. Can you tell us more about that, please?
Well, we've been observing the testimony of Agent Calilong as well as the testimony of Attorney Lotok, no? And ultimately, this afternoon, we were able to resolve with finality that if we will be presenting Attorney Zulaika as well as Captain Bello, it will be a repetition already of what was testified to by the first two witnesses. And that includes the admission of Attorney Villuan na paulit-ulit sinasabi kanina ni Attorney Capunan, no? Kasi there are only few things na kailangang sabihin sana nitong dalawang witnesses na to. And that includes nandun sila sa loob ng detention center and they personally witnessed the Vice President utter those words of threat against the President, the First Lady, and the former Speaker, no? And it appears to us, it was witnessed actually by the public, na na-cover ito ng testimony ng ating dalawang agents from NBI, and na-cover na rin siya repeatedly by the admissions of the defense during their cross-examination and even during recross-examination, no? So to us, Pinky, no, kung aming isasalang pa itong dalawang ito, it will be a waste of time of the court because it is actually a repetition already. Uulitin na lang ang na-cover na ng mga naunang testigo. Surplus age na siya or kalabisan sapagkat na-establish na yung gusto naming ma-establish from these two witnesses. And it will be a redundancy or unnecessary. Redundancy, paulit-ulit, unnecessary, hindi na kailangan, no? We would like to focus to other witnesses, other evidence na may ibang established aside from those na nasabi na ng dalawang naunang testigo.
I understand, of course, that a process like that is definitely up to the prosecution or even the defense when their turn comes. We had an interview a couple of weeks ago, ma'am, and sabi mo nga meron kayong I think now 57 witnesses. And at any given time, you're able to reduce, subtract any of the witnesses if necessary. And in fact, meron din yung tinatawag nga that I learned from you, yung reserved witness that you are given now. What we talked about then was 3 days, but hearing from the presiding officer, I think the agreement was 5 days. But when did you decide not to call as a hostile witness si Attorney Zuleika Lopez? I'm assuming it was just today, but specifically around what time, ma'am?
Well, just today, just after the conclusion of the testimony of Attorney Lotok. Although admittedly, since yesterday, we've been considering ang ganda na ng testimony ni Attorney Lotok. Halos kompleto na, but the final decision only came after the conclusion of the testimony of Attorney Lotok. To be specific, that was after recross examination, no? While admittedly, since kahapon, pinag-aaralan na talaga namin yan, and we became more convinced with his testimony today to dispense with the testimony of these two witnesses.
And there is no, was there any concern that because we understand that Attorney Zuleika Lopez would be a hostile witness, that it could possibly, just possibly be detrimental to the prosecution? Of course, I understand, ma'am, na pinaghandaan niyo to. Pero being a hostile witness, sabi nga ng interview kanina dito po sa BNC kay Corina at kay Willard, tricky po kasi din talaga ang hostile witness. Did it have anything to do with that?
We acknowledge that, Picky, but of course, kamukha ng sinabi mo kanina, it depends on the exigency of the trial, no? Naging observation namin na kompleto na yung gusto naming ma-establish from the testimony of the first two witnesses, and that is the ultimate reason why we are dispensing with the testimony of these two witnesses. And I wish to take note, hindi lang testimonya ni Attorney Zuleika ang dinidispense ng prosecution. It even includes our witness, Captain Bello, no? Dalawa sila na dinidispense na namin tonight, no? For the reason na na-establish na at magiging repetition na lang kung i-present pa sila.
For the benefit of those who do not know what the testimony of Captain Bello would be, please give us the explanation. Ano ho bang ite-testify ni Captain Bello?
Well, Captain Bello was the LSB official of the House of Representatives, no? Who served the transfer order to Attorney Zuleika Lopez, no? Nung ililipat sana siya sa hospital while the Vice President was inside the detention center, no? She's supposed to tell the court na nakita niya nandun ang Vice President at nakita din niya si Attorney Zuleika Lopez. These are the circumstances surrounding the video conferencing where the Vice President uttered the words of threat against the President, the First Lady, and the former Speaker.
Congresswoman Jinky, so who's next? What happens now tomorrow?
Well, tomorrow I understand na nakaschedule ang oral argument. This is about the preterm evidence or documents pertaining to AMLAC, BIR, and even the bank documents, no? The issue here is whether or not those documents which pertain to acts or omissions prior to 2022, when the respondent became an impeachable official, are relevant to this impeachment trial.
Ibig sabihin ho ba na magkakaroon ng oral arguments ang magkabilang kampo para patunayan na kailangan o hindi dapat isama yung mga records ng mga bangko ni Vice President bago po siya maging Vice Presidente? Did I understand that right, ma'am?
That is correct, Pinky, no? But it does not pertain only to the bank documents. It pertains as well to SALN.
Right.
It pertains also to BIR documents, the ITR, no? And the AMLAC documents, no? So ang issue dito, you are correct when you said, no? Kompletohin lang natin yung documents which are concerned in this particular issue. Kung ito bang mga dokumentong ito which are prior to 2022, when the respondent became an impeachable official, are relevant in this impeachment trial, no? Of course, the position of the prosecution is they are relevant.
And with that oral argument coming from both the prosecution and the defense, what happens after? Is that going to be a decision that will be put forward to the senator judges to vote upon if indeed pwedeng isama o hindi?
Well, actually, before I came here, no, the senator judges were discussing whether they will be voting tomorrow immediately after the oral argument, or they will be given additional time to be able to make their position on the matter. And the last thing I heard from Senator Judge Alan Cayetano is like he's requesting for a caucus, no, about the subject matter to be debated upon tomorrow by the prosecution and the defense.
Fair enough, because you had to go to our live point to be able to speak to us tonight. So we thank you for that. So tomorrow is actually going to be also, not that the other days were less important, but this is a shift now, because are you saying na tapos na po ang issue on grave threats?
Well, we still have one witness, no? And I don't know if there will be additional witnesses pa after this one. The last witness I'm pertaining to as of now is Attorney Melvin Matibag, our NBI director, no? I understand that we have reservations, so we haven't discussed whether Attorney Melvin will be the last or whether there will be additional witnesses pa, anchored under the reservation to present additional witnesses or evidence in support of the threat article.
Just to understand it before we go on a break, ma'am, so bakit po bukas yung oral arguments on the can you include AMLAC, BIR, and other pertinent documents prior to the assumption of Sara Duterte as Vice President? Why are we jumping?
What I understand, why the reason, Pinky, is we have pending motion for issuance of subpoena. We have pending request for issuance of subpoena of these documents, including those prior to 2022. No? Itong documents na to, that includes bank documents, that includes the AMLAC documents, that includes the BIR documents. No? Parang hindi naman kasama yung SALN. Parang we have them already. No? So for these three documents, they include those prior to 2022, and that is why I believe the impeachment court deemed it proper to set the oral argument tomorrow before they decide on the request of the prosecution for the issuance of this subpoena.
We'll be taking a very short break. We'll continue our discussion with Congresswoman Jervil Jinky Luistro when we return. Stay tuned. This is On Point. Welcome back. Still with us, House Lead Prosecutor Congresswoman Jervil Jinky Luistro. Congresswoman, so sino pong mag-opening statement for the prosecution bukas?
It will be Congressman Chel Jokno. Of course, we understand. He has been with the academe for so long. He has been a seasoned litigation lawyer, no? As a matter of fact, decano siya, Dean of the College of Law, before he was elected as member of the House of Representatives. So we are very much confident and positive about his engagement to represent the prosecution in this debate regarding the relevancy of the documents prior to 2022 in this impeachment trial.
Let me ask you this, Congresswoman. What kind of an effect would a possible vote by the senator judges, if it comes to that nga, tungkol po dito sa pertinent documents, that they decide that prior to 2022 is unnecessary, which means, I guess that would be a, not a loss, but you don't, I mean, you wouldn't call that victorious on your end, hindi ho ba? Kasi gusto nyo isama yung prior to 2022. Malaking epekto ho ba yan sa pagsusuri o sa debate or proving the point of unexplained wealth kung hindi po masama yung prior to 2022?
Without dwelling on the merits, no? Pinky, and without reference to this particular impeachment trial, but by allowing the documents pertaining to acts or omissions prior to the time when the public official became an impeachable official will provide a clear picture of what happened. And by clear picture, it will provide the source, it will provide retention, ownership, control, no, and accumulation. As a matter of fact, without reference to this particular impeachment trial, if it is proven that what was acquired as ill-gotten prior to becoming an impeachable official is still retained by the public official, then there is a continuing violation of the law. At the very least, RA 3019 or perhaps the plunder law, or even 6713, the law pertaining to the ethical standards of public officials and employees, no? And I wish to point out as well that with respect to the constitutional provision on accountability, particularly Section 2 of Article 11, ang binanggit lang naman doon, who are the impeachable officials? Ang binanggit din lang doon, what are the grounds for impeachment? But the Constitution never provide with respect to the timeline regarding the date of commission, omission or commission of act that constitutes an impeachable offense, no? Sabi sa Section 2, Article 11, the impeachable officials are as follows: President, Vice President, members of the Constitutional Commission, and then the justices of the Supreme Court, the Ombudsman, no? And then they made mention also about the grounds. Kasama dun yung mga culpable violation of the Constitution. Treason, bribery, graft and corruption, betrayal of public trust, and other high crimes. But nowhere will you see the timeline as to the commission of the act, as to whether it should be committed prior to or during the time that the public official is an impeachable official. Walang binanggit ang Constitution doon, no? And that is very clear. That is without specific reference to the subject matter of this impeachment trial.
I actually remember two things after you said that. I understand that you weren't referencing it to the issue now. So let me reference it to the impeachment proceedings trials in the past. During the Corona impeachment trial, I do need to research on this, just to be very frank, and look back again. But were there references prior to the Chief Justice on his SAL-N that were used before he became Chief Justice? Number two, also with former President Joseph Estrada, were there also references used that the court admitted prior to him becoming president?
Yeah, that is correct. Meron. As a matter of fact, we can invoke legislative precedents, no? Sapagkat merong mga incidents na pinag-usapan during the trial which are prior to becoming the impeachable official. We can include, as a matter of fact, Pinky, yung kaso ni Justice Sereno naman, where the basis for the grant of a co-warrant of proceeding ay yung failure niya na i-disclose yung kanyang salary as a UP professor, which was during the time, long before she became a member of the Supreme Court, right? No? So, ang point doon, without, again, particular reference to this impeachment trial, no? Kung yung prior conduct ay ginagamit as basis of disqualification, just like what happened to Justice Sereno, then it must be considered as well in removing impeachable public official.
And siguro para mabalikan lang yung kay Justice Sereno, Congresswoman, hindi po kasi natuloy yung impeachment proceedings laban sa kanya.
I understand.
Hindi po ba? Well, just
I understand.
making it clear, except yung, of course, ang natuloy po yung kay Chief Justice Corona rather, and former President Joseph Estrada. I mean, it's you know, we have to look back at all the impeachment proceedings that happened in the past. So now that will be the case, it will be still up to the senator judges to decide on this. Now, I want to go back to some of the highlights of what happened today, which is really part of my questioning. Dahil nagulat din po ako, I was surprised with the turn of events towards the last part of of the impeachment day. Anong araw na ho ba to? 1, 2, 3, day 5. Alright. Ma'am, ang sinabi niyo po kanina, maganda na po kasi yung testimony ni Attorney Lotoc at ni Senior Agent Calilong. Now,
Perhaps hindi lang siguro maganda kung hindi kompleto na.
Kompleto.
And the supposed offer of testimony for Attorney Zulaika and Captain Bello were served already in the testimony of Agent Calilong and Attorney Lotoc.
okay. Having said that, ma'am, yung pong kanina, some of the points that I wrote down, yung tinanong po kasi itong grave threats, because of course, ito naman po yung pinag-uusapan the past days. Attorney Binluan, when asked, said the defense was saying it wasn't a threat in the first place. Ang sabi po niya, it was a mere response to a Q&A and it was never aimed directly to BBM, the First Lady, and the former speaker. Yun po yung kanyang sinabi. I forget who asked that question. Could have been Senator Judge Pia Cayetano. But do you remember that, ma'am?
Yeah, but our position has always been res ipsa loquitur, no? I do not want to dwell really too much on the merits of the case, but ever since ang position ng prosecution dyan is res ipsa loquitur, and those utterances constitute an impeachable offense.
Can we talk about, though, are you allowed, please forgive me if you are not allowed, are you allowed to even comment on some of the seeming flaws that the defense were highlighting during the questioning, the cross-examination po kay Attorney Binluan, yung pong mga typographical errors and even the mismatch of the dates?
I don't know really how my fellow prosecutors are addressing the questions, no? But under the sub judice rule, and we were reminded as well by the presiding officer during the first day of the trial, we're not supposed to comment on the
Okay.
on the merits of this impeachment trial, no? And that is why I've been very, very restrictive in providing
I
answers
understand.
to your questions, no?
Apo.
But nevertheless, about the inconsistencies, discrepancies, without again specific reference to the subject matter of this impeachment trial, as to whether it will affect the theory of our case, it depends if it is significant or not. Our position is they are not significant.
It was also Attorney Lotto who said that the grave threats were real and actual. I think that's what he said yesterday. All right. So it's day 5. Bukas po ay day 6. Equally, I'm sure interesting, especially because of this oral argument on documents, BIR files, etc. Last question, ma'am. What happens to that BIR box? Does that mean that if the vote becomes favorable to the prosecution, does it necessarily mean that the BIR box can be opened?
Okay, so to update the viewing public, no, the BIR box was returned already by the impeachment court to the BIR, no? But I wish to share as well that part of the request for issuance of subpoena is an expanded list for BIR documents, no? And that is supposed to include what we believe are inside this BIR box, no? So we hope that we will be able to get the favorable judgment of the impeachment court with respect to the debate which will happen tomorrow, because doon nakasalalay yung completeness ng mga documents na nire-request ng prosecution on this request for issuance of subpoena. Kasama doon yung expanded list ng BIR documents. Not only those which we believe are inside the box, but even the other documents of the BIR which we believe are pertinent as well in this impeachment trial.
And just to last question, ma'am, I saw you yesterday together with some of the House prosecutors and even, of course, the defense. How are you guys? Are you in high spirits? Pagod ho ba kayo? Kamusta ho kayo? Ang prosecutor, public and private?
The prosecutors are always in high spirit, both the public and the private prosecutors, no? We believe in the nobility of what we are doing. We believe that this is for the Filipino people. We understand that this is a constitutional duty, no? And yes, we are always in high spirit, and we're positive that we will be able to present all the evidence necessary to support the 4 articles of impeachment.
And we'll see you again tomorrow. Maraming salamat, House Lead Prosecutor, Congresswoman Jervil Jinky Luistro. Thank you po.
Thank you, Pinky, and thank you to all the viewers and followers.
And that's On Point. Join us again tomorrow, 7:30 p.m. here on BNC, the Bilyonaryo News Channel. I'm Pinky Webb. Thank you for watching.
Oplan Romanov pa rin ang sentro ng ikalimang araw ng impeachment trial. Target daw nito si VP Sara, kaya siya nagbanta laban sa first couple at kay dating House Speaker Martin Romualdez. Pero ayon sa testigo ng prosekusyon, sa kapatid ng bise mismo na si Mayor Baste Duterte nanggaling ang salitang Romanov. Yan ang agenda report ni Hannah T. Nag-uulat live mula dito sa Senado. Hannah.
Corina, ang usapang Romanov ay issue sa umano'y banta laban kay Pangulong Bongbong Marcos at sa kanyang pamilya. Hindi raw ito banta laban kay Vice President Sara Duterte. Yan ang isa sa mga lumitaw sa 5th day ng impeachment trial ni VP Sara matapos tanungin ni Senator Judge Raffy Tulfo sa NBI si NBI Regional Director Jeremy Lotok tungkol sa pinagmula ng salitang Romanov na iniuugnay ng depensa sa tanong ni blogger Princess Maui sa online press briefing ni VP Sara noong November 2024.
Saan ba talaga yung Romanov nag-umpisa at sino ba talaga ang dapat mag-ingat doon sa banta na Romanov?
Yeah, insofar as our investigation is concerned, since nag-start yan doon kay Mayor Baste at wala ho kaming ma-validate na ibang Romanov operations na nangyari, I think nag-start yan sa kanila, sir, sa kapatid ng Vice Presidente.
Ayon kay Lotok, batay sa investigasyon ng NBI, hindi nagsimula ang Romanov sa online press conference. Sa halip, nagmula ito sa pahayag ni Davao City Mayor Baste Duterte sa isang maisog rally kung saan sinabihan nito si PBBM na, quote, think of the Romanovs bago matulog. Corina, ang mga Romanov ang huling Russian imperial family na na-execute noong 1918. Kasunod nito, tinanong ni Senator Tulfo kung ang tinutukoy ng Romanov ay babala laban sa first family at hindi kay VP Sara. Sumang-ayon si Lotok at sinabing iyon ang lumabas sa investigasyon ng NBI. Dagdag niya, wala rin silang napatunayang umiiral na hiwalay na Operation Romanov. Kung sumipot daw sa investigasyon ng NBI si blogger Princess Maui matapos itanong ang umano'y operasyon sa online presser, standard procedure daw ng Bureau ang i-validate ang impormasyon at magsagawa ng case build-up para matukoy kung may katotohanan ang naturang pahayag. Tila dumepensa rin si Senator Judge Alan Peter Cayetano at ipinaalalang hindi raw dapat i-conclude na may banta rin si Mayor Baste laban sa first family. Una na rin kasing sinabi ng defense panel ni VP Sara na iba naman daw ang Romanov sa Operation Romanov na tinanong ni Princess Maui sa bise.
And in the same manner, we have to be fair to the first family. We have to be fair also to Mayor Baste and to the Dutertes, that rather than draw a conclusion that there was an actual. So the Counsel for Defense was making a distinction, mentioning Romanov and Oplan Romanov are two different things. It may be the same, it may be different thing. For all we know, narinig ni Mayor Baste na sila Iro Romanov, kaya binanggit niya pabalik. We don't know. I don't know.
Nasa day 5 na tayo ng trial at hinihimay nila kung pasok ba sa grave threats at inciting to sedition ang naging banta ng bise laban sa first couple at kay dating Speaker Martin Romualdez sakaling may mangyari raw sa kanya. Corina, napag-usapan na rin kanina kung pasok ba sa inciting to sedition yung naging pahayag nga ni VP Sara doon sa 2024 online press con at nang tanungin si Lotok kung masasabi bang was someone incited by the remarks of the Vice President. Kinonsidera raw nila yung utterance at yung naging pahayag mismo ng bise at tila naging epekto nito sa publiko at pa ni Lotok maituturing kasing example si VP Sara bilang public official at bukod pa rito may sinay siyang desisyon ng Korte Suprema na ang sinasabi sa People versus Nabang hindi raw kailangang may aktual na naganap na pag-aalsa o sedisyon bago maging iligal ang isang pahayag. Sapat na ayon sa Korte Suprema na ang pananalita ay may tendency na mag-udyok ng sedisyon o maglagay ng panganib ng kaayusan ng publiko. Corina.
Hana, ang ibig bang sabihin nito ay maaari pang idagdag bilang pang-5 article yung inciting to sedition? Saan papaloob yun? Sa grave threats o hiwalay siya at mas malubha na krimeng matatawag? O basehan para sa impeachment?
Corina, katunayan na tanong yan ng prosecution or rather ng defense team ni VP Sara doon sa witness nga na si Attorney Jeremy Lotok kung masasabi bang impeachable offense ang grave threats and inciting to sedition. Gayong yun yung lumalabas daw na tila reklamo laban sa bise because of the controversial remark nga of the Vice President doon sa press conference. Pero nilinaw naman kalaunan sa Senate Impeachment Court na ang pasok doon sa articles of impeachment ay betrayal of public trust kung saan sinasabi nga doon or nakapasok doon yung grave threats and inciting to sedition na reklamo laban sa bise. So bahagi yan noong Article 4 nga ng Articles of Impeachment. Corina.
I see. Hana, ilang oras na rin ang paglilitis pero hindi pa tapos dito sa grave threats na sinasabi at si Ginoong Lotok nga ang nakasalang at hindi pa natin nakikita si OVP Chief of Staff Zulayca Lopez. Sasalang pa ba siya sa witness stand ngayong araw?
Corina, sa ating latest monitoring, nandito pa si Attorney Zulayca Lopez na OVP Chief of Staff pero hindi tiyak sa ngayon kung isasalang ba siya sa witness stand dahil supposedly yung sabina para sa kanya ng Senate Impeachment Court ay kahapon lang at ngayong araw. So nasa desisyon niya ng Senate Impeachment Court kung may extend ba ito hanggang bukas o kung mamayang gabi ba ay posible pa siyang maisalang. Anyway, Corina, kahapon naman din na-brief na rin tayo ng Senate Impeachment Court na posible ngang mag-extend hanggang mamayang gabi itong paglilitis ngayong araw given na magkasunod itong si Lotok at si Zulayca Lopez. Balik sa iyo, Corina.
Okay, maghihintay tayo. Maraming salamat, Hannah T. Nag-uulat live mula dito sa Senado. Ginisa muli ng defense team ni VP Sara ang prosecution witness na si NBI Director Jeremy Lotok. Ang mga senador, judge, sumingit na rin sa pagtatanong tungkol sa Oplan Romanov. Yan ang agenda report ni Dexter Ganibe ng Abante, live nag-uulat mula din dito sa Senado. Dexter?
Corina, 2 oras kahapon, 3.5 oras ngayon, kabuang 5.5 hours o nasa ganun nga, nakahaba ang isinagawang cross-examination ng depensa dito kay NBI Director Jeremy Lotok. Agad nakapag-umpisa ang depensa sa pagpapatuloy ng kanilang cross-examination sa ikalawang testigo ng prosekusyon para sa Article 4 ng Articles of Impeachment ngayong ika-5 araw ng impeachment trial. Pero hindi naman dire-diretso ang pagsasagawa ng cross-examination ngayong hapon dahil may mga pagkakataon na nagtatanong din ang senator judges. Kabilang na rito ang usapin ng Oplan Romanov at natanong din ang prosekusyon at depensa na bigyang linaw nila ang issue ng grave threat.
Ang question ko ay, in your appreciation, dapat ba na ang supposed victim nakaramdam talaga siya ng threats? Or is it enough that the general public considers the statement threatening?
Etong sinabi ng Supreme Court, all that needs to be proven is that they were intended by the accused to have that effects. Yung sagot sa tanong, hindi po galing sa prosecution, hindi po opinion, galing mismo sa Supreme Court.
It is our position that the statements made by the Vice President were not threats in the first place. That's why we were categorizing it as response, a mere response to a Q&A. Number one. Number two, it was never aimed directly at BBM, FL, and the former speaker.
Samantala, sa inilabas niyang pahayag ngayong araw, batay sa naging paglilitis kahapon sa Day 4 ng impeachment trial, nanindigan si Vice President Sara Duterte na ang reklamo laban sa kanya ay hindi suportado ng mga ebidensya. Lagi anyang ginigiit ng prosekusyon na may nangyaring pagbabanta, gayong wala naman talaga ang pagkakaroon ng hitman pero panay imbento lang daw at pawang mga hinabi lang na ebidensya na hindi naman kayang gawin ang mga kathang isip na isang katotohanan. Kailangan niya ay nakabatay ang impeachment trial sa mga kapani-paniwalang ebidensya at hindi sa espekulasyon, gawa-gawa na naratibo o copy-paste na affidavit at mga aligasyong walang matibay na ebidensya. Kahapon kasi, inamin ni Attorney Jeremy Lotok na ang ilan sa mga nakalakip na affidavit sa isinumiti na lang reklamo sa DOJ noong Enero ng 2025 laban sa Vice Presidente para sa grave threats ay templated affidavit dahil sa pagkakapareho ng mga typographical errors. Samantala, ako rin nabalikan ko lang ang pagkakasalang kay Attorney Jeremy Lotok bilang testigo dito sa Article 4 matapos yung napakahabang cross-examination ng depensa. Abay, sumasalang pa ulit siya ngayon sa redirect. Bakit nga ba nangyayari itong redirect examination? Ginagawa ito ng prosekusyon kapag may mga nasambit ang kanilang testigo doon sa cross-examination na medyo makakasira doon sa mga nauna niyang sinabi sa direct examination, kaya nagkakaroon ng redirect para maitama nila yung mga pahayag ni Attorney Jeremy Lotok. Karina?
Okay, so mukhang mahaba ang ating gabi, Dexter, at meron pang redirect pagkatapos ng cross-examination. Siguro naman pagkatapos ng redirect, meron pa bang kasunod yon?
Pagkatapos ng redirect, Corina, kapag may nakita naman ang depensa na kailangan nilang itama doon sa nangyari sa redirect, ay magkakaroon ng cross-examination. Titignan natin yan along the way, baka abutin nga ng gabi or dahil gabi na rin, titignan natin kung maisasalang nga ba ngayong araw itong si Attorney Zulaika Lopez, ang Chief of Staff ng OBP na kanina ay dumating na dito, mag-alas 2 ng hapon, nandito na siya sa Senado. At may dagdag ko lang, Corina, na ang defense team pala ay talaga ng kanilang deputy spokesperson, sa katauhan po yan, ni Attorney Justin Nicole Golar. Siya yung hahalili kay Attorney Michael Powa kapag absent si Attorney Michael Powa o hindi niya kayang magbigay ng briefing sa media kaugnay ng mga updates sa impeachment trial. Itong si Attorney Justin Nicole Golar na isang Cebuano lawyer ang magbibigay ng updates sa media para sa depensa. Corina?
Maraming salamat, Dexter Ganibe ng Abante. Nag-uulat live mula rin dito sa Senado.
Imbento at walang ebidensya. Ito ang banat ni VP Sara sa ikalimang araw ng kanyang impeachment trial. Giit ng bise, walang nangyaring pagbabanta sa buhay ng first couple at ni former House Speaker Martin Romualdez. Gawa-gawa lang din daw ng prosekusyon ng issue ng assassin para patibayin ng akusasyong grave threat laban sa kanya. Dagdag ng VP, dapat nakabatay sa matibay na ebidensya ang paglilitis at hindi sa kathang isip lamang.
Wala talagang lusot para sa prosecution si VP Sara sa paratang na grave threats. Itinulugsa din nila ang anilay panlilin lang ng depensa sa mga Pilipino. Ang detalye sa agenda report ni Isaiah Mirapuentes ng Abante, live mula sa Senado. Isaiah.
Pinky, nasa ikalimang araw na nga tayo ng impeachment trial laban kay Vice President Sara Duterte. Subalit ayon sa prosecution, Pinky, wala raw sila nakikitang sinyales na nagiba o nasira na ang mga ebidensyang laban kay VP Sara. Sa katunayan, Pinky, ayon mismo kay Representative Terry Redon na isa sa mga House prosecutor, tila parang no-brainer daw kung magtanong ang mga abogado mula sa depensa.
May kinausap na ako na tao. Sinabi ko sa kanya, kapag pinatay ako, patayin mo si BBM, si Lisa Araneta, at si Martin Romales. No joke. No joke. Nagdilin na ako, ma'am. Pag namatay ako, sabi ko, huwag ka tumigil hanggang hindi mo mapatay sila. And then he said yes.
Second highest person in the land and wants to be president in 2028. Is this the kind of president that we want?
Walang duda ang House Prosecution Panel na nagbanta ang bise laban sa matataas na opisyal ng bansa.
Una, kung totoong hindi siya kumuha ng killer, ibig sabihin niya vice president that lies. Di ba? Pero kung totoo na nag-contract siya ng killer, then you have a vice president that contracts a killer.
Ang depensa raw, sa halip na itinanggi ang mga ligasyon, ay tila nililinlang na ang taong bayan. Hanggang sa umabot pa nga raw sa pagkwestiyon sa typo errors at sa tila pagtuturo sa Pangulo na umano'y nagmando sa investigasyon laban sa bise.
Kumbaga sa Bisaya pa, ganahan sila nga maglibog ang tao ba para kung ang tanaw nimo dili na nimo maintindihan. In other words, yun ay paglilihis. A deviation from the real issue being discussed.
This was never denied by the Vice President. It was not denied in the answer. And even, 3 days when she was asked about this, and bukod sa hindi niya to deny despite the repeated opportunities to do so, yung fact ho na pag-amin niya, isa yan sa pinakamataas na uri ng ebidensya.
Giit pa ng prosekusyon, kahit ano pa ang idahilan ni VP Sara, ang banta ay banta. At saklawaan nila ito ng betrayal of public trust na isang impeachable offense.
Pinky, alam mo, ayon pa sa prosekusyon, ang hinihintay raw nila ay kontrahin ng depensa ang aligasyon ng grave threats laban kay VP Sara. Subalit hanggang sa ngayon nga raw, Pinky, wala pa silang naririnig kaugnay rito. Maliban pa dyan na Pinky, hindi rin daw pwedeng sabihin ng defense team na walang ebidensyang magsasabing may umano'y pagbabanta nga dahil ayon mismo sa prosekusyon na panood ng taong bayan ang video ng tila pagbabanta ni VP Sara sa first couple maging kay former House Speaker Martin Romualdez at sa katunayan nga, Pinky, ginamit pa mismo yan ng defense team sa kanilang cross-examination. Pinky.
Maraming salamat, Isaiah Mirafuentes ng Abante, nag-uulat ng live mula po dyan sa Senado. Habang nakatuon ngayon ang pansin ng publiko sa issue ng grave threats, naniniwala naman ang isang abogado na hindi ito ang pinakamahirap na artikulong haharapin ng depensa. Mahalaga rin daw na tandaan na ang impeachment ay hindi ordinaryong criminal case. Hindi lamang ito usapin ng paglabag sa batas ang sinusukat, kundi kung karapat-dapat pa bang manatili sa pwesto ang pangalawang Pangulo. Usapang SALN ang nakikita ni Attorney Tranquil Salvador na pinakamalaking hamon para sa depensa ni Vice President Sara Duterte. Kabilang si Salvador sa nooy defense panel ni former Chief Justice Renato Corona noong 2012 impeachment trial, kung saan naging sentro rin ang issue ng SALN at naging basihan para sa impeachment ni Corona. Sinabi ni Salvador sa memo ng Bilyonaryo News Channel na di katulad ng grave threats na naaayon sa magkaibang interpretasyon ng magkabilang panig, ang mga numero sa SALN ay hindi maaaring baluktutin ang pangangatwiran. Sa huli, ano ang dapat abangan ng publiko sa mga susunod na araw ng impeachment trial at ano ang magiging pinakamahalagang batayan ng impeachment court?
Sa SALN, tsaka yung unexplained wealth, yung sa AMLA, secrecy of bank deposit. Even in the past, yan ang mga issues Nung kay CJ Corona, yan ang issue. Nung kay President Estrada, yan ang issue, remember? Yung kay CJ Sereno na hindi naman nag-trial, di ba? Na-file sa Supreme Court, salin rin ang pinag-uusapan. So I think that's something that the public could easily understand. Kasi ba't hindi na-deklara? Ganon. So sa tingin ko, yun ang greater challenge ng depensa. Tapos yung BIR box.
Noong 2001 sa impeachment trial ni President Joseph Estrada, nagdesisyon ng mayorya ng senator judges na huwag buksan ng second envelope na naglalaman ng mga numero at dokumento na nagpapatunay ng ill-gotten wealth ni ERAP. Ito ang naging mitya sa pagsiklab naman ng EDSA 2 at pagpapatalsik rin kay Estrada bilang presidente. Noong 2018, nagkaroon din ng impeachment complaint laban kay dating Supreme Court Chief Justice Maria Lourdes Sereno dahil din sa isyu ng SALN. Pero bago pa umusad ang impeachment proceedings, tinanggal sa pwesto si Sereno ng kanyang mga kapwa mahistrado dahil sa quo warranto petition ng nooy Solicitor General na si Jose Calida. Mahalaga rin anya na makumbinsi ng senator judges ang publiko sa mismong proseso ng impeachment court. Ano man daw ang maging desisyon nito ay mas magiging katanggap-tanggap sa publiko kung makikitang patas, maayos at kapanipaniwala ang paglilitis at may malinaw na ebidensya.
Kasi at the end of the day, ang process, ang greater challenge ng Senate dito is the entire process should be credible. Because regardless of the outcome, if it's credible, ang tao kahit na, alam mo, masama loob niya, tanggap niya eh. Alam mo yung gano'n eh. Pero pag nakita niya hindi, magre-react ang tao.
May duda siya.
Yun ang kasama rito. Kaya it's a very challenging process.
Makakasama natin ngayon si House Prosecutor at Justice Committee Vice Chairman Jonathan Keith Flores. Magandang gabi po sa inyo, Kong.
Magandang gabi po.
Opo. So, before we go into grave threats, do you agree sa sinabi po ni Attorney Tranquil Salvador na baka ang pinakamatinding haharapin ng depensa ay hindi pa ito grave threats, kung hindi yung confidential funds or all evidence that have anything to do with numbers? Kasi hindi mababaluktot ang numero.
Well, tama naman po, in a way, tama din po. But sa tingin ko po, lahat naman ng articles na impeachment na final namin, ay may strength naman po.
Okay, so going back to grave threats, pinag-aralan po namin kanina lahat ng mga sinasabing elemento ng grave threats. 4 po yung nakasulat, binasa namin. So ano po sa palagay ninyo, pasok naman sa lahat ng elemento ng grave threats?
Based po sa findings ng NBI na sinabit nila sa DOJ, pasok naman po yung elements. But ang importante po dito is that we're not trying the Vice President on grave threats alone. This is articles of impeachment po na ang tinitingnan po natin dito is not the criminal aspect of grave threats only, but whether she is fit to stay in the position, in an impeachable position po.
So thereby, kailangan hintayin natin hanggang dulo lahat ng 4 na artikulo.
Hindi naman. One has its own purpose.
Each one has
yes,
its
po.
own
end po. No?
Yes.
Ito naman is betrayal of public trust, culpable violation of the Constitution, pero hindi siya necessary na grave threats lang as a crime itself.
Okay. So, can it stand alone as an impeachable offense? Grave threats. Kung mapatunayan yan, sabi ng iba, tulad ni Attorney Howard Calleja, it's enough. Hindi na natin kailangan magpatuloy, pwede na siya ma-impeach. So, that is possible.
Well, if we have established
na mabanggit ang patungkol sa pagpunta ng ating mahal na NBI Director sa Bangkok at ito po ay kinwestiyon ni Senator Alan Peter Cayetano, kahapon po ay biglang lumabas ang isang pahayag na iniimbestigahan daw po yung patungkol sa pangyayari noong Southeast Asian Games. Ito po ba ay eksakto lang o ito po ba ay mayroong dapat tayong pangambahan? Sapagkat, alam niyo po, ako din po ay dapat ay pupunta ng Iran. Sapagkat isinagawa po ang pagbibigay-pugay sa namatay na kanilang leader, spiritual leader. Pero hindi po ako tumuloy dahil may impeachment po tayo. Tanong ko lamang po sa ating mga kasama, dapat po ba tayong mangamba? Dapat po ba kaming manggamba? At tayo po ay parang eksakto naman lahat ito? Hindi ba po tayo ay malayang korte? Tayo po ay may karapatan na binibigay ng konstitusyon na magsagawa po ng pagdinig na ito. Yun lamang po. Maraming salamat po, Ginoong tagapamahalang hukom.
The manifestation of Senator Judge Padilla is noted. What is the pleasure of Senator Judge Cayetano?
Mr. Presiding
Alan?
Officer, Rule 6 of the impeachment proceedings is that the rules of the Senate is suppletory, and if there is anything that affects the honor, integrity, or the functions of us individually or as a Senate here as an impeachment court, someone can rise on a question of personal or collective privilege. I won't do that, but may I just respond to what Senator Padilla said, since my name was mentioned and since the investigation announced by the NBI yesterday seems to be pertaining to this person as chairman of the 2019 Organizing Committee of the Southeast Asian Games. May I, maybe, in the form muna of manifestation, unless the presiding officer or Senate President thinks that I should elaborate on by asking for time on a personal collective privilege, but I don't want to start that
Senator
precedent.
Judge Cayetano may make his manifestation.
Okay.
For the record, sir.
So, first and foremost, sa sinabi po ni Senator Padilla, I won't ask na ipa-play na yung video, but quite exhaustive yung sinabi ni NBI Director about the Southeast Asian Games. So, if the intention was to have a chilling effect, we already have that chilling effect. May 11, hinabol dito sa session hall na to ng mga ahente ng NBI, si Senator Bato. May 13, nagkaroon ng enkwentro, putukan, pinipilit ng NBI na hindi sa loob ng Senado, but we have all the evidence that it was inside the Senate. Other incidents, I do not want to evoke a reaction or debate because I want to respect my fellow senators. Much of this has been vented in the media, is in court. Director Matibag has promised us that he will give us a warrant issued by the ICC, has promised us that he will hold his agents na nanggulpe ng isang OSAA. He will be the one to implement the contempt order and hold them in his office, but wala ditong natupad. So when I mentioned his name, his position the other day that it was bad taste, walang personal yan. I mean, regardless kung sinong, even if it was a secretary, an alter ego of the president who wrote the prosecution team or the defense team to say, pwede bang next week kasi may seminar, I would have said the same thing, di ba? Na, you know, look at the gallery. Kompleto parati dyan from Congressman Ace Barbers to many Congressman Ridon. I won't name all of you, but you're busy people. But you think this is important, so you take time out and you are here. Diba? Of course, the prosecution team, you have to be, you are here. We are here. despite of many, many other important things, not only investigations, not only the flood control, not only the BIR, not only, we're also talking about the nation being prone to volcanic eruption, to yung bagyo, buti, well, nasalanta pa rin tayo ng bagyong Inday. Ibang Inday ang pinag-uusapan natin dito sa impeachment. But still, we are here. So it was in good faith that I said, as an example, mukha namang masama kapag yung isang bureau head, NBI director is a very important position, but it is a bureau. So if a bureau head, and tignan yung invitation, nakalagay sa invitation, or your representative, and we resolved it. So aksidente ba na yesterday, suddenly after I mentioned it, and after during the weekend, many have been talking about na dapat ata hindi 16. So 21 na lang kami ngayon eh. So 2/3 of 21 is 7. Pag nabawasan pa kami ng 3, 13 na lang yon. Pero some will argue, mabawasan lang kami ng 1 o 2, baka 13 na rin yon kasi wala naman half person o 3/4 person. So all of these issues are valid. Question, the chilling effect is there, but am I intimidated? Wala na akong choice. Ilalabang ko na to, gagawin ko yun ang dapat kong gawin. Bumaliktad man yung sitwasyon, si President Marcos ang ini-impeach and I felt a certain way, ilalabang ko rin. Chief Justice man ang i-impeach, ilalabang ko rin. But for the record, Mr. President, go ahead and investigate. First of all, that's been investigated many, many times. COA, I'm not sure. I think the Office of the Ombudsman, ang nag-file pa ata, Chief of Staff mo eh. Senator Rob, I'm not sure but parang may kaso na nun. Senator Drilon quizzed us here. I was Speaker of the House, but I chose to appear before the Senate to be able to answer all of those questions directly. The SEA Games, paulit-ulit yan. Biktima na ng speakership ng 2019 yan. Nahuli namin yung PR na sinabi kikiam, pinakain daw mga Muslim ng baboy, when it was chicken longganisa na pinakain. Pero nasiraan na tayo sa Malaysia, Indonesia. The SEA Games gave us so much honor. So far, it is still the biggest SEA Games in history. Many of our athletes launched their career, even going to gold medals in the Olympics. Our athletic and our yung aquatic natin center in Clark is one of the best in the world. Ang nagsabi nito yung Israeli coach ng isang foreign team doon. But go ahead if you want to investigate. But I just want to put on record, mukhang misfire. Bakit? Yung sinasabi niyang infrastructure na walang bidding, first of all, the procurement law has many modes of procurement. So don't make it appear sa public na just because walang bidding, may anomalya na to. Okay. Secondly, bakit ko sinabing misfire? Hindi po sa, I'm referring to Director ng NBI Matibag. I had nothing to do with the infrastructure. The chairman of the committee. In fact, I had to resign from the DFA because I was running for congressman during that time. So dun sa sinasabi ni Director Matibag na may congressional insertion to fund it, it's definitely not me because how could a non-member of the Senate or non-member of the House insert anything? Okay. Dun sa sinasabi niyang infrastructure, it was done by the BCDA. The chairman of the BCDA is one of the closest advisors of the president now. The president of the BCDA is one of the closest advisors and is a secretary now. And he said, medyo kaduda tong kumpanya na nanalo walang bidding. If I'm not mistaken, it's the same company who's making the City Hall of Pasig. Huh? So, I mean, if they want to investigate, go ahead. But by mentioning the organizing committee of the SEA Games, ako po chairman nun. At paninindigan ko po na napakaganda nung nangyari doon. At kung may anomalya, ako unang magagalit. So, go ahead. But my point, Mr. Chairman, honorable members of the court, sa prosecution, To be fair sa prosecution at marami akong kaibigan, I've never felt any intimidation from any of you. I mean, you've continued to be either friends or for those who are former friends but friends. I mean, I don't know if nagkamali lang ako, but on the first day, I nodded ng konti kay Senator De Lima. Gumanon din siya, hindi ko alam kung na-acknowledge because we were friends once upon a time and this is a court. We owe it to each other to be professional, di ba? So wag tayong pumayag na someone like Director Matibag would do that. My point, Mr. President, Mr. Presiding Officer, he could have not announced it and investigated. Imbestigahan mo, tingin mo may mali, imbestigahan mo. But it is unfair to me and unfair to the court that kung kailan siya patatawag siya sa Monday, intimidate mo ako, hindi kita tatanungin sa Monday dahil mag-a-announce ka na iimbestigahan mo. Tapos sasabihin mo may insertion, tapos sasabihin mo hindi liquidated po lahat yun. So, let me talk of unfairness. Hindi ba unfair? Kung ako, babaliktarin ko, sasabihin ko, inimbestigahan ko na rin kahapon Ang sabi sa akin, mainit ang ulo ni Director Matibag kasi may contractor na daw yung binigay na lupa para sa NBI at gusto niya sarili niyang contractor. Would that be fair to him? No. It would be a marites accusation. So that's the same thing he announced yesterday. A marites accusation towards me that affects this court because I am now a senator judge. So I hope this is the last time that I'm going to have to speak about this. But definitely, we've been speaking about this, binabawasan talaga kami. Iniisa-isa. Even yung mga vlogger na malapit sa administrasyon, sabi, 2 down, 3 down, may kasunod na. Di ba? So, Mr. President, I want this impeachment to be a test that the 1987 Constitution works and that despite political differences, the prosecution and defense, I saw them after the first or second day, nagkakamayang kayo, nagkakamustahan. After the first or second day nung mainit na baliktaktakan dyan sa pre-trial, nagbabatian, di ba? Even in court. So we can't help but be emotional. We can't help but get mad at what we think is disgusting or sometimes crossing the line. But is there any question that for this verdict, whether it's for conviction or acquittal, to be accepted by the Filipino people, we have to make sure that the integrity of the court is intact. I will admit to you, nahirapan po ako. Wala si Senator Marcoleta Iilan lang po kaming abogado dito. Si Senator Pangilinan, Senator Cheese, si Aimee is a law graduate, di ba?
Pia.
Senator Pia, Bam is a second-year law student and I'm encouraging him na tapusin niya. Total review na yung nangyayari ngayon. But it's not easy. 24 lang kami, nabawasan na ng 3. So I hope this issue of the integrity of the court becomes an issue for all of us. No, I'll repeat what I said when I was Senate President. Director, hindi mo kami natibag. So wag mo try itibagin tong representation na to o itong impeachment court because what you're doing is not helping. You investigate whatever you want to investigate. You want to investigate, ba't ako nagpatubo ng balbas? Investigate mo, no problem with me. Pero wag mo nang i-announce kasi nga naaapektuhan yung integrity ng court. Thank you for the leeway, Presiding Officer.
Thank you, Senator Judge Alan Cayetano. Yes, what is the pleasure of Senator Judge Pia Cayetano?
Mr. President, Presiding Officer, I assume most of my colleagues, like me, were busy studying the lengthy memorandum filed by each of the parties. For the record, 30-plus pages, more or less double space yung sa prosecution. Kaya by the time I got to the defense, para na ako maduduling kasi mahaba na nga yung 30 pages na double space. Napunta pa ako sa single space. Okay lang yun, kasama sa trabaho yun. Pero that's how lengthy the documents were. And I slept at 2 a.m. Hindi kasama to sa explanation ko. Di ako nagyayabang or anything. It's our job. And I'm a night person, so normal sa akin yun. And then in the morning, tuloy ulit. Sent my staff questions, asked for more details, and then we worked together throughout the morning until it was time to come here. So I don't know anything about this statement of Director Matibag. But it bothers me to hear this. I now remember that I saw a message pop up in my phone, which hindi ko nga pinansin kasi nga ito yung important issue ko na pag-aralan ko tong memorandum ng mga parties na inabala nga naman nilang very lengthily and exhaustively na nila dinidiscuss in a written document. But I recall now na may nag-pop up na message from a coach telling me na gustong pa-imbestigahan yung SEA Games. And di ko talaga pinansin. And now Alan brings it up and I am bothered. There is no jurisdiction in the world that allows a judge to be pressured and intimidated. And I ask each one of you, my dear colleagues, payag ba tayo sa ganito? Ganito na ba tayo dito ngayon? Don't we want a better country for our children? Why would you allow a director who's just called to be a witness next week brag that he's going to investigate? And again, I don't know. So I respectfully request that it be played. Because I want to understand. If I don't have reason to be upset, then thank you, I can focus. I can go back to the business on hand. But right now, I am upset to hear this. And I will stand up for each one of you. I don't care what side you're on. I will stand up for you if somebody tries to intimidate you. So with all due respect, Mr. Presiding Officer, I ask that we play it. I want to see what this witness is doing.
Presiding officer declares a brief recess. The trial is trial is resumed. Chair grants the motion of Senator Pia in order for us to be able to move on with the matter on hand for today, which is the oral arguments of the parties. Chair therefore instructs the tech to kindly play the 1-minute video for Senator Judge Pangilinan is recognized.
Thank you, Mr. Presiding Officer. We share, we support the position taken by the presiding officer, but we'd like to place on record that the good NBI director will be here on Monday. So my initial view is that we should be able to do this on Monday, but I will yield to the ruling of the chair, Mr. President.
We thank the understanding and magnanimity of Senator Judge Pangilinan. The tech is instructed to play the more or less 1-minute video alluded to and requested by Senator Judge Pia Cayetano.
Meron kaming mga kaso na pumasok na bago na dapat namin tingnan. Kung maalala nyo, pumunta kami ng Clark because we were given 70 hectares for the NBI Academy. So magkaroon kami ng relationship sa Clark. Nakita namin dun yung parang sports complex na ginamit ng SEA Games, yung sa Philippine SEA Games Organizing Committee. Well, nakarating sa amin, may titingnan kami rito, may kailangan kami imbestigahan dahil nakarating kami rito, billion-billion pala yung pumasok dito na pera na unliquidated. At mayroong private company rito na na-involve na binayaran ng 10 billion at ang pagbabayad insertion sa GAA na hindi binayad. So ito, imbestigahan namin to. Malaking kaso rin ito. Ay, iba pa yun, yung sa Caldero na kaso, I think it's ongoing, pero sisilipin na rin namin. Ito yung tungkol dun sa, it's a Malaysian company na sila yung nag-build ditong sport area na to. Walang bidding, tapos nabayaran ng mabilisan na 10 billion yung halaga, congressional insertion. So sisilipin namin to. Katunayan, meron kaming mga kaso na pumasok na bago na dapat namin tingnan. Kung maalala nyo, pumunta kami ng Clark because we were given 70 hectares for the...
Senator Judge Pia Cayetano is recognized.
Rest assured, Mr. Presiding Officer and dear colleagues and parties, I will not belabor this point. I will not stay long. But clearly, from the statements of Director Matibag, malaki daw kaso to. Naimbestigahan na niya? Alam niya ng malaking kaso? Paano niya nalaman? So sa akin lang, Mr. Presiding Officer, simple lang eh. What was the intention here? To distract the minority floor leader, who is one of only 2 lawyers right now, because our other lawyer was already carted off somewhere. So dalawa lang kami. So you want to distract him. So ako na lang ang tatayo dito. Hindi na siya makakapag-aral. Yung ba intention? Because it is clearly the intention. The fact that he has to stand up, the fact that I have to stand up, the fact that Senator Robin has to stand up, he is distracting us from our job. As Senator Alan said, he could do it quietly. Go ahead. Anong purpose niya? Nagyayabang siya? What's the purpose? Is he trying to intimidate us, not to ask him tough questions when he is our resource person next week? I do not know. But those statements, those actions are not acceptable, possibly contemptible. So I ask the presiding officer and you, my dear colleagues, let's think about this clearly. I will stop now. As Senator Pangilinan said, we can take this up on Monday. Salamat na pinagbigyan niyo ako na mapanood natin at pag-isipan natin. Na gano'n na lang, pag may pinatawag tayo sa witness stand, abangan natin na magpe-press con na kung ano-ano pagsasabi tungkol sa atin. I didn't have enough time to research. But clearly, I know that there's jurisprudence that does not allow a judge to be intimidated. And if hindi pa nanakot yun, then I don't know what is. Kung hindi pa ninindak yun, then I don't know what is. Hindi tayo sensitive. Sanay tayo dito. Pero alam din natin kung pinapatamaan tayo, di ba? Alam natin yon. Di tayo tanga. O so paano? Sabihin ko ngayon sa kanya, o manda ka sa akin ngayon, pagdating mo. Ganun ba? Gaganti na lang ako. Hindi ako ganun. Kilala niyo ako. For how many years ako tumayo dito? Hindi ako nanggaganti. Hindi ako mababaw. Pero I'm asking you, dear colleagues, huwag tayong papayag. The Filipino people deserve better. We deserve better. Thank you.
Thank you, Senator Judge Villa. What is the pleasure of Senator Judge Alan Cayetano?
Yes, I didn't know we were going to play it, but just for the record, there's no issue with the Quadron because it was paid by the private sector. There was no public money used, and it was designed by the firm of a national artist. So much so that that same firm, I don't know when we started to hire them, whether it was the time of Senator Lacson as the Committee of Accounts for the new Senate building or the time of Senator Nancy. But until now, there's engagement. So it's so easy to find out. No? But can I shift to the topic at hand? Just one manifestation for the whole Senate regarding the oral arguments.
We have not yet called the journal and called the court.
Yes. So
called
at the
case.
proper time, I just want to...
Yes, you may do so at the proper time. Proceeding now, if there are no objections, the presiding officer will dispense with the reading of the July 14, 2026 Journal of the Senate sitting as an impeachment court and shall consider the same as approved. Clerk of court will please call the matter before the impeachment court.
Case number 004-2026 in the matter of impeachment trial of Vice President Sara Duterte.
Appearances for the parties.
Good afternoon, Your Honors. Same appearance for the prosecution. We are ready, Your Honor.
Appearances for the respondent.
Good afternoon, Your Honors. I'm Michael Poa. Same appearances for the defense and for the respondent accused, Your Honor.
Before recognizing the counsel for the prosecution for their 15 minutes for their presentation and oral argument in relation to their motions for the issuance of subpoena for banks, AMLC, and the BIR, Chair would like to recognize Senator Judge Alan Cayetano for his manifestation earlier. Alan? The Senator Judge intimated earlier that he had a manifestation before we proceeded.
Yes, this is really to be fair to the prosecution and of course to the defense. One of us. So yesterday I asked whether or not mag-oral arguments today, and then I'd like to thank the Senate President and of course the presiding officer and all our colleagues, no, Senator Soto, although magkatabi kami, hindi kami magkatabi, but I saw him agreeing that we should have a caucus and discuss this. Hinimay ko lang very preliminarily, ha. If we're going to look at issues, for example, relevancy lang, you have about the banks, you have AMLA, AMLC, you have BIR. Then for each one of them, so for example, for the banks and AMLC, you have peso accounts and dollar accounts. Then for each one of them, you have the accounts of Vice President Sara, but also of the spouse, and then possibly of the companies, same sa BIR. So, although I do believe that we have exclusive jurisdiction, sometimes the Supreme Court have defined certain parameters that we either have crossed or not. So if we're going to vote, one vote, whether or not to allow these subpoenas, it would be unfair to everyone. For example, me, I cannot vote unless I see na walang problema sa lahat, then no problem, let's vote, pwede. Pero kung sabihin kong walang problema sa banks at AMLA, may problema sa BIR. Walang problema sa BIR, pero sa spouse, meron. So we're going to have a caucus, and I'm sure we're going to have a good discussion on that. But just two things. Number one, can we give, of course, we'll follow the time today, but if any of the two, the prosecution or for example, in the rebuttal, after the rebuttal ng defense, makikita na ng prosecution saan talaga nag-object yung defense, hindi lang sa lahat. If we can give them a little bit more time, kasi nga, mahabang discussion to. Having said that, I'm more than okay if we have to have an extra day next week, whether to discuss among ourselves or I'm not preempting our caucus. I'm just saying, Mr. President, that I commit to you, I will not delay, I will not overtalk on these issues, and I don't think controversial each and every one of this yung request for subpoena dito, but there may be one or two, and I don't think it would be good for us to lump it in one issue if there are different legal issues. The law, there are similarities in the law, but there's a different law governing AMLA, there's a different law for the bank secrecy, there's a different law for BIR. So, thank you, Mr.
Chair notes the observation of Senator Judge Alan Cayetano. However, subject, of course, to any agreements that will be arrived at in caucus, we are constrained by the motions filed by the parties. There are only two pending motions that this court should act upon. Number one, a motion for the issuance of a subpoena with respect to bank and AMLC records on the one hand, and number two, a motion for the issuance of subpoena for BIR records. Understandably, there are sub-issues underneath each, but we cannot put to a vote each and every sub-issue under each motion. So we will most likely, and the chair would suggest, put it to a vote by the motions that have been filed by the parties, whether or not to grant it or to deny the motion filed by the prosecutors rather in this case. Again, subject, of course, any agreements we might arrive at in caucus, Senator Judge Allen, and the chair will submit to that. Now, as earlier agreed in yesterday's proceedings, the prosecution will be given 15 minutes for their chief arguments. Likewise, the respondent will be given 15 minutes, and then thereafter, the prosecutor will be given 10 minutes by way of rebuttal, and the respondent will be given 10 minutes by way of rebuttal. May I ask who among the prosecutors or counsel for prosecutors will argue the motion for the issuance of the subpoenas for the banks, AMLC, and BIR?
Your Honors, the prosecution will be represented by the Honorable Representative Chel Jokno for the purpose of this oral argument. Nonetheless, Your Honor, we have some manifestation to make for the prosecution.
The lead prosecutor may proceed. This is pertaining to the matter on hand.
This pertains, Your Honor, to the remaining witnesses for Article 4 threat.
Can we discuss that later before we adjourn, lead prosecutor?
We submit, Your Honor.
Thank you. On the part of the respondent,
The part
who
of the
will argue?
respondent, Your Honor, I will be the one arguing today.
For the record, kindly state your full name, Attorney Poa.
My name is Michael Wesley T. Poa, Your Honor. Thank you.
Your Honor, we're requesting that Congressman Chel Jokno be recognized.
For the prosecutors, the Honorable Representative from the party list Akbayan, Chel Jokno, is recognized for his oral arguments on the motions, twin motions that they filed. You are recognized, sir, and you may proceed when you're ready. You have 15 minutes.
Thank you, Your Honor. Good afternoon, everyone, to the members of this honorable court. May it please the court. Simple lang po ang isyong kinakaharap natin ngayong hapon na ito. Pero napakabigat. Bubuksan ba natin ang pinto ng katotohanan o haharangin ito? Ang hiling ng prosecution ay mailabas ang buong katotohanan so that this court may know the truth, the whole truth, and nothing but the truth, and make its decisions based on that. That is why we have requested the issuance of subpoena duces tecum for the bank records, tax records, and anti-money laundering council reports relating to Vice President Sara Duterte and her husband, Attorney Mans Carpio. Sa pamamagitan nito, may lalahad ang buong katotohanan tungkol sa mga alegasyon sa Article 2 ng Articles of Impeachment. Una, na pinayaman ni Vice Presidente ang kanyang sarili ng labis-labis sa kanyang legal na sahod at lehitimong kita bilang isang lingkod bayan. Pangalawa, na meron siyang mga ari-arihang hindi dineklara sa kanyang Statement of Assets, Liabilities, and Net Worth. At pangatlo, na habang siya ay nanunungkulan bilang Vice Presidente, nakibahagi siya sa negosyo, directly or indirectly, kahit ipinagbabawal ito ng ating konstitusyon. Sasabihin marahil ng depensa na walang kapangyarihan ang hukumang ito na busisiin ng mga bank records, tax records at AMLA reports ni VP Sara. With all due respect, that argument is not only legally flawed, it is an affront to the authority of this honorable court. Kung tatanggapin po natin ang argumentong ito, hahayaan natin maliitin at insultuhin ang hukumang ito. The Constitution, Your Honors, please, vests this impeachment court with extraordinary powers. Tanging ang hukumang ito lamang ang may kapangyarihang magpasya kung ang mga pinakamataas na pinuno ng ating bansa ay karapat-dapat pa rin manungkulan. Because this power comes directly from the Constitution, no one, no person, no law, no administrative rule can limit or supersede it. I repeat, nothing and no one can handcuff this court's power to try and decide this impeachment case. Kahit ang bank secrecy law po ay sumusunod at tumatalima sa impeachment court. The law explicitly states, and I quote its pertinent portions, all deposits are hereby considered as of an absolutely confidential nature except in cases of impeachment. Walang kaduda-duda, may karapatan at kapangyarihan ng impeachment court na busisiin ang mga bank records ni VP Sara. Hindi rin po hadlang ang Data Privacy Act. The law itself affirms that confidentiality shall not apply, and I quote, should the personal information be needed pursuant to a subpoena duly issued. Muli, walang kaduda-duda. May karapatan at kapangyarihan ng impeachment court na ipasubpoena ang mga dokumento ni VP Sara Duterte. Pero sabi po ng kampo ni Vice President, irrelevant daw ang mga bank records, AMLAC reports at BIR records. Lalo na daw yung mga transaksyon na nangyari bago siya umupo bilang pangalawang Pangulo dahil wala raw itong kinalaman sa kasong ito. The prosecution respectfully but vehemently disagrees. Ayon sa report ng Anti-Money Laundering Council na isinumite sa Committee on Justice ng House of Representatives, the financial activity of Vice President Sara C. Duterte increased significantly starting 2007 when transaction values surged to 208.15 million pesos. According to this report, which is marked as Exhibit P-2-7-8, I quote, financial movements intensified between 2009 and 2013 with consistently high totals exceeding 400 million pesos, including notable peaks in 2009, 704.93 million pesos, 2010, 648.58 million pesos, and 2011, 597.15 million pesos. Si VP Sara po ay nanungkulan bilang Vice Mayor ng Davao City mula 2007 hanggang 2010. Naglingkod naman siya bilang Mayor ng Davao City mula 2010 hanggang 2013. From 2007 to 2013, ayon sa records ng AMLAC, lumampas sa 3 billion pesos ang kanyang financial activity. May kinalaman ba ito? Ito ba ay relevant sa Article 2 ng Articles of Impeachment, which alleges, among others, that VP Sara betrayed the public trust and culpably violated the Constitution when she amassed unexplained wealth manifestly disproportionate to her lawful income? Para sa prosecution, malinaw ang sagot. The Vice President's financial activity as Vice Mayor and Mayor of Davao City relates directly to the main fact in issue in this case, her fitness or unfitness to serve as Vice President. Let me explain. The framers of the 1987 Constitution added betrayal of public trust as a ground for impeachment, and I quote, to include all acts which render the officer unfit to continue in office. For this honorable court to determine whether VP Sara Duterte is unfit to continue in office, it must have a clear picture of the respondent as a public servant. Kailangan makita ng publiko at ng mga senator judge ang tunay na kulay ng vice-presidente at larawan ng kanyang buong pagkatao bilang isang lingkod bayan. If she amassed staggering amounts of unexplained wealth while she was a vice mayor and mayor, doesn't that say a lot about her unfitness to serve as a vice president? Isn't that relevant to the question this court must resolve at the end of this trial of whether or not the vice president betrayed the trust given to her by the people? From what I have gathered and read, Your Honors, please, this is not the first time this court has been confronted with this issue. Sa impeachment ni dating Chief Justice Renato Corona, tinanggap ng hukumang ito ang mga ebidensyang nakalap bago pa man siya naupo bilang punong hukom. I believe it was then Senator Judge, now presiding officer Francis Escudero, who raised the question, will the impeachment court consider only Corona's acts as Chief Justice? This after observing that some exhibits predated his appointment as Chief Justice. This matter was taken up in caucus, after which this court decided to allow such evidence. When Philippine Savings Bank President Pascual Garcia III testified before this court in the same Corona trial, he refused to answer the question of then-Senator Judge Franklin Drilon on the starting balance of Corona's 2 peso-denominated accounts. But, if I'm not mistaken, it was Senator Judge Alan Peter Cayetano who said that records of initial deposits are among the quote-unquote opening documents that should have been brought to the impeachment court. After reading the subpoena, presiding officer Senator Juan Ponce Enrile held that Senator Judge Cayetano's observation was correct. During the same hearing, the presiding officer ordered the issuance of subpoena to PS Bank Katipunan branch manager Annabel Tiongson to bring all the bank records of the Chief Justice. A few days later, the impeachment court denied the defense's motion to quash the subpoena for the peso bank accounts of CJ Corona. The presiding officer explained that the purpose of the subpoena is to find out if Corona has not included the deposits in his salin. This court also denied the defense's motion to suppress evidence on Corona's bank accounts. Sa huli, binusisi ng hukumang ito ang bank records ni Chief Justice Corona mula sa kanyang unang balanse bago pa man siya naging punong mahistrado. The panel of prosecutors respectfully submits that the subpoenas for the production of the bank records, AMLA documents, and BIR documents of the Vice President and her husband are proper and should be issued by this honorable court. Now allow me, Your Honors, to return to my first point. There is a deeper reason why this court must resist the attempts of the respondent to exclude evidence that is obviously relevant. It has to do with curtailing the power of this court. The Constitution gives this honorable court, and I quote, the sole power to try and decide impeachment cases. Kayo lang po, Your Honors, ang may kapangyarihang magpasya kung ano ang impeachable offense at kung anong ebidensya ang maaaring tanggapin para patunayan ito. Kinilala ito mismo ng Korte Suprema. In the case of Francisco versus House of Representatives, the Supreme Court declared, and I quote, a determination of what constitutes an impeachable offense is a purely political question which the Constitution has left to the sound discretion of the legislature. Such an intent is clear from the deliberations of the Constitutional Commission. Inulit po ito ng Supreme Court sa kasong Gutierrez versus House of Representatives, where the Supreme Court declared, and I quote, Francisco instructs that this issue would require the court to make a determination of what constitutes an impeachable offense. Such a determination is purely a political question which this Constitution has left to the sound discretion of the legislature. Clearly, the issue calls upon this court to decide a non-justiciable political question which is beyond the scope of its judicial power. Since this impeachment court has the sole power to determine what constitutes an impeachable offense, no one, not the Supreme Court, much less the defense, can impose limitations on that power. No one can dictate to this court how to exercise the exclusive power to decide what constitutes an impeachable offense. In closing, Your Honors, I go back to the most fundamental provision in our Constitution on the accountability of public officers, Article 11, Section 1, which provides, and I quote, "Public office is a public trust. Public officers and employees must at all times be accountable to the people." Ibig sabihin po, sa proseso ng impeachment, ang pananagutan sa taong bayan ang pinakamahalaga sa lahat. Kaya naman po, ang hiling namin sa Korte, gamitin ang inyong natatanging kapangyarihan at karapatan na busisiin ang bank records, tax records at AMLA reports kaugnay ni VP Sara at ng kanyang asawa. Sa ganitong paraan, Your Honors, madedesisyonan ninyo ang kaso base sa buong katotohanan. The truth, the whole truth, and nothing but the truth para sa interes at kapakanan ng sambayanang Pilipino. Before I close, if Your Honors, please, if I have whatever time I have left, may I request that it be credited to my rebuttal. Maraming salamat po.
We will try to do that, Your Honor. You have 1 minute and 39 seconds. And if at all we do so, we shall equally credit it to the rebuttal, if any, of the Counsel for Respondents.
Thank you, Your Honor.
Attorney Powa, if you're ready, you may proceed with your oral arguments on the twin motions filed by the prosecutors. You may proceed, sir, when you're ready.
Thank you, Your Honor.
You have 15 minutes.
Mr. Presiding Officer, Honorable Senator Judges, magandang hapon po sa inyong lahat. The issue before the impeachment court today is not whether you possess the power to issue a subpoena. The real issue is whether such power may be exercised in a manner that disregards due process and compels the production of documents and information beyond what is allowed by law. Your Honors, jurisprudence provides that for a subpoena to be valid, it must comply with twin requirements of 1, definiteness, and 2, relevance. Ibig sabihin po nun, dapat particularly describe po ang nasasaklaw ng subpoena at dapat may direktang kaugnayan sa ginagawang paglilitis. Your Honors, when a subpoena becomes oppressive, when it is unreasonable, and when it is merely issued for the very purpose that there is a hope that somewhere, somehow, something incriminating will come out, it ceases to be an instrument of justice. It becomes a weapon of a fishing expedition. And that is exactly what confronts this very court today. And that is why the defense has taken the position that the prosecution's requests must be denied. Allow me to explain, and let me begin with constitutional points. Our first point, Your Honors, due process. Impeachment is primarily a legal and constitutional procedure with political characteristics. It is sui generis, but it is not a purely political proceeding. Ibig sabihin po nun, the Bill of Rights, especially the due process clause, applies in all stages of the impeachment process. Your Honors, those are not my words. Those are the words of the Supreme Court in Duterte versus House of Representatives. And that is the law of the land. When we speak of due process, we offer a simple proposition that evidence must be present to support each and every accusation. Pero hindi po yon yung nangyari dito. Balikan po natin kung saan nagsimula itong proceeding na ito. I have here with me, Your Honors, copies of the Zabalya and Cabrera complaints, both filed before the House of Representatives. Both accused the Vice President of allegedly amassing unexplained wealth, both with voluminous attachments, yet not one attached a document to support that accusation. Not a single financial transaction record, not even a single SALN. In fact, it was only after these complaints were filed, and more significantly, only after the respondent had filed her answer before the Committee on Justice, that committee started searching for evidence to somehow support these accusations through, again, the issuance of subpoenas. Your Honors, we objected then, and we are still objecting now, because with all due respect, the position of the defense is that is the very definition of a fishing expedition. Your Honors, in our legal system, it is not permitted to accuse now and then just look for proof later on. That is not how due process works. Hindi po dapat natin pinapayagan yan. Moving on to my second point, Your Honors, let's talk about relevance. It is our position that the requests of the prosecution are in fact fatally overbroad. Bakit po fatally overbroad? An impeachable offense is an act or omission committed while the public official is occupying an impeachable office, not before being elected or appointed to such position. Again, Your Honors, those are not my words. Those are the words of the Supreme Court in Duterte versus the House of Representatives. That is controlling, and that is the law of the land. Yet here, Your Honor, today, the prosecution is requesting for documents spanning almost 2 decades, almost 20 years, dating as far back as 2007. Your Honors, it is a fact na noong 2007, ang respondent ay vice mayor pa lamang. Definitely not an impeachable office, Your Honors. How is that relevant? It is the position of the defense that it is not. In fact, what that is an unlimited search throughout a person's financial history. That should not be allowed. Your Honors, if a subpoena is not narrowly tailored, it is oppressive. For these reasons alone, we are of the position that the request should already be dismissed. Nonetheless, if the impeachment court were to extend its utmost liberality, which the prosecution have asked for in their memorandum, we'd like to point out, Your Honors, that Congress itself, the Senate and the House of Representatives, enacted laws that specifically prohibit the disclosure of these information that the prosecution is asking for now. Let us go through them one by one. Let's start with RA 9160 as amended by RA 11521, which is the Anti-Money Laundering Act. Your Honors, the prosecution is asking for covered transaction reports, suspicious transaction reports, financial intelligence reports, again, spanning almost 2 decades. However, it is clear under Section 8A, which we are flashing on the screen right now, na bawal po yun. Disclosure is prohibited under this provision, Your Honors. It is in black and white Meron po bang exception? Wala po. Impeachment is not an exception. Had Congress wanted to make impeachment as an exception, madali lang naman pong ilagay yun sa batas. Pero hindi po iyon nagawa. Now, in fact, I also have here copies of the Financial Intelligence Report and another report from the AMLAC, the Information Management Analysis Group, which were already marked as exhibits, Your Honor. And it's in the records of the court. No? Exhibit D2-8-P1, where it says specifically that it should not be the information should not be used as evidence in formal proceedings, Your Honors. Clearly, Your Honors, to compel AMLAC officials to disclose such information would be to compel them to violate the law. Let's move on now to the tax records, Your Honors. Prosecution is asking for tax records, so let's look at the tax code. Section 270 of which criminalizes disclosure of taxpayers' information. Meron po bang exception sa batas na ito? Meron po, but it is limited. Kasama po bang impeachment? Hindi po. That is very clear. Again, Congress wanted to put an exception for impeachment. They could have easily done so, but they did not. Now, Your Honors, let's go to Bank Secrecy Law, RA 1405. The state policy has always been to favor the secrecy of bank deposits, Your Honors. Dito, while we recognize that impeachment is in fact an exception, Your Honors, we submit that this exception is not automatic. Meaning, hindi porket may exception for impeachment, pwede na kaagad natin buksan ang lahat ng bank records na hinihingi ng prosecution. Why? Because, Your Honor, this exception does not dispense with constitutional safeguards. It does not abolish the right to due process. So dapat po, meron pa rin tayong basihan. If you look at the articles of impeachment, wala naman po doon na nagsasabing yung sinasabing unexplained wealth coming from, even if it was an illegal activity, ay pinasok sa isang specific account. In fact, Your Honors, this exception does not automatically mean that we should permit a fishing expedition. Yun nga pong mga bank account numbers na nakaspecify sa request for the issuance of a subpoena, ang aming posisyon po dyan, yan po ay nakalap doon sa illegal disclosure, with all due respect, na ginawa ng AMLAC before the Committee on Justice. And then, Your Honors, they're also asking for the bank records of the spouse. Your Honor, the spouse is not an impeachable officer. And therefore, the spouse is not covered by this exception. Again, Your Honors, we should not allow this. In closing, Your Honors, the prosecution has repeatedly invoked accountability. Your Honors, we agree with them. No one is above the law. But in the same manner, no one must fall below or be outside the protection of the law. Impeachment is indeed a powerful constitutional tool. But, Your Honors, impeachment is not a magic word or a magic wand that one can just wave to transform an illegal act into a legal act, to transform unlawful access to lawful access. That is not what the Constitution contemplates. That is not what the laws enacted by Congress contemplate. And that is not something that the Honorable Impeachment Court should allow. We submit, Your Honors. Thank you very much.
The gentleman still has 2 minutes and 48 seconds, which we shall credit, similar to the request of the prosecutor. to your sir rebuttal should you desire to use it, counsel for the respondent, Attorney Paul.
Thank you, Your Honor.
Counsel, for the prosecutor is recognized. Attorney Chel Jokno, you have 11.38 minutes, which will round off to 12 minutes, counsel. You may
Thank
proceed
you.
when you're ready for
Thank you.
for your rebuttal.
Maraming salamat po, Mr. Presiding Officer, at magandang hapon po ulit sa ating lahat. Let me address each of the points that the defense has raised in their oral argument. Sabi po nila una ay due process daw ang isang paulit-ulit na dinidiin ng defense. But there's no debate that due process applies in this proceeding, just like in any other proceeding. The real issue before this honorable court is, will the subpoenas that we are asking be issued by this court actually deprive the respondent of any form of due process? Ang aming paniwala po ay hindi. And allow me to explain why. First of all, we are not yet at the stage where any evidence is being put in the trial or offered to the honorable court. Nandito pa lang po tayo sa punto na kung maari bang ipaproduce natin itong mga dokumentong ito. The defense will have every opportunity to make objections if and when particular exhibits or documents are identified by a witness and offered in evidence. Therefore, wala pong due process violation ang pag-issue ng subpoena. Second, the defense repeatedly cites the case of Duterte versus House of Representatives as, I quote, the law of the land, as I quote, controlling daw yung desisyon na yan. But I must remind the defense of that particular case and why the pronouncements quoted are mere obiter dicta, o kung sa simpleng salita po ay side comment lang. The entire Duterte versus House of Representatives case revolved around a different mode of impeachment. Kung maalala po natin, yan yung at least one-third na members of the House ang nagsampa ng kaso. And the entire decision discussed how due process should apply to. Totoo, may sinabi ang Supreme Court tungkol sa mode na ginamit po ng complaints. Pero hindi po yun ang issue sa kaso ni Duterte. That issue is just a side bypass or incidental declarations of the court that are not controlling and are not the law of the land. And if you look mismo at the decision of the court, they expressly said, we are speaking of due process in relation to how these proceedings reached the Senate as an impeachment court, not this kind of procedure. Second, paulit-ulit din po nilang sinasabi na ang ginagawa po ng prosecution ay fishing expedition. Actually po, meron ng desisyon ang Supreme Court that addresses squarely this point. This case involved a case of unexplained wealth, the case of Republic versus Rabusa, GR 208183, decided August 31, 2022. Just like here, the prosecution in that case requested subpoenas for the production of bank records. Prosecution in that case requested subpoenas for the production of bank records. Just like here, the argument was raised that this is a mere fishing expedition. In fact, hanggang sa Court of Appeals, ang sabi po ng Court of Appeals ay fishing expedition lang po yan. But please allow me to read just a portion of what the Supreme Court held here. I quote, "The Court of Appeals resolved that the bank accounts of Rabusa et al. Were protected under Republic Act 1405, that is the Bank Secrecy Law. Given the arbitrary demand to disclose the contents thereof, the Court of Appeals considered the inquiry as a fishing expedition to utilize evidence against Rabusa et al." In the instant case, given that the court orders in the form of various subpoena duces tecum and ad testificandum all involve the forfeiture of unexplained wealth, the RTC was in error for not allowing petitioner to examine, inquire, and look into the subject accounts. I continue. As the present proceedings on unexplained wealth are now encompassed within the exceptions of Republic Act 1405, the court orders subject of this case clearly fall within the orders that would enable the examination of the respondent's bank accounts as contemplated in the first exception. Thus, it comes clear that this court cannot sustain the RTC's and Court of Appeals theory that there was no court order authorizing the examination of the bank accounts. On the contrary, records prove that the RTC issued several subpoena duces tecum and ad testificandum, which required certain persons to testify in open court and present documents which pertain to the existence and identity of the subject accounts and also to the accounts, the contents found therein. I just move forward. Given the existence and propriety of the subpoenas, the evidence procured through the same should have been duly considered by the lower courts. This court cannot agree with the Court of Appeals' supposition that the examination of the respondents' bank accounts was but a mere fishing expedition to pin liability on them. Next, the defense repeatedly cites a number of laws to claim that the requested information and documents
Po
that we
nila,
are asking from this
confidential
court,
daw ito sa ilalim ng
conditions of
Republic Act
something that
1405.
are confidential.
Sabi po nila, confidential
Sabi
daw
po
ito
nila,
sa ilalim ng
confidential
Anti-Money
daw ito sa
Laundering Act,
ilalim ng Republic
pati
Act
ang National
1405.
Internal Revenue
Sabi po
Code,
nila,
pati
confidential
ang
daw
Data
ito sa
Privacy
ilalim ng
Act
Anti-Money Laundering
ay
Act,
confidential
pati ang
din.
National Internal Revenue Code,
Pero kung
pati ang
titingnan po
Data
natin,
Privacy Act,
klaro po
ay
at malinaw
confidential
po
din.
sa amin ang batas
Pero
at
kung
ang
titingnan
utos
po
ng
natin,
salitang batas
klaro
sa
po at
impeachment
malinaw
court
po
na ito.
sa amin ang
You
batas
have
at
the
ang
sole
utos ng salitang
exclusive
batas
power
sa
to
impeachment
determine
court
an
na ito.
impeachable offense,
You
and that
have the
includes
sole
the
exclusive power
to find
to
out,
determine an
ferret the
impeachable
entire
offense,
truth, and make
that
your decision
includes
on
the
that
power
basis.
to find
I
out,
will not dwell
ferret
on
the
the
entire
exception
truth,
to
and make
Republic
the
Act
decision
1405.
on
That's
that
very clear.
basis.
There's an
I will not
exception for
dwell
impeachment.
on the
Pero paano
exception to
naman po
Republic Act
yung sinasabi nilang
1405? That's
Section
very clear.
8A
There's
ng
an exception for
Anti-Money Laundering
impeachment.
Law?
Pero paano naman po
If
yung
you read
sinasabi nilang
that
Section
law,
8A
particularly
ng
that
Anti-Money Laundering
provision,
Law?
it clearly refers
If you read
to prohibiting
that law,
leaks by
particularly that
members of the
provision,
Anti-Money Laundering
it
Council.
clearly refers
It never
to
was
prohibiting
intended
leaks
to
by members of the
short-circuit
Anti-Money
the
Laundering
impeachment
Council.
process
It
or
never was
limit the
intended
powers of
to
this honorable
short-circuit
court to
the
find out
impeachment
the truth.
process or
Ganon din
limit
po
the powers
ang nakalagay sa
of this
ating
honorable
National
court to
Internal
find out
Revenue
the
Code.
truth.
Sabi po ng
Ganon din
defense,
po
there's nothing that
nakalagay sa
allows
ating National
these
Internal Revenue
documents to
Code.
be made public.
Sabi po
I
ng
cite
defense,
Section
there's nothing
71,
that allows
NIRC.
for documents to be
After
made
the
public.
assessment shall have
I
been
cite
made,
Section
I just move
71,
forward.
NIRC.
The returns, together with any
After
corrections,
the
shall be
assessment
filed
shall
in
have
the
been
office
made,
of the
I'll just move
Commissioner,
forward.
and I quote, and shall
The returns,
constitute
together with any
public
corrections, shall
records
be
and be
filed in the
open to
office of the
inspection
Commissioner,
as such
and I quote,
upon the order
and
of
shall
the President.
constitute
And in
public
fact,
records
during
and be
the
open to
Corona
inspection
impeachment trial,
as such
the
upon the
President at
order
that
of
time
the President.
did
And in
order,
fact,
and
during
that is
the
why
Corona
this court
impeachment
admitted
trial,
the
the President
PRR
at that time
documents.
did order.
Your Honors, madaling sabihin na confidential ang ilang impormasyon at dokumento. Madaling magturo ng batas. Pero ang hinahanap po ng impeachment court ngayon at sa mga susunod na araw,
Pero ang
linggo at
hinahanap
buwan,
po ng impeachment
ay ang
court
katotohanan.
ngayon sa
At
mga
ang
susunod
layunin
na araw,
ay makamit
linggo at buwan,
ang pananagutan.
ay ang katotohanan.
Confidentiality,
At ang layunin ay makamit
Your Honor,
ang
should not
pananagutan.
be the prevailing principle
Confidentiality,
in this proceeding.
Your Honor, should not
Hindi po
be the
confidential
prevailing
ang
principle
katotohanan.
in this
Maraming salamat po.
proceeding. Hindi po confidential
Thank you,
ang katotohanan.
Representative, the Honorable
Maraming
Chel
salamat po.
Jokno. Attorney Poe,
Thank you,
counsel for respondent is recognized
Representative
for his
Honorable
rebuttal.
Chel
Sir, you have 13 minutes.
Attorney
Thank you,
Poe,
sir. I will
counsel
not
for
take up the
respondent is
entire time
recognized
to
for his
expedite
rebuttal.
matters.
Sir, you have 13
Your Honors, I
minutes.
respect, of
Thank you,
course,
sir.
the
I will not
arguments
take up the
put
entire
forth
time
by
to
the
expedite
distinguished
matters.
opposing counsel.
Your Honors,
But
I
when it
respect,
comes to
of course,
due
the
process,
arguments
Your Honors,
put forth by
I
the
think
distinguished
it's beyond
opposing
debate,
counsel.
no? That
But
due
when it comes
process
to due
must be
process, Your
observed
Honors,
in every
I
stage
think
of the proceedings.
it's beyond
And
debate.
aside
that
from
due
that,
process
due process
must be
requires,
observed
Your Honor,
in
that
every
we
stage
also
of the
respect the
proceedings.
protections
And aside
afforded
from
by
that,
law
due
on the
process
respondent.
requires, Your Honor, that we also respect the protections afforded by law on the respondent. Your Honors, ang sabi po ng ating distinguished opposing counsels, obiter lang daw po yung sinabi ng Supreme Court. But Your Honors, nung sinabi ng Supreme Court sa Duterte versus House of Representatives na ang impeachable offense is an act or omission that is committed by a public officer while occupying an impeachable office, hindi naman po siguro pwede doon lang sa yung one-third mode gamitin yung ganong definition, pero pagdating po sa ibang mode ay hindi na po applicable yung ganong definition. Your Honors, in fact, in that decision, which I failed to mention earlier, sinabi rin po that the acts or omissions must be done in relation to the office. Kasi yun nga po ang purpose ng impeachment. Next, Your Honors, yung sinasabi na dapat kahit na may mga prohibition sa batas, pwede pa rin nating masapina para ma-examine. Your Honors, it is the wisdom of Congress kaya po may ganung mga prohibitions against disclosure under the law. Kung papayagan po natin that a court process, even an impeachment court, can issue a subpoena to thwart those provisions, it's as if, Your Honor, we are doing judicial legislation here because a judicial issuance can easily repeal for the time being that provision or at least suspend, Your Honor. Maybe not repeal. Properly, the proper word might be suspend that provision of law. I've never heard about that, Your Honors. And then lastly, Your Honors, parati nating sinasabi rin, no? Two points. Yung nabanggit na Section 71. I agree po under the tax code that Section 71 provides that if the President orders, then nawawala na po yung confidentiality. However, Your Honors, even given that there's an order from the President, I think we should still think about the relevance. Para saan ba ine-examine yung mga dokumento? Hindi ba para sa impeachment proceeding? Hindi po namin sinasabi na kung sakaling nagkamali man ang Vice Presidente, kung sakaling may paglabag man sa batas ang Vice Presidente noon, ay hindi na pwedeng maparusahan. Marami naman pong paraan. You can file cases against the Vice President for those infractions, preterm infractions. Pero pag impeachment po ang pinag-uusapan, we are limited to what impeachable offenses are. And again, the Supreme Court is clear about that. Your Honors, there's also a repeated citation of the Corona case. But we would just like to point out that the Corona case was tried, decided upon way before Duterte versus HOR. And Your Honors, since it was decided before Duterte versus HOR, the Supreme Court was fully cognizant of what happened in the Corona trial. And yet, Your Honors, they imposed these guidelines. In fact, the line itself in the Duterte versus HOR is we clarify, I quote, we clarify the constitutional requirements of impeachment. At kasama doon yung nabanggit namin kanina on what constitutes an impeachable offense. And that is very clear. Marahil, sinasabi natin na yon ay isang obiter, pero Your Honors, paano po magiging obiter yon? Kung yun mismo ang itinakbo ng desisyon. The fact that the one-year bar was triggered was only the effect of not abiding by the due process clause of the Constitution. And lastly, again, Your Honors, we do not disagree with the prosecution in terms of accountability. Again, no one is above the law, but no one should also be deprived of the protection
given by law, Your Honors. Thank you.
Bago mag-recess ang mga senator judges para mag-usap sa caucus, nais kong sambitin sa record na binabati ko ang magkabilang panig, partikular si Congressman the Honorable Chel Jokno, gayon din si Attorney Poa, sa isang mahinahon, malumanay, maginoo at magalang na diskurso at debate kaugnay sa may tuturing nating kontrobersyal na isyong ito. At inaasahan ko, yan din ang magaganap sa caucus at sa aming pagbabalik matapos nito. Senator Judge Alan Cayetano is recognized.
Thank you, Presiding Officer. Very eloquently said. Before we go to our favorite subject, recess, the prosecutor was going to say something about Monday witness. Can we hear that? Because if I don't want to preempt, but can we hear that? Because if they're not going to have witnesses on Monday, I have a proposal.
I'm sure they will. They were in fact on the verge of announcing it.
No, because, Mr. President, this is what I wanted to say. We do need the caucus, but after hearing both sides, I really have many questions, and I think we should really dapat mahimay. But after hearing them, I think there's a couple of issues we will agree on, but I'd rather ask my questions on Monday. So if everyone agrees, then we can caucus but allow them to adjourn, no? Unless someone wants to ask after our caucus.
We will hear the lead prosecutor. However, Senator Judge Cayetano, it is the predisposition of the presiding officer, given that we don't have any witnesses today to settle this matter and this issue today. That's the only matter for us to discuss anyway.
That's my point, Senator Judge. No, I'm reviewing the rules. Hindi naman tayo tatagal pag per legal issue kasi nakalagay naman not more than 2 minutes. So, meaning for example, for me, issuing the subpoena is not one issue. Whether the subpoena is to the VP or to her husband is two separate issue. Peso account or dollar account is a separate issue. Whether or not the company's accounts, etc., should be subpoena is a different issue. But for me to decide, I want to ask the prosecution and the defense about that. So medyo mahaba-haba talaga.
To answer the Senator Judge, we have a precedent that I think, if I remember correctly, it involves the good gentleman himself. When then Senate President Enrile made a ruling with respect to the request for the issuance of a subpoena against the former Chief Justice Corona and his family, the gentleman agreed with respect to not issuing the subpoena against the Chief Justice, but disagreed with respect to not issuing with the family.
No, I was correct there. That was the first. The rules of court says pwede pagka son-in-law, but I was overruled by Senator Enrile. I appealed. The body agreed with him. So even if I was correct, I was overruled. But my point is, Mr. Presiding Officer, that was one simple issue. That's why I didn't argue. I'm saying this seems to be like 2 subpoenas. But there are several subject matters, AMLA, etc. And remember, this is Article 2. What's our assumption? August or September pa to iti-take up eh. So I'm just saying, so for example, no, we all agree on the ruling. It benefits one side. We should tell them why we ruled that way so that if they file a motion for reconsideration or they go to the Supreme Court, malinaw din yung ruling natin doon. There are substantive issues here. There are some issues, as eloquently said by Congressman Chel Jokno. Alangan namang bago ako ng stand kung pare-pareho yung issue about, let's say, bank account. So, you know my vote on that, di ba? But my vote on Chief Justice Corona doesn't mean it's the same vote if it was on his spouse and the companies that are under his name. I can tell you honestly right now, I don't know what to vote for, what my vote will be. But I do know that these are 2 important issues. Even the definition of definiteness
and the definition of fishing expedition, I want to pursue that with them.
With the
Your
permission of
Honors.
Senator Judge Allen, can we discuss that in caucus?
Yes, yes. So I'm just saying, if we're going to discuss it and maraming magtatanong, do you want them to go home and we can extend till Thursday next week or whatever?
No, not at this time.
Okay.
We can advise
Yeah, I
them
submit
properly
to the presiding
at the
officer.
appropriate time. Senator Judge Pangilinan.
Now, just to reiterate the earlier manifestation of the presiding officer, we agreed to go on caucus after the presentation
Yes.
after the oral argument. So let us stick to the agreement, Mr. President, Mr. Presiding Officer. Thank you.
Umaasa pa rin ako na maging mahinahon yung caucus.
So we move to
Chair declares a recess. We will advise the parties as to what time we will most likely finish once we know that we are in the process of winding up. In the meantime, kindly relax and study the next witnesses you will be presenting. Trial is on recess. For the information of the parties as well as the viewing public, in caucus, the senator judges agreed to study the matter more, given that not everyone has actually completed reading the memoranda given by the parties and submitted by the parties, and given that they want more time to look into the complicated issues involved in these two motions for the issuance of subpoena. The senator judges agreed in caucus to decide on the matter on Monday, and that on Monday, senator judges who wish to ask the
On
parties
both
questions will be afforded the time to ask. Following our rules, it shall be 10 minutes per senator, not exceeding 1 hour for each side. At this juncture, may now recognize the lead prosecutor, the Honorable Luistro. As I understand, she intended earlier to make a manifestation with respect to their intended witnesses on Monday. Kindly already exclude Monday, Honorable Luistro.
Yes, Your Honor. First of all, we would like to acknowledge the positive response of the Honorable Impeachment Court to our previous manifestation. Accordingly, we would like to reiterate that the prosecution will no longer be presenting Attorney Zuleika Lopez as well as Captain Belinda Bello. Reiterating, however, the same concern on redundancy, surplusage, and lack of necessity, the prosecution further manifests that we will not be presenting as well the following witnesses for Article 4, that is threat. Number 1, Your Honor, is the Philippine National Police Firearms and Explosives Office representative. The witness intended to testify that the respondent owns firearms, including the high-powered ones, which demonstrate the capacity and capability to execute the threat. On the other hand, Your Honor, it has been shown already that the government took seriously the threat. As a matter of fact, it prompted the full-scale investigation, including the recommendation to file a criminal complaint. Number 2, Your Honor, is Mikel Flores and Bons Magsambol. They belong to the press who were present during the November 23 video conference. They will be testifying that they were among the reporters or media persons who were present during the video conferencing, and to the fact that they heard the respondent utter the threat against the President, the First Lady, and the former Speaker. On the other hand, Your Honor, the testimony of Agent Calilong already established that the video is authentic, plus, considering, Your Honor, the defense's subsequent admission that the same are authentic videos, Your Honor. Number 3, Your Honor, is Sheriff Abe Andres. The witness intended to testify on the 2011 incident pertaining to the violence allegedly committed by the respondent on the sheriff. On the other hand, Your Honor, during the past proceedings, it has been acknowledged by both parties. Particularly, it was acknowledged already that the occurrence of this incident of 2011, so we deem it unnecessary as well to present this particular witness. Number 4, Your Honor, is the family member of a victim of threats. The witness intended to testify on the effect, the gravity, and the seriousness of the threat allegedly committed by the respondent. On the other hand, Your Honor, Attorney Lotto already testified that threat is a private crime and its prosecution does not depend on the complaint, participation, and even the subjective feeling of the victim, including his families. Finally, Your Honor, the psychiatrist. The witness intended to testify on the respondent's state of mind, the nature of the violence in the statement made, as well as the capacity and capability to actually execute the threat. On the other hand, Your Honor, both parties have sufficiently established already the circumstances surrounding the statements made by the respondent in the authenticated video. The same is true with respect to the respondent's own subsequent confirmation of those statements, as well as the testimonies already presented. Your Honor, considering that these 5 witnesses are included in our pre-trial order, Your Honor, we respectfully withdraw their names among the prosecution's witnesses for Article 4 threat. This withdrawal, Your Honor, renders Attorney Melvin Matibag, the NBI Director, as our last witness for threat, who will be testifying this coming Monday. Tuesday, Your Honor. Likewise, Your Honor, the prosecution acknowledges the 5-day notice rule. However, considering that the decision to forgo the testimony of Attorney Zuleika Lopez, as well as that of Captain Belinda Bello, came only after the conclusion of the testimony of Attorney Lotok, plus considering, Your Honor, the earlier manifestation, which will render Attorney Matibag the last witness for threat, we would like to beg the kind indulgence of the Honorable Impeachment Court to note our next witnesses. This will be in support of Article 1, Confidential Fund. And if we will be presenting Attorney Melvin Matibag on Tuesday, then this means that the first witness for Confidential Fund will be presented on July 22, that is Wednesday.
Yes.
Nevertheless, Your Honor, we are requesting that we be allowed to request for the issuance of subpoena for our first 3 witnesses for Confidential Fund. That includes Marivic Pareja of the Legislative Archives Museum Management Service of the House of Representatives, and also, Your Honor, 2 land bank employees, including Violeta Constantino, former branch manager of Land Bank Show Boulevard Branch, and Ninita Camposano, former branch manager, Land Bank, DepEd Branch.
To clarify, Honorable Wistro, this is for the issuance of subpoena ad testificandum only?
Your Honor, the request is for the issuance of both subpoena ad testificandum and subpoena duces tecum.
Kindly submit in writing the motion in order to be able to specify the documents you want to be the subject matter of the subpoena duces tecum. We will await it within the afternoon, even after adjournment, so that we can sign the subpoena by today or tomorrow at the latest.
May I inform the Honorable Impeachment Court that the list or the request for subpoena ad testificandum and duces tecum, the written ones, have been submitted already to the Honorable Impeachment Court, Your Honor.
I stand corrected. Yes, I have it with me now.
Your Honor, may I just enter some correction with respect to the testimony of Attorney Lotok to the act of threat or grave threat. The same is a public crime which does not need a private complainant, and its prosecution does not depend on the complaint participation.
Counsel, before going there, let the presiding officer act on these requests for issuance of subpoena first. The presiding officer hereby grants the request for the issuance of subpoena ad testificandum to Ms. Marivic Pareja to appear on July 21 and 22, to Ms. Violeta Constantino and Anita Camposano, also a subpoena ad testificandum to appear on July 21 and 22, and subpoena duces tecum to Ms. Lynette Ortiz, correct? Of the Land Bank of the Philippines, to appear on July 21 and 22. The aforestated requests for subpoena are hereby granted. Clerk of Court is directed to prepare the corresponding subpoena ad testificandum ducis tecum as the case may be, and for the Sergeant at Arms to be instructed to serve the aforestated subpoenas. As you were saying, Honorable Luistro.
May I just manifest, Your Honor, that with respect to the testimony of Attorney Lotok to threat, the same is a public crime, and therefore its prosecution does not depend on the complaint, participation, and even the subjective feeling of the victim, including that of his family.
What is this about? I think, if I remember correctly, Representative Luistro, the presiding officer stated that also yesterday, that there are only certain private crimes that require the complaint of the victim. And these mostly are private and sexual crimes, such as concubinage, adultery, seduction, abduction, rape, and acts of lasciviousness.
We
These
understand,
are the only
Your Honor.
private crimes that require the signature or complaint of the private complainant.
We understand that, Your Honor, and we in fact submit to the position of the Honorable Impeachment Court, except that this representation misstated the supposed public crime into a private crime, Your Honor.
Noted.
Your Honor.
Before recognizing the counsel for respondent, Senator Judge Aquino is
Just a
recognized.
point of order, Mr. Presiding Officer. With the presentation of the articles and the witnesses, we're tackling all of the articles from the prosecution and then all of the articles from the defense? Or initially, maybe I was mistaken. I thought we would tackle the, per article, prosecution, then defense, prosecution, then defense. Is it all articles, then all articles, Mr. Presiding Officer?
Not a point of order, but perhaps a clarification.
Yes.
But the answer is yes. We will first finish the presentation of the prosecution for all articles before listening and allowing the respondent to present their evidence in chief for all the articles as well. Thereafter, we shall decide by article. After the formal offer of evidence by both parties shall have been made and the final arguments shall have been made of record as well.
All right. Salamat, Mr. Presiding Officer.
Counsel for the respondent is recognized. What is your pleasure, ma'am?
Good afternoon, Your Honors.
Good afternoon, ma'am.
I just have a few, before I express some statement with respect to the discourse that we just heard from the lead prosecutor, may I just clarify, because I don't know if I'm mistaken, but she did mention that they are now withdrawing 5 witnesses under Article 4, namely the Philippine National Police Firearms and Explosives Office Representative, Mr. Flores, Mr. Magsambol, the sheriff, and the psychiatrist.
And one more, the relative of the family of a
Okay.
victim. That would make it 6.
Then that's clarified, Your Honor, because I also heard the lead prosecutor say that Attorney Melvin Matibag will be their final witness for Article 4, and I had neglected to consider the family member listed as one of the reserve witnesses. Thank you for the clarification, Your Honor. But on another matter, this is not an objection, just a statement or a manifestation with the kind indulgence of this honorable
Counsel
court
may proceed.
and the senators, judges. Yesterday, at the conclusion of the hearing, we have heard a manifestation from the good lady, Attorney Kapunan, with some suggestion on how to speedily proceed with the rest of the presentation of the prosecution for Article 4. And I think towards the end of her speech, which was quite lengthy, was really just essentially informing this court about the fact that they will no longer present Attorney Lopez, whom they had requested subpoena for, as well as Ms. Belinda Bello. But my point is, I'm not objecting to the good counsel's manifestation or even the manner by which she delivered it yesterday or the lead prosecutor's manifestations today. Only that my concern is those manifestations are almost always accompanied with lengthy discourse containing conclusions of law and facts that in reality only this impeachment court can really determine. Now, why is this a concern for the defense? Because this affects the fairness and balance of this impeachment court and the way it would perceive whatever manifestations or expressions of sentiments or discourses that counsel for both parties will deliver before this court and before the public. Naririnig po tayo ng taong bayan at anuman ang sabihin ng ating mga kagalang-galang na mga miyembro, no, officers of or members of the bar who also are officers of the court, and we all know that we are before the impeachment court, and therefore we should try evidence and not advocate for the conclusions or the positions that we may have already made even before we went to this trial. And so I'm just expressing a concern on behalf of the defense and just for the guidance of both parties. If the only message that and this goes for both parties, if the only intent really is just to withdraw witnesses, and perhaps it would better serve the purpose of aiding the speedy disposition of this case if that fact alone will, be the only thing that will be mentioned without factual assertions or conclusions of facts or even interpretations of the law. I think that would be more fair for everyone and for the guidance of the public and this court. That's all, Your Honor. Thank you for your indulgence.
May I comment, Your Honor?
No need, counsel. Let the chair react to the statements made by lead counsel for the respondent. The presiding officer took it as the statements as akin to a tender offer of excluded evidence, very similar to that. Although we are not yet at that stage, although evidence has not yet been excluded, the presiding officer took it as that. Therefore, what is your pleasure? I will give it to the counsel for respondent. Should you decide not to call witnesses in your witness list, do you want the same privilege of being able to make a tender, meaning an explanation of why you won't be calling these witnesses? If not, given the fact that it was given already to the counsel to the prosecutors, or we will simply remind both parties to cease from doing so henceforth. I give you the equal opportunity, counsel.
Thank you, Your Honor.
What is your pleasure?
Let me just clarify, Your Honor. With respect to the presiding officer's statement on it, the chair taking the prosecution's manifestations a tender of excluded evidence, we respectfully disagree, because if this is a tender of excluded evidence, as the presiding officer had said, there was, number one, there's no excluded evidence because, number two, they never offered it in the first place, and number three, they didn't, in fact, withdrew the presentation of these 5, 6, or 7 remaining witnesses that they listed in their pre-trial brief. Number two, Your Honor, I'm not actually asking for any special treatment or privilege or even the same amount of time that were given to the lengthy manifestations and discourses by members of the prosecution. All I'm asking is if the parties may be guided and from making conclusions of law that in fact really just advocate the position, because I think we all agree that at no point during this trial that the prosecution and defense will probably say, I agree with you on this point of evidence or on this point of law. I think mahalaga nating maintindihan yun, because the prosecution clearly has taken side, defense taken side, and we are advocating for totally divergent views and opinions. All I'm asking, Your Honor, is that if the intent truly is to aid this court in speedy disposition of this case in a fair and balanced manner, just so also with the considering that we are being watched by by the people, no? Yung ating mga mamamayan na sa tingin ko gusto rin nilang matuto mula dito sa paglilitis na ito sapagkat sila interesado rin sa kung paano ba pinapagana ang batas sa bayang ito at kung paano pinatutupad yung mga karapatan, no, ng mga tao at kung paano binibigyan ng pantay na halaga yung prosekusyon at depensa. All I'm asking is, if the intent is just to say, we're withdrawing, then that's it. Just state the intent and then without any conclusions, Your Honor, because conclusions really are just for the courts to make and not for either of the parties. Thank you, Your Honor.
So noted, as the court said, it is akin to and not exactly a tender offer. Therefore, the court will now remind both parties to kindly limit any such manifestations on the withdrawal or change on the withdrawal of their witnesses, to kindly limit it to the withdrawal of such witnesses, and it applies to both sides,
Thank you,
both the
Your Honor.
prosecution and the respondent side, should that time come on the part of the respondent. So ordered. Any other matters to be taken up?
Thank you, Your Honor. None from the defense, Your Honor.
Quick manifestation, Your Honor.
I'm sorry?
Quick manifestation, Your Honor.
Yes.
Just to respond to the manifestation of the defense.
Yes, the Honorable Luis.
Nais ko lamang pong ipaalala sa ating mga kababayan, this is a constitutional process. This is of paramount of importance. And therefore, providing the reasons for the withdrawal of these witnesses need to be communicated as well to the viewing public, Your Honor. Kailangan pong maintindihan ng ating mga kababayan ang naging hakbang ng prosekusyon kung bakit wini-withdraw ang mga pangalan ng ibang testigo para sa Artikulo 4, and that is threat. That is for the record only, Your Honor.
Noted. Court already made a ruling. Senator Judge Cayetano.
Mr. Senate President, Mr. Presiding Officer, I agree with you both, and there's a solution to that. Let me start by I agree with the defense. Actually, I was going to stand up yesterday, but with all due respect to a good lawyer, Attorney Kapunan, and to the fact that my seatmate, Senator Miggs, was very proud of her, saying that she's his ninang, I did not stand up anymore. The problem with explaining why you're withdrawing is actually you are feeding to the court something they did not testify to, and then something the defense cannot object to. So, and if it is a proffer or a tender, it is clear to everyone, in-exclude yon. Kaya ko nga lang nilalagay. But tama naman si Presiding Officer, it's akin, it's not the same. But dun kasi sa tender, nag-ruling eh. So it's very clear to us it's unacceptable, di ba? So after the very eloquent manifestation of Attorney Kapunan yesterday, if I was a layman, I would think what you said, whether it was the agent John Mark, whether it was the second witness sa NBI, was true. Kasi parang may summation. The same thing with you, the very able lead prosecutor and chairperson of the House Committee on Justice, di ba? Having said that, I agree with you, this is an impeachment court. People have to know why. But I think we've been very lenient. No one except the spokesperson has spoken about the sub judice rule. So you can actually explain it in the press con afterwards, if I may, no? Because nga, I was also observing yesterday and I was saying, kung ako yung defense, dadagdagan ko na yung witness ngayon at every time i-withdraw, may chance akong i-explain bakit wini-withdraw, then reinforce kung ano yung sinabi nung before. So I understand you completely, ma'am. People have to understand why it's not a sign of weakness. In fact, in your it's a sign that you've achieved your position. But we can do that in the press cons and other forums. But if you do it kasi here, walang chance yung prosecution to rebut that. Or if they do, it's one rebutting the other rather than the witness standing. So if I may offer that solution, Mr. Presiding Officer.
As ruled by the presiding officer, henceforth, that will no longer be allowed. Senator Pangilinan, Senator Judge Pangilinan, before Senator Judge Pia Cayetano.
Yes, just a very quick manifestation. I was actually listening to the ruling of the presiding officer, and initially I thought he would rule that the defense would likewise be given the opportunity to speak up. And at some point, when they likewise have the opportunity to withdraw witnesses, I would like to think, Mr. Presiding Officer, that would have been the better approach, because this is an impeachment court. This is not, we are not bound by technical rules, unlike court proceedings where lawyers are familiar and would really want, to make it as orderly and as technical as possible. But again, I will yield to the ruling of the chair, but just a reminder to everyone that technical rules of evidence does not apply strictly in impeachment court proceedings. Precisely because nakikinig ang taong bayan, pagka-technical masyado, na sa halip na lumalabas ang bawat punto. Hindi ko sinasabing hindi dapat magsalita ang defense. In fact, yun ang original o initial na suggestion at minumungkahi ng ating presiding officer na kung gusto magsalita ng defense din para tapatan yung nabanggit ng prosecution, mas maganda sana. But I will yield. I just wanted that manifested, and I will yield to the ruling of the chair.
We thank the good gentleman for his understanding and magnanimity. Given that counsel for respondent did not want the same benefit, it also saves on the court time, and as pointed out by Senator Judge Allen, these words can be best expressed outside this court, so that we can manage the court's time better, given that they have both parties have their respective spokespersons to discuss these matters. Counsel for respondent, you wanted to be recognized?
Yes, Your Honor.
Yes, ma'am.
May I just very briefly, so that I won't take any more time of precious time of the court and our everyone who's here. With just a brief response to the lead prosecutor's counter manifestation that this is because this is a constitutional procedure. We understand that. When we came here, mulat ang aming mga mata na pumunta rito at alam namin na ito ay isang constitutional mekanismo. Kaya nga, yung sinasabi ko kanina at ang aking kahilingan lamang ay nakasandig doon sa prinsipyo na iyon na dahil ito ay isang constitutional mechanism, kailangan siguraduhin natin na balanse at patas yung lahat ng magaganap. At hindi ko, I find it difficult to understand how manifestations containing assertions that are laden with conclusions and personal advocacy, and obviously one-sided advocacy of either parties, would help the court arrive at the proper determination of whether the respondent is guilty or not guilty of the charges contained in the articles of impeachment. Hindi rin po ito in response po to our just good Senator Pangilinan, hindi po technical na or rules, no, yung aking ini-invoke dito, kundi yung actually it's substantive dahil ito ay nakasandig sa ating saligang batas. Salamat po.
Noted. Senator Judge Pia Cayetano is recognized. What is your pleasure, ma'am?
I would just like to support the ruling of the presiding officer, cautioning the both prosecution and defense. I too noticed the esteemed Attorney Lorna Copunan's lengthy explanation on the withdrawal of the witnesses. But because she is Lorna Copunan, nakikinig ako in the same way na even if I don't know some of your names, makikinig ako sa inyo. Rest assured. I think it's her first time to also stand up. So I was being very patient in listening to her. But I did take note of some statements that sabi ko parang conclusions na to or excessive explanation of of her observations which I didn't think were proper. So, okay naman, okay na yon, tapos na yon, pero moving forward nga, Mr. Presiding Officer, I agree with you. And I just need to put this on record kasi nga, sinasabing wag tayo masyadong technical. Pero, to a certain extent, kailangan naman ho natin, tingnan naman yung rules natin kasi, maayos ho tayo, di ba? So, I want to read into the record. This might be a paraphrase na nung sinabi niya, ha, kasi sinasummarize namin ng team ko yung statements. And anyway, di ko na mahanap sa phone ko dahil kahapon pa yon. But I recall, no, and feel free to correct me, but this is a minor thing naman. Parang dinescribe niya kung bakit hindi na daw papupuntahin si Attorney Lopez. Kasi naman daw, napakita na daw ng defense yung video kung saan siya ay crying and complaining. So observations na po yun ni Attorney Kapunan. Hindi po siya ang witness. Hindi po siya ang dapat nagsasabi sa judges na crying and complaining yung isang testigo. Trabaho po yun ng abogado na i-elicit yon dun sa witness na mapepresenta doon. So yun po yung reason kung bakit hindi hupe pwede yun. We're not being technical, but neither of the lawyers here are allowed to stand up and be the one to explain what you are experiencing. That is the job that is for the witness to do. Your job is to ask the witness questions. Yun. So to be clear, it's not being technical, but it's making sure that magawa niyo yung trabaho niyo na maayos at magtanong tayo ng maayos sa witnesses. Kung di na pala siya papupuntahin, no need na to say kung ano yung na-observe. Kasi nga, hindi na ho sa inyo yon as lawyers. Yun lang naman po. Again, my utmost respect for Attorney Kapunan and to all of you. You're all doing a great job. Like I said, once in a while, we will be called out. Even I tell the presiding officer, call me out pag sumobra ako, pag medyo nag-exceed tayo ng authority natin, because we're all just trying to do our jobs here. So thank you again, everyone, for your time and patience. Thank you, presiding officer.
Chair, in humility, accepts the presiding officer's lapses in this regard, as twice pointed out by Senator Judge Pia Cayetano already. The chair will be more mindful in the future, but I also ask the parties to also be equally mindful in case the chair forgets or is not unable to point it out on the part of either party should this happen again. Any
Quick
other points?
manifestation, Your Honor.
Hindi tayo titigil niyan, Jervel, sinasabi ko sa'yo. Yes,
I just want to
one
put
last
on record, Your
manifestation
Honor.
from the Honorable Luistra without prejudice to another manifestation from Counsel for Respondent.
Thank you,
I
Your
just
Honor.
want to manifest, Your Honor, that the Honorable Impeachment Court has been very much fair in as far as this issue is concerned. As a matter of fact, the presiding officer even asked the lead defense counsel if she would like to avail of the same opportunity to explain the reason for the withdrawal in the event the defense would be withdrawing likewise their witnesses. Also, Your Honor, may I just add, and with all due respect to Honorable Senator Pia Cayetano, the intention of the prosecution is never to abuse the time of the impeachment court. It is never to influence the senator judges, neither is it to influence the viewing public. The explanation was a statement of the position of the prosecution, and of course it is anticipated that the same is adverse to the other party because it is apparent that we are in the prosecution side while the opposing counsel is on the defense side. But nonetheless, let me reiterate and put on record, Your Honor, the purpose is not to influence the senator judges, neither is it to influence the viewing public. It is only a statement of position of the prosecution for withdrawing the names of the prosecution's witnesses, Your Honor.
Noted, and the ruling of the court stands on the matter.
Just a
Counsel for Respondent.
brief counter manifestation, Your Honor. I thank the lead prosecutor for mentioning that the same courtesy was earlier offered to the defense with respect to providing lengthy discourses or manifestations before this court. But I think the point essentially that I'm trying to make is that we're not asking the court for any advantage. What we're merely asking is fairness. That's all, Your Honor. Thank you.
Same answer, noted, and the court stands by its ruling. Any other matters to be taken up from the senator judges? There being none, no other business to be taken up, the trial is hereby adjourned until 2 p.m. of Monday, July 20, 2026.